All right, good morning, everyone, and welcome to the December 7th, 2023 board meeting. We'll bring the meeting back to order. Ms. Canavong, if you could take roll call for a quorum.
Certainly. Ms. Walmsley,
Present.
Ms. Davis,
Present.
Ms. Lahan,
Present.
Ms. Snare.
Here.
Mr. Dang is absent right now. Mr. Nassif,
Here.
Mr. Anderson,
Here.
and Mr. Thorwald.
Here.
We have a quorum.
Thank you, Ms. Canavong. First item of business is going to be our hearings. Tab 26 is where we'll start. We're going to go ahead and take a couple of these separately. So, Mr. Hargraves, I think you had a request. You want to address that real quickly?
Yes, thank you. I will ask that agenda item 26E, case number 23-0494 involving Ahmed H. Fali, be pulled and handled separately.
Thank you, Mr. Hargraves. We'll do
Thank you.
that. And then I'm recused from 26F. So I think we can take 26A through D together, and then we'll handle those other two separately, if that sounds good to the group. All right, this is the time for the board to consider consent agenda items 26A through 26D. Items Tyler Lead Board Case number 23-0408. Anthony Kenneth Fretchel Board Case number 23-0437. Carol Richardson Board Case number 23-0476. And Shannon Jensen Board Case number 23-0529. Does any respondent, attorney, or board member wish to pull any of these items from the consent agenda for further consideration? Hearing none, will the state's attorney please introduce themselves?
Yes, Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present for these matters? Mr. Lee, Mr. Pretchel, Ms. Richardson, or Ms. Jensen? All right, the state has filed a motion to deem and vacate the hearings in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints as findings of fact and the alleged violations as conclusions of law. Are there any motions with regards to the state's motion to deem?
I move the board grant the state's motion to deem and vacate the hearings.
Do I have a second? Any discussion? All those in favor?
Aye.
Any opposed? We will now deliberate on the appropriate discipline to be imposed. Any discussion by board members? Mr. Hargraves, do you want to address the board with your request?
It's up to the board how you want to handle these based upon the lack of response in all of these. The state had included in its motion a recommendation for revocation of the licenses.
Thank you, Mr. Hargraves. Any discussion, board members? Or do we have a motion?
Madam Chair, I move we follow the state's recommendation.
We also need to deem and vacate the hearings as well.
And deem and vacate.
A motion and a second. Ms. Canavong, if you could do a roll call.
Ms. Walmsley,
Aye.
Ms. Davis,
Aye.
Ms. Lahan,
Aye.
Ms. Snare.
Aye.
Mr. Dang is absent. Mr. Nassif.
Aye.
Mr. Anderson,
Aye.
Mr. Thorwald.
Aye.
Ayes have it.
Thank you, Ms. Canavong. Let's go ahead and do Ms. Cleveland, which is 26F, and I will step aside, and then we'll come back to the other one.
This is the time for the board to consider consent agenda item 26F, Cheyenne Cleveland Board Case 23-0036. Does any respondent, attorney, or board member want to pull this case from the consent agenda for further consideration? Will the state's attorneys please introduce themselves?
Yes, Seth Hargraves, Assistant Attorney General on behalf of the state.
Are there any other parties present for these matters? The state has filed a motion to deem and vacate the hearing in this matter. If this motion is granted, the board will have adopted the factual allegations set forth in the complaints as findings of fact and the alleged violations of law as its conclusions of law. Is there a motion regarding the state's motions to deem?
I move that the board grant the state's motion to deem and vacate the hearing.
Second.
Any other discussion? All those in favor?
Aye.
Any opposed? We will now deliberate on the appropriate discipline to be imposed.
Okay, I move to adopt the state's recommended discipline as set forth in the motions to deem and vacate the scheduled hearing.
Second.
I have a motion and a second. Can I get a roll call, please?
Ms. Walmsley is recused. Ms. Davis?
Aye.
Ms. Lehan?
Aye.
Ms. Snare? Let the record
Aye.
reflect that Mr. Dang has joined the meeting. Mr. Dang? Mr. Nassif?
Aye.
Mr. Anderson?
Aye.
Mr. Thorwald?
Aye.
Ayes have it.
Thank you very much.
All right, back to you, Mr. Hargreaves. Item 26E, Ahmed Faith.
Yes, thank you. This matter was originally set for hearing and then the state filed a motion to deem when there was no response. I was contacted by Mr. Fili earlier this week. He has signed a consent agreement for voluntary surrender. I would ask the board to accept that voluntary surrender consent to resolve this matter in lieu of the motion to deem.
Thank you, Mr. Hargreaves. Board members, questions or discussion?
If no, I'll make a motion to accept the request to voluntary surrender from Mr. Fili.
Second.
We also need to vacate.
And vacate the hearing, please.
Modified.
I have a motion and a second. Ms. Cannavon.
Ms. Walmsley?
Aye.
Ms. Davis?
Aye.
Ms. Lehan?
Aye.
Ms. Snare?
Aye.
Mr. Dang?
Aye.
Mr. Nassif?
Aye.
Mr. Anderson?
Aye.
Mr. Thorwald?
Aye.
Thank you.
All right, next up is tab 27A, Patricia Ann Watchman, board case 23-0168. This is the date, time, and place where the matter involving Patricia Ann Watchman, board case number 23-0169 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Tennille Davis, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Jeff Anderson, and Sharik Al-Nassif. Let the record reflect that board members have been furnished copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce themselves, starting with the state?
Yes, Seth Hargreaves, Assistant Attorney General on behalf of the state.
Patricia Watchman.
Welcome, Ms. Swetchman. Before moving forward, do parties have any preliminary matters that they would wish to address with the board?
Yes, at your last meeting in October, the board voted to accept Ms. Watchman's request to modify a proposed consent agreement. The board voted to, if the new consent agreement was not signed, to move to hearing. The consent agreement was modified, presented to Watchman, Ms. Watchman. Initially, she sought to bring it back to the board for further modifications, at which time we set the matter for hearing and in accordance with the board's motion. Thereafter, she signed the previously revised consent agreement. So at this point, it's up to the board if you want to accept that signed consent agreement, which is in your packet.
Thank you, Mr. Hargreaves. Board members, any questions for him? Does anyone
I'll make a motion.
want to discuss it further? Ms. Watchman, do you want to address the board?
Yes, good morning, everyone. The last time I was here, I did look it over and I didn't have any issues with it. I am in full compliant with what the board had given me, which is suffice and good for me. And I was unaware of, I had a misunderstanding. So I take full accountability for my misunderstanding, and I wasn't expecting to come back to the board again. And if you could just please accept that, I am in full accountability to do everything that I signed, and I signed it within about 5 business days of receiving it on a Monday. So it gave me extra time to just read it over, but I'll be full and compliant with it. I have nothing to revise, nothing to bring to the table if all of you are in acceptance of it, but it was just on my behalf that I misunderstood.
Thank you for that, and thank you for being here. Any other discussion or questions for her?
I'll make a motion to vacate the hearing and accept the signed agreement.
Second.
Is there any further discussion? Ms. Countavong, if you could do a roll call.
Ms. Walmsley,
Aye.
Ms. Davis,
Aye.
Ms. Lehan,
Aye.
Ms. Snare,
Aye.
Mr. Dang,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson,
Aye.
Mr. Thorwald.
Vacate, yeah, aye. Sorry, thinking of something else.
Thank you.
This concludes this matter. Thank you, Ms. Watchman, for being present.
Thank you so much for your decision. And I do have my license expiring tomorrow. Do I get to have it further out?
Staff can address that for you.
Okay.
Thank you.
Thank you so much. Take care.
Item 27B, Nicholas Daniel Posadillo, board case number 23-0335. This is the date, time, and place where the matter involving Nicholas Daniel Posadillo, board case number 23-0335, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violation of the board's statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Tennille Davis, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Jeff Anderson, and Tariq Al-Nassif. Let the record reflect that the board members have furnished copies of the complaint and notice of all pleadings and records. Will the parties please introduce themselves, starting with the state?
Yes, Seth Hargreaves, Assistant Attorney General on behalf of the state. I do not believe that Mr. Podziatlo will be present after the complaint notice of hearing was sent out. We were contacted by him. He has signed a consent agreement for voluntary surrender, which is in your packet. To resolve this matter in lieu of hearing, the state would ask that the board accept that consent agreement, vacate the hearing to resolve the matter. Thank you.
Thank you, Mr. Hargreaves. Board members, questions or discussion?
I'll make a motion to vacate the hearing and accept the proposed consent agreement.
I'll second.
I have a motion and a second. Any discussion? Ms. Canavong?
Ms. Walmsley,
Aye.
Ms. Davis,
Aye.
Ms. Lehan,
Aye.
Ms. Snare,
Aye.
Mr. Dang,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson,
Aye.
and Mr. Thorwald.
Aye.
Thank you.
27C, Ray David Cordova, board case number 22-0733. This is the date, time, and place where the matter dealing with Ray David Cordova, board case number 22-0733, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violation of the board's statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Tennille Davis, Kristen Snare, Kevin Dang, Cedar Lehan, Frank Thorwald, Jeff Anderson, and Tariq Al-Nassif. Let the record reflect that the board members have been furnished with copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce yourselves?
Seth Hargreaves, Assistant Attorney General on behalf of the state.
Madam Chair, I'm recused from 27C and 28D or 27D by my employment.
Thank you, Ms. Lehan. Let the record reflect that she is recused. Is Mr. Cordova present?
I don't know.
Len, are you able to see if he's online?
Madam Chair, this is Cam. He is not online.
Thank you, Cam. Since Mr. Cordova is not present, let's go ahead and proceed then. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain certain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Mr. Hargraves, would you like to make an opening statement?
Yes, thank you. This case involves Ray David Cordova, holder of pharmacy technician license T001759. Mr. Cordova's license is currently suspended in accordance with ARS 32-3202 in lieu of an expiration. His license was scheduled to expire at the end of October if he did not renew, because he was notified of the complaint in this matter. Before that, the license did not expire and remains suspended pending the outcome of this case. This case initiated by a complaint filed in December of 2022, indicating that Mr. Cordova had tested positive for methamphetamine on a pre-employment drug screen. After that complaint was received, board staff reached out to him. He indicated that the results was a false positive from a prescription medication that he was currently taking. Board staff requested some type of correspondence from his physician, his prescriber, indicating that possibility. There was initially no response. There was a follow-up from board staff. Again, no response. The board obtained a copy of the drug screen results. A complaint was opened and a subpoena was issued to Mr. Cordova to respond to the allegations, provide documentation or proof of current employment, as well as proof of his continuing education from his last renewal. He did respond. He did not provide any documentation regarding continuing education. In his response, he indicated that his initial view was that it was a false positive. However, he later found out that he had taken a hit off of a vape that, unbeknownst to him, had methamphetamine laced within it. Again, he did not provide any continuing education documents, which under the board's rules, he is required to maintain and provide within 20 days of request by the board. He is also required to complete 20 hours of continuing education within the 2 years prior to each renewal period. When he failed to provide any documentation, board staff went to CPE Monitor to see what CE had been reported, and he had only completed 10 out of the required 20 hours. The board voted to invite Mr. Cordova to a conference at your October meeting. He also was subpoenaed to appear and attend that conference. He failed to comply with that subpoena, did not show up for that conference. As a result, this matter was set for hearing for today. The evidence and testimony that will be presented will establish the factual allegations in the notice of hearing, as well as the alleged violations and activity of unprofessional conduct. Thank you.
Thank you, Mr. Hargraves. Mr. Cordova is still not present, just checking.
As far as I know. He did respond to the notice of hearing, but it did not appear that from that he would be attending. He was not quite, his response was, which is part of the state's exhibits, is he doesn't know why this is still going on.
Okay. Do you wish to call any witnesses, Mr. Hargraves?
Yes, I will call Jennifer Kiangavan.
Dr. Gandhi, can you please swear in the witness?
Certainly, Madam Chair. Ms. Gillivan, right hand, please. Do you swear that the testimony you'll be providing will be truthful and complete?
I do.
Thank you.
Ms. Kiangavan, could you please state your current occupation for us?
I'm the Deputy Director at the Board of Pharmacy.
And what are your job responsibilities as deputy director?
Oversee activities of the agency, including compliance and licensing and other duties as prescribed by the Executive Director.
Are you familiar with the current complaint case involving Mr. Cordova?
Yes,
How are you familiar with it?
through this complaint investigation.
Okay. And you have a copy of the state's exhibits with you?
Yes.
How did this complaint initially come about?
This came about from a complaint that was filed online by a local business.
Okay, if we can go to what's been marked as State's Exhibit 1 on Bates page 3 of the exhibit, which would be for the board members' board book, page 2621. Could you identify this document?
Yes, this is the complaint that was submitted online.
And can you just kind of summarize what the complaint is?
And certainly, this was submitted on December 19th, 2022. A representative from this business, excuse me, filed a complaint stating that an individual had a pre-employment drug screen at an employee health facility, which resulted in a positive methamphetamine result.
And after this complaint was received by board staff, what, if anything, was done?
Staff reached out to Mr. Cordova for more information,
And how was that done?
initially by phone.
Okay. And who was it that contacted Mr. Cordova?
Initially, Dr. Gandhi contacted Mr. Cordova.
And what was, are you aware of what that conversation was?
I wasn't present for the conversation.
Was the summary of that conversation relayed to you by Director Gandhi?
It was in an email.
And looking at what's been marked as State's Exhibit 2, specifically Bates page 6, which would be board book page 2624. To identify this document?
Yes, this is an email from Dr. Gandhi to myself and Ms. Mitchell.
Okay, and you're referring to the bottom of Bates page 6, email dated December 20th, 2022.
Correct.
And could you indicate what Director Gandhi indicated from his conversation with Mr. Cordova?
He indicated that Mr. Cordova was on a medication that could cause a false positive for methamphetamine, and that Mr. Cordova was getting a doctor's note stating that he is on this medication, and that is the reason for this result.
To your knowledge, was that documentation from his doctor ever submitted?
It was not.
Jumping forward to Bates page 8. So additional email, is that correct?
Correct.
And on the top of the page dated May 15th, 2023, do you see that?
Yes.
Who is this email from and who is it to?
This email is from Dr. Gandhi and it is to Mr. Cordova.
And could you read that email for us?
Yes, it says, Mr. Cordova, during our call, you indicated you were going to have your your prescriber supply a letter. I have not received any correspondence up to today. Can you please give me a status? Based on the positive drug screening, we will be moving your case forward.
Okay, jumping to the next page, there's another email from Director Gandhi to Mr. Cordova dated May 19th. Do you see that?
Yes,
And can you read that one for us?
it states during a drug screening, you tested positive for a controlled substance. You indicated you were on a medication that may have caused a false positive result. When we spoke a while back, you were going to produce a doctor's note stating you were on that medication. Did you still need a pharmacy technician license?
And there is an email from Mr. Cordova just under that on that same date, May 19th. Do you see that?
Yes.
And what was his email?
His email states, you will be moving my case forward to where? I still don't really understand what this is all about. What is this case? I haven't worked in an actual pharmacy for almost 2 years now. My last job was fully remote, so I don't know what you think I've done.
To your knowledge, did Mr. Cordova ever submit documentation from his physician?
He did not.
Were you able to obtain a copy of the drug screen results?
Yes.
And how did you do that?
I emailed the company that filed the complaint.
And looking at what's been marked as State's Exhibit 3, specifically Bates page 11, which would be Board Book page 2629. Could you identify this document?
Yes, this is an email sent on June 12th, 2023 to the individual who filed the complaint. And it is a request from me to her, asking her to provide a copy of Mr. Cordova's drug screen results.
And did you obtain a copy of those results?
I did.
And looking at Bates page 16, Board Book page 2634, is that a copy of the results
Yeah.
that you received?
Yes, it is.
And looking at this, the participant noted is Ray Cordova, correct?
Correct.
And under results of controlled substance test, what was listed as the record status?
Positive.
And the collection date?
November 8th, 2022.
And just above that for test type, what was the test type here?
Pre-employment.
And underneath, it lists the different tests performed and the results.
Correct.
And were any of those positive?
Yes.
Which one?
Amphetamines.
With that documentation and lack of documentation from Mr. Cordova, what happened next?
At that point, staff opened a complaint and sent Mr. Cordova a complaint notice and subpoena for response.
Okay, we can jump to what's been marked as State's Exhibit 4, Bates page 20, Board Book page 2638. Could you identify this document?
Yes, this is the complaint notice sent to Mr. Cordova,
And what is the date of the notice?
June 22nd, 2023.
And attached to that notice on the next page, Bates page 21, what is this?
A subpoena for response.
And what was he being asked to provide?
He was asked to provide a detailed explanation as to why his pre-employment drug screen resulted in a positive methamphetamine result, as well as any relevant documentation that supports his explanation, his current employment information, and proof of continuing education for the last renewal cycle.
And jumping a couple pages to Bates page 24. First of all, how was the notice and subpoena sent to him?
Regular mail, certified mail, and email.
And Bates page 24 is notification that the certified mail had been delivered.
Correct.
And Bates page 25, is that a copy of the email sent to him with the document?
Correct.
Did he respond to the notice and subpoena?
Yes.
Jumping to what's marked as State's Exhibit 5, Bates page 27, Board Book page 2645. Is this his response?
Yes,
Can you go over and summarize the response for us?
certainly. Mr. Cordova responded that his drug test came up positive. He finally figured out a few weeks later why his drug test came up positive. At first, he thought it was a medication he had taken for a little while that would cause the false positive. But it turns out that a few days prior to his drug test, he states he had used a vape that a friend had that day. Mr. Cordova states he was not informed by him or anyone that the vape also had methamphetamine in it. Mr. Cordova responds that his current employment is not in a pharmacy and that he's not worked in a pharmacy since October of 2022. And then he also responds that he does not have copies of any continuing education.
Okay, and as a licensed technician, did he have a responsibility to complete continuing education?
Yes,
And what is that requirement?
20 hours with every renewal cycle.
Okay, and if you can look at what's marked as State's Exhibit 6, on Bates page 31, Board Book page 2649. You identify what this document is?
Yes, this is Mr. Cordova's renewal application for 2021.
Okay, jumping to the next page, Bates page 32. The application is signed by Mr. Cordova electronically.
Correct.
And what is the date of the signature?
November 3rd, 2021.
So based on the board's continuing education requirements, what time period would he have been required to complete the continuing education?
Between November 3rd, 2019 and November 3rd, 2021.
And above the signature, there's a affirmation. Could you read that for us?
Sure. By signing below, I certify that I have complied with the continuing education requirements set forth in statute and rule, including the opioid-related, substance use disorder-related, or addiction-related continuing education requirements. Licensees are exempt from the continuing education requirement between the time of initial licensure and first renewal.
Was this a situation where he was a renewal after initial license?
No,
And in his response, he indicated that he did not have any documentation of the CE, correct?
correct.
Were you able to verify what, if any, continuing education he had completed?
Yes.
And how did you do that?
Through CPE Monitor.
And what is that?
It is a service through NABP where staff can obtain CE that's been completed by licensees.
And if you can take a look at what has been marked as States Exhibit 7, Bates page 34, Board Book page 2652. You identify what this is?
This is Mr. Cordova's CPE Monitor activity transcript.
And what is the date range for this transcript?
November 3rd, 2019 to November 3rd, 2021.
And according to this, how many hours did Mr. Cordova complete during that time
He
frame?
he completed 10 hours.
And that's less than the required 20?
Correct.
So as a result of that, what happened with the case at that point?
So the case was prepared for presentation to the board as a complaint at its August board meeting.
Okay, if we can take a look at what has been marked as States Exhibit 8, Bates page 37, Board Book page 2655. What is this document?
This is a meeting notice sent to Mr. Cordova indicating that his complaint would be considered by Complaint Review Committee on August 8th, 2023, and then considered by the Board of Pharmacy at their meeting on August 16th through 17th, 2023.
And jumping to Bates page 39, that was also sent by email, correct?
That's correct.
Did Mr. Cordova attend either of those meetings?
He did not.
And what happened at that meeting?
Excuse me, at Complaint Review, the board, excuse me. The board made a recommendation to consider Mr. Cordova's case at conference, and they also made a recommendation to issue a subpoena to compel appearance and testimony. The full board accepted that recommendation at its meeting in August.
And was Mr. Cordova notified of that determination?
He was.
And looking at what's been marked as States Exhibit 9, Bates page 42, Board Book page 2660. Is this the notification to him regarding the board's action?
It is
And what's the date of the letter?
September 19th, 2023.
And this informs him of being invited for the conference on October 19th, correct?
Correct.
And looking at the next page, Bates page 43, that was sent by email.
Correct.
And next page, Bates page 44 is a copy of the subpoena to attend, correct?
Correct.
Did Mr. Cordova appear at that conference?
He did not.
Was there any correspondence or communication from him at all?
No.
As a result of that, what happened next?
At conference, the board voted to move the matter to hearing.
And looking at Exhibit 10, Bates page 50, Board Book page 2668. What is this?
This is an amended complaint and notice of hearing.
And that's notifying him of today's hearing.
Correct.
And was he required to respond to this?
Yes.
Did he?
Yes.
And looking at States Exhibit 11, Bates page 60, Board Book 2678. Is this his response?
Yes.
And Can you just kind of summarize the response for us?
Sure. Mr. Cordova asked why he was still being bothered with this. He asked why none of the conversation I had with you was put on the subpoena. He indicated that he explained everything that happened. None of that was included. He says it's been almost 2 years since I've worked in an actual pharmacy. He didn't, he indicates he didn't renew his license because he never wanted to work in a pharmacy again, so he has no need for it. He said he told staff that in his last conversation as well. And he states he's not sure why he has to deal with this and why it's being taken to such a level that it has.
At this time, I would ask that states exhibits 1 through 11 be admitted into evidence.
Board members, do I have a motion to accept the exhibits?
Madam Chair, I move that we accept state's evidence 1 through 11.
Second. All those in favor?
Aye.
Any opposed?
And state has no further questions or no further witnesses.
Mr. Hargraves, do you care to make a closing statement?
Yes, thank you. The evidence and testimony presented established the factual allegations in the amended complaint notice of hearing, as well as the alleged violations stated in the same document. The evidence has shown that Mr. Cordova has committed acts of unprofessional conduct, including ARS 32-1901.01C1, using alcohol or drugs to an extent rendering them unfit to perform their duties, as well as 1901.01C5, 13, 14, and 15 regarding the reporting CE that he did not complete and his failure to comply with the board's CE requirements, as well as 32-1901.01C17 failing to comply with the subpoena for attendance at the conference. It's the state's view that the established violations are grounds for disciplinary action in light of the current status of his license and Mr. Cordova's views toward the board in this proceeding. The state would ask that as part of the outcome in this, that his license be revoked. Thank you.
Thank you, Mr. Hargraves. At this point, we can begin with general discussion or motions related to findings of fact and conclusions of law and a potential final order. Any discussion, board members? Or do we want to move forward with motions?
Madam Chair.
Which one of you want to go?
Madam Chair, I move that the board grant the state's motion and deem the allegations in the complaint and the notice of hearing as admitted.
Second.
The
Excuse
state
me, Madam
didn't make
President,
that-
if I could just interrupt. Thank you. For the record, Diane Didia, Assistant Attorney General, serving as the board's independent legal advisor on this matter. If we could just modify it slightly, it's the amended complaint. Just want to make sure the record's clear. Thank you.
Actually, and the state didn't make a motion to deem it
To
this matter.
deem correct. So it's just, if we could move to on your script, I think it's part 2, motion to adopt the factual allegations and the alleged violations from the amended complaint and notice of hearing as findings of fact and conclusions of law. If you want to say ditto, that's your motion, that works.
Ditto, that's my motion.
Okay.
Ditto, that's my second.
Alrighty then. Any discussion? I have a motion and a second. All those in favor? Aye. Any opposed? Now we can move forward with discipline. Mr. Hargraves made a recommendation of revocation. Do I have a motion with regards to the state's suggestion?
I move to revoke Mr. Cordova license.
Second.
A motion and a second. Any discussion? Dr. Grundy, are you taking roll call?
I can do it for him.
Okay, Ms. Galvin is.
Mr. Nassif,
Aye.
Mr. Dang,
Aye.
Ms. Snare,
Aye.
Mr. Anderson,
Aye.
Mr. Thorwald,
Aye.
Ms. Lehan. I'm sorry, recused. Ms. Davis,
Aye.
and Ms. Walmsley.
Aye.
Thank you.
This concludes this proceeding. The board's decision will be reduced to a written order. Thank you for attending. Item 27D, this is the date, time, and place where the matter dealing with Valerie Wright, board case number 23-0038 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board's statutes and rules and whether disciplinary action is warranted. Board members today present include Lori Walmsley, Tennille Davis, Kristen Snare, Kevin Dang, Cedar Lehan, who is recused from the matter, Frank Thorwald, Jeff Anderson, and Tariq Al-Nassif. Let the records reflect that the board members have been furnished with copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce themselves, starting with the state?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Is Ms. Wright present?
We understand that she is going to appear by phone.
Lynn or Dr. Gandhi, can you confirm if she's present or not? Yes. Ms. Wright, if you can hear us, if you could please unmute yourself and introduce yourself for the record.
I prompted Ms. Wright to unmute, not sure if she's able to.
Ms. Didia, how shall we proceed?
I would recommend that we table this for a few minutes and see if Dr. Gandhi is able to get her on the line, or if someone has any other way to communicate with her, maybe email her to let her know that we're trying to reach her.
Okay.
And then if you want to move to the next item on the agenda
Okay.
to 28, and then we can come back to that.
Okay, that sounds good. That sounds good to me.
Okay.
All right, Dr. Gandhi, if you could try and see if you can reach Ms. Wright or have somebody from the staff.
Madam Chair, one moment. I apologize. She, I think, dialed in using her cell phone, so she should be on right now.
Okay, Ms. Wright, can you hear us?
Yes, yes.
If you could please introduce yourself for the record. You have a little bit of feedback. If your
Okay. I have my phone, I
audio's
was on.
if your audio is on your computer, maybe turn that off.
My name is Valerie Wright.
Ms. Wright, do you have an attorney with you today?
No.
I'm sorry.
No.
Okay, thank you. You have the right to be represented by an attorney, but the law does not provide for an appointment of counsel on your behalf. If you wanted an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving your rights. This hearing is the opportunity for you to present testimony and evidence on your behalf. If you wish to appeal the board's decision, the record that you make today may be evidence considered in the court to determine whether the board's decision was proper. Do you understand what I've told you, and do you wish to proceed without counsel today?
Yeah.
Okay, thank you, Ms. Wright. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Mr. Hargraves, do you have an opening statement?
Yes, thank you. This case involves Valerie Wright, holder of technician trainee license T073569. Ms. Wright obtained that technician trainee license in July of 2021. This case was previously before you in October for a conference, at which time the board voted this matter to a formal hearing. This case started out in January of this year when the board received notification from the Department of Public Safety that Ms. Wright had been arrested and or fingerprinted on charges of felony theft and felony fraudulent schemes and practice. Under state statute, she had an obligation to report those charges to the board within 10 days, and she failed to do so. Those charges were filed in Maricopa County Superior Court in December 7th, 2022. The charges included felony theft, felony fraudulent schemes and practices, and 12 counts of felony false statements to obtain benefits. Again, she did not report those charges to the board. When the board did find out about it, a complaint file was opened. She was asked to, she was sent a notice and a subpoena asking to respond, provide relevant documentation, which she did. It was found out that she eventually pled guilty to a single charge of false statements to obtain benefits, an undesignated offense. Under your statutes, that is considered committing an offense involving moral turpitude. So the evidence and testimony will show her criminal conviction for an offense involving moral turpitude and her failure to timely report criminal charges to the board. Thank you.
Thank you, Mr. Hargraves. Ms. Wright, do you wish to make an opening statement?
No.
Mr. Hargraves, do you have any witnesses?
Yes, Ms. Kiangavong.
Dr. Gandhi, if you could please swear in the witness.
Ms. Gillavong, if you can raise your right hand. Do you swear that the testimony you'll be providing will be truthful and complete?
I do.
Thank you.
Ms. Kiangavong, could you state for us your current position, your occupation?
Yes, Deputy Director with the Board of Pharmacy.
And as Deputy Director, are you familiar with this current case involving Ms. Wright?
Yes,
And what is Ms. Wright's status with the board? Does she hold a license?
she does.
And what license does she hold?
She holds a technician trainee license.
If you can take a look at what has been marked as States Exhibit 1, Bates Page 2, also Board Book 2716. You identify this?
This is a primary source of license verification for Ms. Wright,
And what does it indicate in regards to her license?
that it is open.
Okay, and when was her license issued?
July 22nd, 2021.
And at what point would that license be scheduled to expire?
July 31st, 2024.
And a complaint was opened against Ms. Wright, is that correct?
Correct.
And how did that come about?
Came about through a notification from DPS of suspension of her fingerprint clearance card.
Okay. And looking at what's been marked as States Exhibit 2, Bates Page 5, Board Book 2719, is this that notification?
Correct.
And according to this, what is the date of this letter?
December 29th, 2022.
Okay. And it references the suspension of the fingerprint clearance card.
Correct.
And can you read the second paragraph for us?
Yes, DPS was notified you were arrested and or fingerprinted for felony theft and felony fraudulent scheme/practice on or about December 28th, 2022 in Maricopa County, Arizona. Arresting agency was Maricopa County Sheriff's Office.
And was staff able to confirm whether there were charges against her?
Yes,
And how was that done?
was done through a public record search.
Okay, and looking at what's marked as States Exhibit 3, Bates Page 8, Board Book 2722. Could you identify this document?
This is a case history of Ms. Wright's charges.
Okay, and this is from printout from the Maricopa County Superior Court
Correct.
and lists the case number CR 2022-007290.
Correct.
And it lists several charges, is that correct?
Correct.
And what are those charges?
There are 12 charges of false statement to obtain benefits, 1 charge of fraud scheme / practice conceal, and 1 charge of theft.
Okay, and then going down as far as case documents, indicates that there was a direct complaint filed in this matter. Is that correct?
Correct.
And what is the date listed for that?
December 7th, 2022.
And under state statutes, would Ms. Wright have an obligation to report those charges to the board?
Yes,
And what is the time frame she'd be required to report those?
within 10 days.
Did she do so in this case?
No.
So once you were able to confirm the charges and when they were filed, what happened next?
Staff opened a complaint and sent Ms. Wright a complaint notice and subpoena for response.
And looking at what's been marked as States Exhibit 4, Bates page 10, Board Book 2724. You identify this document?
This is a complaint notice sent to Ms. Wright,
And what is the date of the notice?
January 25th, 2023.
And looking at the next page is a subpoena.
Correct.
And according to this, what is she being requested to do?
She was requested to provide a detailed description of events that led to her criminal charges, the status of her charges, and any remedial or corrective actions she had taken. She was asked to provide a response to the allegation of failing to report the charges filed against her within 10 working days. She was asked to provide copies of the report from the arresting agency and records from the adjudicating court. And she was also asked to provide her current place of employment.
Did the board receive a response from Ms. Wright?
Yes,
Taking a look at what's been marked as States Exhibit 5, Bates page 16, which would be, I believe, Board Book page 2730. These are email exchanges, is that correct?
correct.
And at the bottom of Bates page 16, there's an email from Jennifer Mitchell to Ms. Wright, correct?
Correct.
And that was an email notifying her of the complaint and the subpoena.
Correct.
And just above, there is a response from Ms. Wright, correct?
Correct.
And that response was submitted February 8th. Is that correct?
Correct.
In that email, she indicates that she is attaching information requested. Is that accurate?
That is accurate.
Jumping a couple pages to Bates page 18. What is this?
Is this a written response from Ms. Wright?
And this written response regarding the charges,
Correct.
can you briefly summarize them for us?
Sure.
And actually, they go on to the next page as well, correct?
Correct.
Can you summarize that for us?
Sure. She indicates that the events that led up to her charges was that she applied for unemployment compensation that she received from the state of Arizona Economic Security, who indicated that she was ineligible from May of 2020 to March of 2021. She said that she pled guilty to 1 count of making a false statement, and she paid all of the balance that is due plus interest. She states that she did not report the charges filed against her because at the time she had not gone to court to respond to the allegations against her, and she didn't know there was a time frame to report allegations of pending charges. She states that her place of employment at the time of this writing was CVS Health. And that's all.
Now, looking at what's been marked as States Exhibit 6, Bates page 21, which would be Board Book page 2735. There's further communication from Ms. Wright, is that correct?
Correct.
And here we have an email dated February 27th, 2023.
Correct.
And the email indicates that she is sending a copy of the signed plea deal, correct?
Correct.
And is that plea agreement on the next page?
Yes,
And according to this, what was she pleading guilty to?
she pled guilty to false statement, a class 6 undesignated offense.
And jumping to State's Exhibit 7. Bates page 25, Board Book page 2739. We have a sentencing order from the court, is that correct?
Correct.
And down toward the bottom of that page, it is a judgment of the court, correct?
Correct.
And it says the defendant is guilty of the following. Is that correct?
Correct.
Can you read for us what she was found to be guilty of?
A false statement to obtain benefits undesignated.
And then the rest of the document goes through what the sentence was, correct?
That's correct.
And Bates page 26 includes period of supervised probation for
Correct.
3 years.
Correct.
So at some point, this matter was brought before the board, correct?
Correct.
And she was invited for a conference before the board?
Correct.
And was she notified of that?
She was.
And looking at State's Exhibit 8, Bates page 30. What is that document?
This is a meeting notice sent to Ms. Wright of her conference scheduled with the board on October 19th, 2023.
And did she appear at that conference?
Yes,
And what was the result of that conference?
the board made a motion to move the matter to hearing.
And was she notified of that?
Yes,
Looking at what's been marked as State's Exhibit 9, beginning on Bates page 32, is that the complaint notice of hearing in this matter?
yes,
Did she respond to that?
yes,
And looking at what's been marked as State's Exhibit 10, is this her response?
yes, it is.
I would move State's Exhibits 1 through 10 into evidence.
Board members, do I have a motion with regards to the evidence? Oh, wait, we need to give her a chance to.
Absolutely. If you would ask Ms. Wright if she has received the exhibits, I would assume it's by email. And then also to see if she has any objections.
Ms. Wright, have you received the exhibits and do you have any objections?
Yes, I have received the emails and no, I don't have any objections.
Thank you. Do I have a motion, board members?
I move we accept State's Exhibits 1 through 10.
I second.
A motion and a second. All those in favor? Aye.
Aye.
Any opposed? Board members, any questions for Mr. Hargreaves?
State has no further questions for Ms. Kiana Vong at this time.
Ms. Wright, do you wish to cross-examine Ms. Kianavong?
No,
Mr. Hargreaves, do you have any further witnesses?
No further witnesses. Thank you.
Ms. Wright, do you have any witnesses?
no,
Mr. Hargreaves, do you care to make a closing statement?
Madam President, if I may just interrupt, if Ms. Wright would like to testify on her own behalf, she has that option. We need to swear her in.
Okay. Ms. Wright, do you wish to testify on your own behalf?
no, you said everything, no. No,
Okay. Mr. Hargreaves, do you have a closing argument?
Yes, thank you. The evidence and testimony that has been presented here today support the factual allegations in the notice of hearing, and they support the alleged violations. The evidence and testimony has shown that Ms. Wright has engaged in unprofessional conduct by failing to timely notify the board of the charges within 10 days. As required by ARS 32-3208A. A failure to do so constitutes unprofessional conduct under ARS 32-3208D. Her conviction in this matter constitutes unprofessional conduct under 32-1901.01C1, committing a felony whether or not involving moral turpitude or a misdemeanor involving moral turpitude or any drug-related offense. In this matter, the offense for which, the undesignated offense for which he was convicted of involves moral turpitude and thus a violation, unprofessional conduct under C1. It's the state's position that the evidence and testimony supports disciplinary action in this matter. Thank you.
Thank you, Mr. Hargraves. Does the state have a recommendation for the formal discipline?
In light of the conduct and the fact that kind of the seriousness of those allegations, and given the fact that the board could have done something different during the conference, had it chose to do so, I think the state would recommend revocation in this matter.
Thank you, Mr. Hargraves. Board members, any additional questions? Ms. Wright, do you wish to make a closing argument?
Yeah.
Go ahead.
I'd like to say that filing for unemployment was the biggest mistake I ever made in my life. It has altered my life. I'm sorry. It has altered my life in so many ways. Being that this is my first offense, I struggle with it daily. And I just want to ask the board for a second chance to configure my career as a pharmacy technician. Thank you.
Thank you, Ms. Wright. State, do you wish to make a rebuttal?
No, thank you.
Board members, any questions for Ms. Wright? All right, we'll move forward with motions. The board will now discuss if the state has proven the allegations with regards to the findings of fact. Have a motion.
I'll make a motion to accept the findings of fact.
And
Second.
no, conclusions of law. Next
The
page.
findings of fact and
Conclusion.
conclusions of law.
Correct, in the complaint notice of hearing. It's on part 2 of your script. I don't know if you want to jump to that. But that works also.
I move to adopt the factual allegations and the allegations of unprofessional conduct from the complaint and notice of hearings as finding of fact and conclusion of law.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? We'll now make have a discussion around discipline. Mr. Hargraves' recommendation is revocation. Any discussion? Otherwise, do we have a motion?
Do we have any other options?
Madam President, members of the board, absolutely. You have the range of discipline that you would like to impose, a letter of reprimand, a degree of censure, up to probation, suspension, a certain period of time. That would be that probation term, and any type of terms that you would like as part of that probation or suspension, all the way up to revocation. And as far as the terms for probation or suspension, I would defer to staff that maybe they could make some recommendations for this particular set of circumstances as to what would allay the board's fears, not only that she's regulatable, but that also that she would be really rehabilitated going forward.
I have a question. Can you state what the opportunity is to come back after your license been revoked?
Staff, correct me if I'm wrong. I believe it's 2 years.
Madam Chair, yes, it is 2 years unless the board states otherwise.
I would be in favor of a probation that is in concurrence with her sentencing through the court of law. I agree that there's been some ethical choices that she's made that were not smart and moral turpitude. Findings are true. I don't know how much they're going to affect her ability to perform as a pharmacy technician trainee.
Ms. Didia, is it proper to ask her a question at this point? Ms. Wright, if we're going to look at anything outside of the state's recommendation, which is to revoke your license, I'd like to understand why haven't you appeared when we've asked you to appear before today?
The time that I wouldn't have made it on time at 8:30. I didn't know if you guys want to call me at 8:30 or at 9, but I had to drop my children off at school and I just didn't want to miss it. So I
Madam Chair, you invited her for a conference last meeting. She did
And she
appear.
did appear,
Yes.
okay.
My concern is that this has to do with benefits, and that is something that would be an ethical concern in this type of career. So I think I'm in favor of the revocation. Just want to bring that up for discussion.
Ms. Wright, I'm curious, you have a trainee license today. How have you taken the PTCB exam? How far along are you on becoming a full technician? How
So
dedicated
I
are
have-
you? I'm sorry, go ahead.
I've been working under my my license, trying to gain as much knowledge, but I haven't taken my PCP. My employer urged me to take it like a month or two before it expires, to make sure that I'm ready. But even if it don't, even if it do expire and I feel like I don't have the knowledge, I do plan on going to school for it. Because I'm really fighting hard for it. So I might as well just take advantage of it.
She has had a trainee license since 2001. I'm sorry, 2021. I'm having a hard time today, clearly.
So I'm kind of leaning towards what Dr. Davis says is with a probation for the concurrent term of the technician trainee license. That gives her till July because the license expires in July. That's kind of what I'm thinking right now.
I think we could also order continuing education in ethics.
If I may just make a suggestion too, if her trainee license expires in July and the board is leaning towards a probation during that time with certain terms, then perhaps the board would entertain a motion to have a stayed revocation. So essentially she would be under probation during that time up until July, has to meet and comply with all of the terms, whatever the board sets forth. If she fails to do so, her license is automatically revoked. And you can institute that during that period of time for a period of 2 years, however you see fit.
I personally think that makes sense.
I also like that.
If the board, and just to move this along, if the board has some ideas and maybe staff can chime in here as well about those terms, what the continuing education would be that, whatever type of hours in whatever type of ethics or, that the board sees fit, that we can lay out those terms. And again, if board has any ideas for that as well, I'll help you structure a motion.
Okay, so the motion would be to revoke the license, but stay the revocation until the end of her tech trainee license, so July of 2024, and order 6 hours in continuing education in ethics to be completed within 90 days.
And then concurrent probation.
Right, she's on probation during that time. Does the board have any other terms that they would like to impose? Besides the 6 hours of ethics within a 90-day period? Now, and all of that will be spelled out in the order, in the written order that she needs to get board approved, CE credits and all of those things to supply the board with that documentation that she's completed it within those 90 days. All of that stuff will be laid out in the board order.
What about notifying her employer? Is that already implied?
Notifying her employer that she's on a stayed revocation. I would defer to staff if that's something that you typically do. You do? Okay, so her employer would be notified. Okay, yes.
Okay, I'll add that to my motion.
Okay, so just to clarify for the record, so the board's motion is to issue a stayed revocation for the period of up to when her license expires, which I believe is July. Is that correct? 2024?
7/31/2024.
Okay, great, thank you. Under which she would be under probation, and the probationary terms that she would need to comply with would be to complete 6 hours of continuing education in ethics within 90 days by a board-approved supplier, and to provide that information and documentation to the board, as well as to notify her employer that her license is in a probationary stayed revocation status, and that she has certain terms to comply with. Is that?
Would it be
correct?
an assumption that she also needs to comply with all state and federal laws, or
Oh,
should that be included?
that will be in the board's
Okay.
order. Absolutely. Yes.
And then when her tech training license expires, she'll have the opportunity to apply for a full pharmacy technician license, and the stayed revocation will be canceled.
Correct. Under the terms that you have right now, you could also make it to where you could require her up until that time that she come and reapply, and not reapply in the sense that she's reapplying for her license, but to come back to the board to ask. I mean, you can make the probation a little bit longer if you would like, and that she would need to come back to the board to apply for her revocation, her state revocation and probation to be terminated early, which might get a little bit messy. I mean, you don't need to do that. Okay.
I think it would be better to have the probation for a longer period after she does come, if she does come back, to get her to move forward after that.
I mean, it's 8 months probation.
Yes,
What are you thinking? You're thinking longer, Frank?
I'm thinking longer. It's a relatively short time between now and when it ends. And if we're going to do probation, given the circumstances, I think it should be longer.
How would that transition with a different license number? Because it's tied to the consent agreement's tied to her current license.
Correct. That's my understanding. If Dr. Kianavog, could you, well, you're a witness right now. Dr.
Madam Chair,
Gandhi?
yeah.
Yeah, thank you.
I can chime in. The board can require the application if she applies for the full technician license to appear. And then we can just have that application appear before you, and then you can bridge the probation if you'd like at that time.
I would personally like to see that.
That makes sense.
Okay. And keep in mind, as part of the state revocation and the probationary terms, is if during that time, if, for instance, I know you had made mention about complying with all state and federal laws, if there is an issue or if she doesn't comply with the CE credits, her license is automatically revoked. That's how that state revocation would work.
How about a time frame for the CE?
90 days, I believe, was that your motion? Okay.
And just for clarity, if she does not apply for a full technician trainee license, what happens?
Her license expires in July anyway.
Right.
And
if she does reapply, then I believe what Dr. Gandhi is saying is to also institute that when she does if she does reapply, that she would need to come and appear before the board.
She can't, right?
And her trainee license obviously isn't eligible for a renewal either. So she has to get certified as a next step as well.
If I may just, is it okay if I make a comment?
Yes, I'm gonna have Dr. Gandhi though chime in as well.
Sure.
Okay, just make sure that since you're under witness right now.
Dr. Gandhi, could you comment on dealing with an expired license that has a complaint and is on probation.
Certainly, Ms. Gildenhoff, thank you for bringing that up. When an individual is on probation and a probation hasn't concluded, that matter is still kind of lingering and open, so never fully adjudicated. So, Ms. Dede, the question, I guess, for you is how do we fully adjudicate that if she doesn't transition to the other license and we have a probation on this license that's going to expire in July? How do we put it to rest?
Dr. Gandhi, if I can just confirm your question, I believe you're concerned about if her license expires in July and she doesn't reapply and she's still under probation. Is that correct?
Correct.
Okay, my understanding though is that if the probation is simply up until her license is expired, then it's expired and she's no longer under any type of probation. She doesn't have a license to practice. This will all be part of the record for when and if she does reapply, and then the board can make its own recommendations at that time and institute, certain criteria in order for her to receive her application, her license at that time when she does reapply. For instance, appearing before the board, for instance, being on probation for another year, have more CE credits, etc. Does that, Dr. Gandhi, does that help?
It does help. I did have a follow-up question though. If I
Sure.
may. Would it make sense then not to, I guess, put in the consent agreement that if she were to apply for a technician license, that the board consider extending the probation to that?
I believe, yes, absolutely. You can put that term in there as well.
Okay, thank you.
All right, so does somebody want to take a stab at a motion since we've had a lot of discussion?
I can try
And-
again.
And if I can just clarify, so this would be offering her a consent agreement, is that correct? Or would this be a stayed revocation order? It would be a little bit different. So
I think we wanted to do state revocation.
you want to do an order?
Yeah.
Okay.
Which one would be better in this case?
I recommend having a board order because then there's that, carrot and stick that you need right now for regulatability. And so if she does not comply with this, her license is automatically revoked versus waiting to see if she signs the consent agreement, what those terms are, all of that kind of stuff. So I would
And then
recommend.
having to come back to a hearing to do this
Correct.
all over again.
Correct.
Okay, I will make a motion to issue a board order for a stayed revocation of her technician trainee license until July 31st, 2024. Under the terms that she complete 6 hours of continuing education and ethics within 90 days, supply evidence of that to the board staff. And if she does not apply for a full technician license, her trainee license will automatically expire. And she must appear before the board when she applies for a technician trainee or a technician license.
Perfect.
We also talked about notifying her employer.
Oh, yes, sorry, yes.
Oh, yes, and include notification to her employer about her state revocation on her license.
I'd like to second that motion.
Madam Chair, if I may make a comment.
Yes, Dr. Gandhi.
Notification to her employer within 10 days of issuance of the order, and then confirmation to the board that the employer knew 10 days after that, I would say. So if that's okay.
Yes, I will add that to my motion.
And I'll modify my second to reflect that as well.
We don't know that she's employed as a tech.
I think she's employed at CVS.
Is she still?
Miss Wright, are you still employed at CVS?
Yes.
Okay, thank you. Okay, I have a motion and a second. Any discussion? Ms. Galvin, do you want to do roll call?
Mr. Dane,
Aye.
Mr. Nassif,
Aye.
Kristen Snare,
Nay.
Ms. Lehan is recused, Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Mr. Anderson,
Aye.
Mr. Thorwald.
Aye.
Okay. 6-1 with one recused, motion passes.
All right, ayes have it. This concludes this matter. Ms. Wright, the board staff will be in communication with you with the written order. And just a reminder, your technician trainee license is expiring in July, and you'll need to get certified in order to move on to a technician license. So wish you the best of luck. Thanks for being here.
Thank you, guys. Have a nice day.
All right, item 28A, Paul McGee, board case number 23-0433. Good morning, Mr. McGee. Looking for the script on this. Ms. Countavong, did we add a script in here? I don't see one.
There's not a script
Okay.
for this matter.
Mr. McGee, I believe you're here before us, asking for us to reconsider our rehear your matter.
Correct, if I may. So at the last board meeting, I believe that the board issued an order revoking, I'm sorry. Correct, sorry. Upholding the denial of his application. Mr. McGee has requested a motion, a review or rehearing. There are, I believe, 8 rules under which the board could grant a review or rehearing. If you would like, I can recite those for you. And I believe that they are in Ms. Galvin's, yes, they are in Ms. Galvin's response to the request for rehearing.
2781, I believe.
Correct. It's R423, yep, 128, and there are 8 grounds. Mr. McGee's motion did not cite any section or any argument or any facts. So I believe he can have an opportunity to explain that as well as it, because it's a license denial application and he's made this motion for review or hearing, it's his burden today. So he'll go first.
Mr. McGee, if you could please introduce yourself for the record.
Yep, I'm Paul McGee. Nice to meet you. Excited to see you guys this morning again.
Thank you. Ms. Galvin.
Jean Galvin, Assistant Attorney General on behalf of the state.
Mr. McGee, as you heard from our independent counsel, there are 8 grounds for which we can accept your petition for a rehearing. Would you like to make an opening statement as to why you feel like you meet one of these 8 grounds for rehearing?
I do believe it's section 4, number 4 of the 8 grounds. I'm not sure if there's any order, but as I said last time, I was planning on being off unsupervised probation, and that meeting just happened to be a few days before that happened. So this meeting here, I'm currently off unsupervised probation. So that is why I'm here today to do that.
So just for the record, do you feel like that information is newly discovered material evidence that could not be with reasonable diligence discovered and produced at that original hearing?
I do.
Ms. Galvin, would you like to make a statement?
Yes, thank you. To begin, his request for rehearing or review was filed. It's required to be filed in writing, and that request in and of itself is supposed to contain the justification and the grounds upon which the board is requested to grant the rehearing or review. He did no such thing. He appeared today and is verbally requesting and giving you his justification for the reason that that he believes the request for rehearing or review should be granted. The state would object to that. Those grounds should have been provided in his written motion. Secondly, as his own statement today, this is not newly discovered evidence or material. He testified at the last appearance that this is what he expected, that he would be released from probation. So this is not new evidence. The board had that information previously. Whether he is released from probation does not negate the fact that he was denied and he lied on his applications for his application for licensure. He made several misrepresentations, and he also was convicted of an offense that barred his license application being granted. The fact that he's not released from probation does not undo the misrepresentations and the conviction. The state respectfully requests that you grant or deny his request for rehearing or review.
Thank you, Ms. Galvin. Board, go ahead.
He'll have a rebuttal.
Okay. Mr. McGee.
I do feel that it was new information because word of say does not do anything here. I did expect to be off probation, but that was not going to be until I got the paper, until the judge did grant that. It was not true. So I was just telling you right now, last meeting, that what I was just said, I was apologize for giving you misinformation. All the information that I gave you, I did believe was true. And that now this is new information. This is facts from the clerk. And I do believe I emailed this to the board after I did receive it.
Board members, any questions for Ms. Galvin or Mr. McGee? Discussion?
Absolutely. And just to clarify, what is before you is Mr. McGee's motion for review or rehearing. He has the burden, whether the board, if the board can either grant it or deny it. And then he'll have further appeal rights from here to Superior Court.
Board members, discussions or questions?
When we originally denied his license, was information included in that denial as to how to appeal in writing?
Absolutely. So the board order on the denial would set forth that rule with those 8 grounds. Also would specify that it needs to be in writing, and you need to specify what those grounds are, what you're arguing now.
And he did not do it this way, right? He just showed up.
Correct. No, correct. My understanding is that when board staff sent him the order by email, which I believe they also send by certified mail and regular mail, but that he replied that something to the effect, if staff could correct me, that it was, I wish to appeal it, please and thank you. Is that correct?
That's correct. That was the extent of his request for rehearing.
But this doesn't satisfy the rules, right? Like he didn't like send a.
That would be a question for me. Correct. It does not.
Since it doesn't, so I move to deny his request for rehearing.
Second.
Any further discussion? All those in favor? Voice, roll call.
Let's do a roll call,
Okay.
please. Thank you.
Ms. Cannavong?
Ms. Walmsley,
Aye.
Ms. Davis,
Aye.
Ms. Lahan,
Aye.
Ms. Snare,
Aye.
Mr. Dang,
Aye.
Mr. Nassif, Mr. Anderson,
Aye.
Mr. Thorwald.
Aye.
Thank you.
Thank you.
Thank you for your time and attendance today. Let's take a brief break, give Ms. Dadia a chance to reset over here. We'll come back at 10:15. Thank you.
Would you like to retake roll call, Ms. Walmsley?
Ms. Calvin, do we need to?
Staff has made that request. There's probably some indication that there was a problem with
Okay.
IT, so please do.
Sure. Or would you prefer that I just restate what the roll call was?
Doesn't matter. Either way.
Okay, after the break, all board members were accounted for.
Thank you.
Thank you.
Go ahead, Ms. Moltz.
Good morning, Hannah Bowles, Licensing Administrator. Calvin Scott and Company applied to renew their non-resident manufacturer permit on September 22nd, 2023. The permit holder disclosed formal disciplinary action taken in Alabama. Investigation into the cause for disciplinary action in Alabama revealed concerning inspections from 2019, 2021, and 2023 from the FDA. Alabama issued Calvin Scott and Company a $15,000 fine due to a warning letter issued from the FDA on August 25th, 2020. The warning letter summarizes significant violations of current good manufacturing practice regulations for finished pharmaceuticals. Calvin Scott and Company stated that they have not been inspected by their home state of New Mexico since 2021. The inspection indicated a very dirty cleaning supply room, a broken water heater, and flooring that needed to be replaced. The New Mexico inspector also noted observations that had been cited in the 2021 FDA inspection that still had not been addressed. They also received citations in 2023, which were repeats from the observations in 2019 and 2021. Thank you.
Thank you. Would you like to make a statement before we jump into questions?
Yeah. So Alabama asked for us to come to court kind of like this. We signed a document saying that we would not be attending the hearing, which we have done in the past. In 2004, we did the same thing and they issued a $500 fine, which is why we decided not to attend that hearing as well. We assigned a lawyer. This notification apparently did not get to the Alabama board. And so they treated us as a no-show and they went on with disciplinary actions regarding a warning letter that we had in August 25th in 2020. This warning letter has now been closed by the FDA. We have the documentation that shows that. We had another lawyer go to Alabama and they have also closed the case with us. I have that consent order as well. What other questions do you guys have, I guess, or how to proceed?
Are you saying that Alabama gave you a fine because you were a no-show, or they just proceeded to
They-
have the hearing or the conference without you?
Correct. So here, the first initial thing, the charge was based on the warning letter that we received in August 20th or 25th, 2020. And then the final order, which was issued, was that the respondent was probably notified of the charges, but failed to appear in a scheduled hearing. So that's kind of why they went the extra step. And it was a complete mishap with this paperwork showing that we were not going to attend the meeting. And again, this warning letter has been finalized by the FDA. I have that in writing as well.
Have you provided those documents to the board? You have. Okay, I'm not
Yes.
finding them.
It looks
And if
like
you wanna
the
go over-
closeout letter is on page 3334 from the FDA.
And I'm not too sure which ones you guys are looking at, but if it's the exhibit letter here.
We
And if-
have quite a lot of documents that were submitted by Calvin Scott during the renewal process.
And you want to go over what the warning letter was? Does that help at all or?
I would like to point out the citations from the 2023 FDA inspection from this year. I think that's probably more important because there were repeat violations from 2019 and 2021.
So, and again, that wasn't what Alabama was concerned about, but
It looks like according to the NABP clearinghouse that the Alabama discipline is for a fine due to a warning letter issued from the FDA in 2020.
right. And that warning letter had to do with, we were packaging some products in a container that wasn't stability tested. We did a voluntary recall on all those products. None of those products went to Arizona. None of those products went to Alabama. I have all that recall information here as well. And since then, we no longer use that form of packaging when we do the medications. The other topic that they wanted to discuss was that we did not have a cleaning and maintenance procedure in place. We have updated that, and I have all the documentation to prove that. We have done testings with a lab and done swab testings on everything, and everything came back clean. And then the third one was not having a quality control unit, which we have established. So those are the three issues in the warning letter.
The 2023 inspection report is on page 1845.
What sort of products do you manufacture at your facility?
We do not manufacture anything. We are a repackager company. So we distribute mainly in the weight loss industry. We do products like phentermine, phendimetrazine, Tenuate, and then we do some supplements as well.
So all non-sterile products?
Yes.
Madam Chair, have the findings cited by the New Mexico Board of Pharmacy addressed or corrected by your company?
Yes.
Do you have documentations that prove
From
that?
the
those-
New Mexico board?
For
I didn't,
since 2021?
no, I did not bring that with me. I don't have that.
Okay. The reason I ask is because FDA, based on the FDA 2023 results, there were many of those citations have not been addressed.
We are in the current standing with the FDA is that we send them everything that they wanted and they say, you guys are fine. Like you do not need to send us any more information.
When was your last inspection by New Mexico? Was it 2021?
By New Mexico, yeah,
Yeah.
they haven't come back since then.
Okay.
And we've submitted everything that we needed to them. I didn't bring that part with me because I thought it was just addressed about Alabama.
Because I find it, as a repackaging company, I find it disturbing that, to see that you have, you cleaned the supply room with mops, Swiffers, buckets that are very dirty, and broken hot water heaters broken. So those are the items that.
I understand, but that was 2021 and that's a board in New Mexico. I have that information. I just didn't bring it with me, but that is definitely closed out.
Yeah.
And I don't know if there's a way to contact them to verify that what I'm saying is true. But as it goes to Alabama, it was all about this warning letter that we received in 2020.
And you notified all the states you were required to about the Alabama discipline?
Yeah, when we renew a license, we have to tell them if we've been disciplined, and yes, we have by Alabama. Colorado asks us for the same information. We present it to them. They said it's fine. We have no reason to move forward with that.
So no states have issued reciprocal discipline on your license based on the Alabama action?
Correct, no. And the Alabama action had to do with a lot with not showing up to that date. I have the Colorado consent form here too, if you want to see that. This is basically saying that Colorado did an investigation as well, and it said that there's no reason to move forward.
Have you had any other discipline in any other state?
No.
How about Maryland?
Maryland, we, our license just took a long time to renew. And so we couldn't ship products there for a long time.
You didn't pay a fine in Maryland of $25,000?
That might have been before my time. I'm not too sure. When was that?
Looks like 2013.
So again, that might have been, I don't think I was part of that then. I don't know what that fine would be. If it was 2013.
How long have you been with this company?
I've been there for about 10 years, but my knowledge of that incident isn't, I don't know what happened in 2013 with Maryland.
According to what we have from NABP, it was for operating without a license or a permit, specifically shipping products to physicians' offices without holding a wholesale
So
distribution.
that had to do with the renewal of the license took for a long time. There are some states that allow you to ship in the product when you're renewing the application. I don't know what happened at the time with the management when I, wasn't managing the company. And they continued to ship kind of not knowing that they couldn't, I believe. And then they got caught and they paid the fine and they stopped. We now have a very fine relationship with the Board of Maryland and we continue doing business there.
Can you speak to the employee training? It seems that's come up a couple of times.
Yeah, we do. A couple of years ago, we did not have a quality control unit in place. We kind of had a system where everyone kind of had a certain job that would overlap, like everyone wore a couple of different hats. Now we have a specific unit that does quality control. We have a training personnel as well. They do monthly training on everything. We just did a GMP certification yesterday. We are really trying to, satisfy everyone's needs and when it comes to the FDA requirements.
So you would expect if they came back in, you'd be entirely compliant with that at this
Yeah.
point?
Oh, 100%. Yes. With the training. Yeah. Our logs are up to date.
It looks like most of the observations from the 2023 FDA inspection are about documentation
Right.
of things, right? Not about cleanliness or
Right.
cleaning procedures. It's more about lack of documentation.
Sure. And some documents were filled out incorrectly. Things that were very correctable at a pretty fast rate. And again, we have since not closed out. We've closed out this issue to the point where the FDA said, you do not need to submit us any more information regarding the most recent 483. We are content with what you sent. We will do an investigation when we come out next time for further action.
Madam
They
Chair.
did provide that correspondence from the FDA that is included in your packet.
So going back to the FDA findings, number 3 says equipment used in the manufacture, processing, packing, or holding of drugs product is not of appropriate design to facilitate operations for its intended use. Can you elaborate more on that?
Which observation 3 we're talking about?
Mm-hmm.
Which one?
So practically FDA is telling us that the equipment that you use at your facility is not designed to facilitate the operations for its intended use.
Sorry, what observation is that though from?
From FDA findings. And they have cited you on this before in 2019 and 2021. So my take on this is that you used an equipment that is not approved by FDA.
Oh, okay. That had to do with validating the equipment. So the equipment did not have a validation process during that time. That was what they found during that inspection. So we had to do a robust validation, accreditation SOP and make sure that each equipment was validated.
So the initial finding dated back in 2019.
Right.
Why didn't you address it in 2021?
We did address it, but we didn't get through every single piece of equipment. For instance, we did the pill counters, we did our labeler, but we did not do the printer of the labeler. We didn't know that had to be validated as well.
So you had 2 years to work on this project.
Correct. But again, the validation of the printer was, they asked us, how do you know that 100 labels got printed out of the printer? We didn't know we had to do like a whole validation process based on saying that the 100 labels, we need to print out 100 labels, hand count them 8 times, and then document that it's actually accurate. I do have that all cleaned up now, just we didn't know that the validation had to go to the printer as well as just the pill counters and the label systems.
How long has your company held a license in Arizona?
I do not know off the top of my head. I would assume quite some time.
Madam Chair, one more question. From New Mexico inspection results, the New Mexico Board of Pharmacy did recommend that the flooring need to be replaced.
Yeah.
And that's not to me, is a construction project.
That happened. We're talking a couple of years ago. too.
Okay, so
Yeah.
it's already done.
Oh,
The
yeah.
floor has already been replaced. Okay.
Yes.
Madam Chair, Calvin Scott has held a permit since August 3rd, 2011.
Have we ever had any issues that you can see?
Let me take a look one moment.
I have a question. Do you have someone who's over your compliance?
Yes, we do. Well, it's part of our quality control unit, and then we also hire external help from a company, and we use them quarterly. So 4 times a year, we have them help go through and do an internal audit of our compliance.
An external consultant?
Yes. They're from
Okay.
Compliance Insight.
I guess the reason why I'm asking is some of these items seem very basic, like
Right.
cleanliness, the appropriateness of equipment, of the flooring.
Right.
They seem like kind of basic things.
And we have changed drastically in the past 2-3 years.
And I just want to hear that there's oversight,
There is,
there's accountability, there's change.
absolutely. And we can provide you with photos or documentations or anything you need further ahead.
Madam Chair, it looks like this is the first time that Calvin Scott has disclosed anything on their renewal application.
I don't know. This is where my head is. We see multiple repeat violations with the FDA. Well, that's not uncommon. We also have had issues with the New Mexico board. It's been a little while since New Mexico's been in there, but it hasn't been that long since the FDA is there. I don't know. I'm kind of torn on this one personally, because I feel like, to your point, that some of these things seem like they should have been easily correctable, but yet they kind of are following them along the line. And since this is a non-resident pharmacy and our inspectors are in there, it gives me a little bit of pause. It's kind of where my head is right now.
I'm thinking, could we do some sort of monitoring probationary period until the next FDA inspection? Because these repeat findings three times. Is there a mechanism to do that?
When do you expect your next inspection to be for New Mexico?
I have no idea. We can try to request one. I don't know if that's possible.
What about the FDA inspection?
The FDA inspection happened last year. They kind of stated that we're no longer on their target area. And so they don't know when the next inspection will be. They've been satisfied with what we've supplied them.
Dr. Gandhi, is New Mexico a VPP state? Do they do blueprint inspection?
I have to research that a little bit, Madam Chair. Let me do that while you continue talking.
Mr. Anderson, if we did some type of probational, what would the terms be? What would you like the terms to be?
Probation for the permit concurrent and until the next FDA inspection, and then a request to come back to the board to present the results of that FDA inspection.
Yeah. I don't know that we can tie it to the FDA. I mean, Sunil, you're way closer to that. I mean, that unless it could be a long time before the FDA comes back, it could be a short time. That's not typically something that's timed. I don't know that they're going to go request an FDA inspection either. Kind of where my head is, and why I asked Dr. Grande about VPP is perhaps we extend it to the next meeting and request a VPP inspection at their cost that could be brought back to us. That way we have the opportunity to have a different set of eyes on it, or VPP or New Mexico inspection. Whatever they choose was kind of where my head is. So that way we've got a different set of eyes to see if any of these things really have been corrected. is where it kind of was my train of thought.
I like that idea. I would
Does
feel
VP do they inspect repackagers?
I don't know.
they do. I would assume that they would because that's your home state, right? New Mexico.
No, she was saying VPP, like
Oh,
the
okay.
blueprint inspection. Dr. Gandhi, Jen, do you know? I don't know.
I don't know. Going through his responses to the FDA inspection from June 2023 appears that they've corrected most of these things. There's a lot of documentation in here to support that as well, like printer qualification reports and things like that. It looks to me that there were some times that you had some repeat violations, but it appears right now that you've corrected all of them.
Yep.
Or I was kind of thinking is some sort of letter of concern or whatnot with requirement if possible for them to submit their next board inspection or FDA inspection to the staff that they could look it over. And if there were any issues, bring it back before us at the board.
Do you ship into Arizona?
Yes,
Is that the reason why you have a license?
yes.
And what's the nature of your business into Arizona?
We, what do you mean? We ship repackaged pharmaceuticals, mainly weight loss products to like med spas and whatnot.
Okay.
So the prescription controlled substances.
Specifically to provider offices?
Yes, it has to be shipped to a doctor.
You mentioned controlled substances.
Controlled for
Weight loss.
yeah, weight loss. Phentermine is a controlled
Okay.
for substance.
If I may, the correspondence from the FDA states, "Good afternoon. If all your corrections have been completed and implemented, then you do not need to further send in updates. We will verify your corrective actions and ongoing corrections during your next inspection."
That's where I'm kind of leaning towards probation till that next inspection, and then they demonstrate that they've corrected this. I don't know.
But there's no set timing on that. I mean, it
Mhm.
could be 10 years, could be never, I mean, how
But
do,
we've-
how do we?
We've had 3 here in the last 5 years, 3 FDA inspections within the last 5 years, because we've had 3
Which
483s.
tends to be a concern also.
Right, which is why
Mhm.
we've had so many 483s.
What if we imposed a period? This is just an alternative thought. I just think like, how do we manage this as like, how does our staff manage this since we have no way to know when the FDA is going to come? What if we put a time frame on the probation and that they were able to come back before us if they have an inspection from either the FDA or the New Mexico board, and we can review it at that time and determine like maybe it's a year, maybe it's 2 years, and then they have the opportunity to come back before us if they can provide a satisfactory inspection. And if they want to request an inspection and get it to us sooner, then that's fine. They can come and bring it before us. Is that an acceptable option, Ms. Galvin?
Typically, terms are attached to a period of probation where you would want the licensee or the permit holder to accomplish something, to engage in some sort of conduct during the time of probation.
Gotcha.
You
Would
would al-
the inspection be part of the terms? Seeking out the inspection?
If they request it and you look at, not just waiting around for an inspection to occur either from New Mexico or the FDA, but if they get the VPP, then that might be. That
Or
would be
the
them
Board of
ordering them to-
Pharmacy in New
ordering them
Mexico.
to obtain it, yes, would be a term of probation. You also have to provide violations, what violations would they commit if you're going to impose probation?
Have you guys ever been inspected by the DEA? Just
Yeah,
out of curiosity.
Yes.
Okay.
The DEA is mainly just about pill control. They want to know your inventory, where it went. They're not so concerned about anything else besides where did the medicine go.
So can we just make a board order for them to get an inspection?
Madam Chair, New Mexico is not a blueprint state.
So VPP is not an option then.
A board order to get a New Mexico Board of Pharmacy inspection.
And that would be a consent agreement at this time. It would be an interim consent agreement.
Yeah. All right.
Could we potentially table it and ask them to contact the New Mexico board and figure out a time frame for an inspection? And then once we get that inspection, approve their permit pending the results?
Yeah, that would be an option.
I mean, the FDA is satisfied with what's currently going on. I know a lot of these things are from years ago and what does the probation mean if we can't ship in your state until it's cleared? Is that correct?
I don't think the board is requesting or ordering you to stop shipping.
Madam Chair, another comment. So yes, New Mexico is not a blueprint state, but NABP, they do inspect repackagers. So they could request an inspection by NABP.
And we've had one of those recently as well.
Do we have that? No.
It's been about a year and they still have not given us our report.
NABP is not giving you the report?
No,
So you requested and paid for it and they didn't give you a report.
correct. They said they're still working on it.
That seems very atypical to me.
I have that documentation as well. I can send you guys.
So we should wait for their report.
When was that inspection?
It's a year ago.
I'd say over a year ago. To the point now, they just asked us to renew our license with them and they didn't ask for any inspection.
Were you required to get an NABP inspection to renew one of your
Yes,
permits in another state?
correct.
What state asked for that?
Particularly Maryland. And then I know there's a few other states that require the NAPD license to have it.
So is your license still pending renewal over there?
It's still pending renewal, but it's still active. To the point where they just asked us to renew it again without it ever being actually renewed.
Is there a way for us to reach out, or like our board to reach out to NABP? To,
Madam Chair, I just did that, so I'm waiting for a response.
But now it's been a year. I think we want something current.
I mean, we usually get NABP reports back within a couple days of inspection, so it's highly atypical.
He has had a FDA inspection in June. So he's had a regulatory body in his facility within the last 6 months.
Which found repeat violations from the last time, which what I was kind of hoping for is that we would have some sort of progress that we could have seen by somebody independently evaluating it to see that something has changed since the last FDA inspection, since we found the same kind of things that we found on the other ones, is where my head was at with trying to find a way to validate what he is saying is true, which I have to believe that it's true, but I'd like to validate that as well.
Sure.
Trust
What if
but
we-
verify.
What if we did it for probation pending either an FDA, an NABP, or a New Mexico inspection?
I think an interim order or interim consent agreement requesting an inspection is more appropriate than putting it on probation
I agree.
pending the inspection. You would issue an interim order, an interim consent agreement for that inspection, see the results, and then determine if probation is warranted.
Would an interim consent agreement requesting an inspection count as discipline?
No.
so we can ask for NABP. I mean, it's been a year ago, so maybe it'd be more appropriate to ask them to get another inspection from NABP, and we can apply probation till that completed.
The NAPD BPD just asked us to renew our license and send in the fee or the paperwork, which we just did the other day. So I don't know if that inspection is going to happen naturally as well.
Yeah, but it's been like almost a year, you said, right? Like
Yeah.
more or less. Yeah,
NABP
but-
doesn't license pharmacies, just for the record.
Doesn't what?
NABP doesn't license pharmacies.
Will they give you a certificate, right? Of a,
So
If I may, it looks like NABP conducted an inspection on July 29th, 2022. The accreditation date is valid until July 28th, 2025, but it says re-accreditation in progress.
okay.
So I think we need more information from NABP as to why that's still in progress.
Could we table it so the next meeting, see what information we can get from NABP, and in the meantime, see if he's able to request an inspection from New Mexico?
You may.
So, Ms. Calvin, if we place him on probation, would his company be able to ship the drug to Arizona?
Yes, that does not prohibit him from shipping into Arizona. But again, you would typically want to attach terms, and that would require you to find and determine that unprofessional conduct has occurred.
I'm in favor of tabling to the next meeting, trying to gather that information before we do something like put them on probation.
Then I would ask that you be very clear with staff about what information you would like them to obtain, and also be very clear with the permit holder what information you want them to obtain and present to the board.
For me, it says we should hear back from NABP. I mean, till next meeting, you can reach out to them as well. You know what I
Sure.
mean, because I mean, if you have something been pending for a year, I mean, you should have already reached out to them, but maybe now till next meeting, hopefully that you'll get the report from them.
and we have reached out to them and they just say we're behind. So.
Does the FDA have a liaison to the states that can assist with this?
Just to ease my mind about the cleanliness of the pharmacy, can you reach out to your company where the central office and ask them to fax to the board staff records that shows that you have already addressed all the citations cited by the New Mexico Board of Pharmacy way back in 2021?
Yeah. We do that.
Okay,
Is there, can I get that fax information or?
whatever.
Okay, sure.
And Mr. Hargraves noted that their permit, the expiration date has been extended through tomorrow. So you would probably have to.
Extend that,
Mhm.
and if we're gonna table it till the next
What's
meeting.
the benefit of tabling versus making an order?
It's just to wait for NABP to see what's finding or what to look into the report.
We can include that in the order that we'd like
Okay.
that
if
information.
better to do- Yeah.
And,
for consent.
and
consent
that
order,
inspection
consent
was still a year ago, whatever they're gonna come back with. So I mean, things have changed for the better at our company a year after that inspection that did occur. I don't know what, if they're gonna say anything, the inspection went really smooth. but-
Unless they have more finding, we don't know, right?
Right, but they may have findings that are already corrected.
Essentially, if we table it, we're asking him to do something and, or we're ordering him to do it. I think I'd rather have it on the record that there was an order.
What about extending the renewal date on the permit and issuing a board order to request an inspection at his own cost from New Mexico? Can the Arizona board fly out there and inspect?
Yeah, that's very atypical. That
Okay.
doesn't happen.
A New Mexico inspection and provide that to us within a certain time frame?
So it would be an interim consent agreement where they, the permit would be extended until the February board meeting date. And in the interim, we would require them to obtain a current inspection from the New Mexico board.
Okay.
And then to Ms. Nair's point, if they failed to do that, then that would be violation of a board order.
And then if there's any reason the Mexico State Board says no, they won't do an inspection or they can't promise a time date, I just can provide you with that information.
Yeah, you can reach out to staff at that point.
Okay.
I'll make that my motion.
I'll second.
Any further discussion? Since it's an order, do we want to do roll call? It's not discipline though, right?
It is not discipline, but I want to be sure that we have everyone on record.
Okay, let's do roll call then.
Ms. Walmsley,
Aye.
Ms. Davis,
Aye.
Ms. Lehan,
Aye.
Ms. Nair,
Aye.
Mr. Dang,
Aye.
Mr. Nassif,
Aye.
Mr. Anderson,
Aye.
Mr. Thorwald.
Aye.
Thank you.
Thank you for your time.
Thank you. So is our permit then extended?
It will, yes, it will be extended. The staff will be in communication with you.
Okay.
Thank you.
Thank you for your time.
20G, InfuServe America.
We're here.
Hello, if you could please introduce yourself for the record.
I'm Ryan Quigley, General Counsel. With me is Anthony Wolfenbarger, the pharmacist in charge.
Ms. Galvin, do you have questions for the?
No, I'm General Counsel. You're here as a fact witness. Is that correct?
I'm here, the fact witness, as well as Mr. Wolfenbarger, our pharmacist in charge.
Thank you.
Ms. Bolts, would you like to give us a brief summary of the application review?
InfuServe America applied to renew their non-resident pharmacy permit on September 11th, 2023. They disclosed disciplinary action taken against their facility in November 2021 by the California Board of Pharmacy. The order from California states that in 2019, InfuServe was found to have been compounding a sterile injectable product with a dietary grade active pharmaceutical ingredient. The order also indicated that the business was using ascorbic acid USP, yet labeled this preparation sodium ascorbate. In a remote sterile inspection conducted in 2020, a California inspector found similar violations to those in 2019, along with other causes for discipline. The causes for the 2021 disciplinary action include misbranding compounded sterile drug preparations, failing to maintain quality of compounded sterile preparations, adulterated preparations, incorrectly labeled compounding sterile preparations, failing to maintain quality of compounded sterile preparations, adulterated preparations, failing to obtain ingredients from an FDA-registered supplier, and failing to report an adverse reaction in a patient who received glutathione when reported by the administrating physician. InfuServe America provided a detailed list of the items shipped into Arizona that were associated with the California complaint. These, the settlement and accusations, various correspondence submitted on behalf of InfuServe, and a list of adulterated and/or mislabeled items shipped into Arizona are available for your consideration.
Thank you, Ms. Bolts. Would someone from InfuServe like to make a brief statement before we proceed with questions?
Yes. Hi, my name is Anthony Wolfenbarger, and I'm a pharmacist here at InfuServe, pharmacist in charge, Florida license PS 2166. My statement would be yes. At the time, 2019, we were relying on our suppliers to provide us with API suitable for compounding. At that time, we relied on PCCA and Fagron to do that. At that time, we were not ourselves personally vetting that against the FDA's site identification for manufacturers. That was certainly our fault. The C of A's were obtained, the C of A's were evaluated. There was no indication that this product was not suitable for the compounding we were doing. So that being said, yes, we have made many corrections since then and have been inspected by California 2021, 2022, 2023. Florida, again, those years, and we recently had NABP, VPP here, October 11th of this year, and found in full compliance.
Board members' questions?
The California Board of Pharmacy has been disciplining many sterile compounding pharmacies for compounding sterile products with things that they consider to be inappropriate for use in compounding because of draft guidance by the FDA. The FDA has indicated in draft guidance that dietary supplement grade products are not appropriate for use in compounding, even though the United States Pharmacopoeia makes no difference between dietary supplement and drug grade products. So just remember that's draft guidance from the FDA about the dietary supplement. Also, the sodium ascorbate, when ascorbic acid is dissolved in water and the pH is adjusted with sodium hydroxide, the final product is sodium ascorbate, even if the starting ingredient was ascorbic acid. The repeat inspections and kind of similar discipline from the California board for this pharmacy and many, many other sterile compounding pharmacies would give me no pause in renewing their license.
Thank you, Ms. Davis. Very helpful.
I'm fine with this. You want to make a motion for that? Or?
Unless there's further discussion.
I'll make a motion to renew InfuServe America's non-resident pharmacy permit.
I'll second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Thank you very much for your time and attendance today.
Thank you very much.
Thank you.
20H Tomladon Company.
Hello, I'm here.
You could please introduce yourself for the record.
My name is Nick Miller. I'm the pharmacist in charge of Tom Eldon Company. We do business as Pharmacy Solutions, and we're in Arlington, Texas.
Thank you very much. Ms. Voltu, will you give us a review of a summary of this renewal?
Tomeldon, I'm sorry, how do you pronounce it?
Tom Eldon.
Tomeldon applied to renew their non-resident pharmacy permit on September 26, 2023. The permit holder disclosed a settlement agreement with the United States Attorney's Office for the Northern District of Texas on behalf of the Drug Enforcement Administration and a related memorandum of agreement with the DEA. These were to resolve allegations stemming from a DEA inspection in 2019. The agreement alleges that Tomeldon refused or negligently failed to make, keep, or furnish required records, reports, notifications, orders, and order forms, statements, invoices, and other information required under the Controlled Substances Act. These alleged record-keeping violations took various forms, some of which were recurring and included filling a prescription for a fictitious individual and disposing of controlled substances without proper documentation.
Thank you, Ms. Bolts. Would you like to make a comment?
Yes, please. First off, I would just like to thank the board for allowing the flexibility for me to do this remotely and stay in Texas and take care of my patients. So I really appreciate this, and I'm grateful for the technology that allows me to do it. So thank you for that. We're a compounding pharmacy. We've been in business for 32 years. We have one location. We're PCAB accredited for both our non-sterile and our sterile products. We've requested multiple VPP inspections and have really had no significant issues that's come from that at all. 4 years ago, we had the DEA come in November 2019, and that inspection was primarily focused on controlled substance waste documentation, documentation of the waste that was generated during the compounding process, and also anticipatory compounding of sterile controlled substances. So we entered into the MOA and the settlement agreement in January of this last year, and we notified the board as soon as that was finalized with the letter. As far as the anticipatory sterile compounding, The DEA deemed that process, they were calling it manufacturing and stating that we could not perform that process of making the sterile controlled substances ahead of time. And the explanation, really, the important thing to remember with that is whenever we're making a sterile compounded controlled substance, whether it's controlled or not, I suppose, we're submitting that for potency and sterility testing, quarantining it before it's ever dispensed to a patient. So all of our prescriptions were dispensed pursuant to patient-specific prescriptions. We weren't selling in bulk. Everything was being submitted to PMP. But the DEA's view was that in order to do that, the product it can't sit in quarantine for at least the 14-day period to get the sterility results back. So in response to that, we immediately ceased that procedure, and we've not resumed it since then.
Thank you for that. Board members, questions?
Are you dispensing controlled substance prescriptions into the state of Arizona?
I don't have an exact number. I would, and I don't want to speculate, but I would assume that we are, but in very, very limited numbers.
I've had dealings with the DEA at my pharmacy as well in the past where they had problems with anticipatory compounding of controlled substances and made reference to requiring a manufacturer permit.
I have a question. Wasn't something found about a fictitious person? Can you talk about that?
Yes, I'd love to. Thank you. So in the review, as I mentioned, everything was being submitted to PMP. And of course, we welcomed the inspection with the DEA, and we were eager to see what they had to say so that we could improve our processes. So during this time when we were compounding, we were submitting these items to PMP. And whenever DEA, I suppose the way they got it was they reviewed those records and they saw that there was a prescription filled for a literal Jane Doe was the name on the prescription. And during the process, during the drug utilization review process, when the pharmacist was typing that prescription that was sent over to us via fax, we actually have documentation that we reached out to the prescriber's office who confirmed that the prescription was legitimate. So we made a mistake in continuing to fill that prescription. It was 1 unit of a controlled substance on a one-time basis. That was the only incident. In the settlement agreement, it alludes to the fact that some of the violations were repetitious, but I want the board to know that the incident of the fraudulent prescription was one single incident that was identified. And so the pharmacist, we circled back and trained on identifying those things and those red flags, which we did identify, but we didn't follow through on refusing the fill. So we take ownership of that, and that was a mistake.
It seems to me like they've followed up on the items and they have a good handle on their operations currently, so I would move to approve this.
I'm comfortable as well, based on the fact that the DEA is going to continue to monitor them with their MOA anyways, so I would be in support of that as well.
I'll second the motion.
A motion and a second for approval. All those in favor?
Aye.
Aye.
Any opposed? Hearing none, thank you so much for your time and attendance today.
Thank you guys for the ability to come in and represent myself. So thank you very much for your time.
Thank you. Next up is item 20I, Cody Walker, pharmacist renewal. Is Mr. Walker present? Do we expect Mr. Walker to be present today?
He was invited. I haven't heard either way.
Board members' thoughts, are we okay to continue, or do we want to table this and come back to it later today? Do we want to hear from him? All right, let's hold off on this one. Staff, if you could reach out and see if you can get him on the line, that would be great. Item 20J, Quan Trong pharmacist application renewal. Please approach. If you could please introduce yourself for the record. If you can push the button.
Okay, my name is Kung Tung.
Thank you. Appreciate you being here. Are you doing the review today? Okay, perfect. Go ahead.
Mr. Trong applied for to renew his pharmacist license on October 10th of 2023. He disclosed disciplinary action issued by the Board of Examiners of Nursing Care Institution Administrators and Assisted Living Facility Managers, in which he holds an Assisted Living Manager certificate that enables him to practice as a manager of an assisted living facility in the state of Arizona. On August 16th, 2021, the Department of Health Services conducted an on-site assisted living facility complaint investigation at Kyran Manor LLC. On January 1st, 2021, Mr. Trong submitted a written response to DHS indicating that Kyran Manor LLC was the only facility that he managed at. He stated that he knew in June of 2021 that the facility license had expired and that Ms. Yosef, the facility owner, controlled and made all the decisions for the business activities. On September 16th of 2021, DHS took enforcement action and imposed a civil money penalty upon the facility licensee, Kyran Manor, for the substantiated violation of unlicensed care provided for 122 days from May 1st, 2021 to August 31st of 2021. Based on the evidence, the NCIA board determined that Mr. Trong was responsible for the identified violations and that his actions or lack of thereof fell below the standard of care managers and could have caused harm to the residents and the public. He was disciplined with the following. His certificate was immediately suspended, but the suspension was stayed as long as the terms of the consent order were met. He was placed on a term of probation for 3 months. During the probationary period, he had to submit a $614 fee and complete 3 hours of continuing education and ethics. Board staff asked Mr. Trong to provide verification of his certificate, and according to the verification, his certificate is currently active and expires September 7th of 2025.
Thank you, Ms. Garcia. Mr. Trong, would you like to make a statement?
Oh, yes, with that incident that I completely have no control over the owner business because she forgot to renew her facility license. And she is the owner. She is the designated manager for that facility. So the Department of Health, the reason they don't let she willing to pay for the late fee, but the Department of Health did not allow her to do so because she lost her grandfather status, like in the old days that when they own a home that did not have a fire sprinkler in it, and they still let the elderly living in there. Now that, you know, most city like Mesa, Chandler require a fire sprinkler, safety for the elderly people. So she willing to pay the fee and run without a license because the Department of Health allowed her to do that. And I walked into to get the professional come in to install the fire sprinkler. But then it's too expensive for her. She don't make that. She only have like, at the time when I was a manager, she only have 2 or 3 elderly people in the home. But then at the time that the Department of Health come out, she have 5. So she say it's so expensive for her to put in the fire sprinkler to get her license approved. So at that time, then she's not willing to do it. So then I withdraw from to be a manager because she, you know, she don't want to put in a fire sprinkler. But I don't know, you know, my attorney said that I'm not supposed to be responsible for her business. They should not spend me because, you know, it's difficult if a manager shouldn't live and we're not responsible for. I manage the people the caretaker, but not her facility license. It's her job to doing that. But I don't know why that the board of nurse that I guess that they punished me because they put me on probation because they want me to pay the inspection fee for people to go out there to inspect, but I have no control over her business.
So you don't work for this assisted living facility anymore?
No,
What was your role when this whole thing transpired?
my role is that, you know, to make sure the elderly people are taken care and to make sure that people working in there to, you know, that they up to date with their license. But with her license, the facility license is that the owner had to be responsible for it.
But you held an individual license to do this work as well.
That's right, yes.
And that's why the Department of Health Services took action on your individual license, is because you had responsibilities at that time.
I have a responsible, they require any assisted living that they require a manager, but then when you was a manager, you can designate, the Department of Health allow you to designate somebody else to be a manager. And so I come in there, I designate like 3 people to be a manager on that facility. The 2 caretaker plus the owner.
But you were ultimately responsible in the eyes of the law.
I think so, but you know, but after the fact, then my attorney saying that I should talk to her from the beginning because, you know, I'm not supposed to be responsible for the facility license. That's because she just forgot to renew her facility license. I'm responsible to manage the people working there and make sure that the residents are okay.
Madam Chair.
One of you.
So question, are you currently working as a pharmacist elsewhere?
Yes, I'm working as needed pharmacist for Sam's Club.
Sam's Club. During this time, the time that you were fined by the DHS, were you working as a pharmacist during that time?
Part of it, because during that COVID, I was unemployed, and the owner did not find a manager to manage a facility. So she called me up and she asked for help. So I was unemployed at that time too. So that's why I come in to be a manager just less than a year.
So as a manager of the facility, were there drugs involved? Were you handling drugs or administering drugs to the patients?
No.
Okay.
Basically, you just do the administer work that complying with the Department of Health. All that it, you know, all the old people, they have drug from their own pharmacy that they bring in. You know, it's basically it's a residential assisted living care.
But did you exercise your skills as a pharmacist by counseling the patient on these drugs or administering the medication to these residents? None.
No, that's right.
Okay.
So from what I'm hearing, and this is just, I'm summarizing, is you allowed this facility to hang your personal license because it was a requirement and you didn't actually work there. And you designated assisted living managers, designees under
No.
your AL manager license. And because you said you were unemployed, but you're hanging your license at this building, you're not caring for these residents. And
No, I come there like the Department of Health require you to come in like 12-hour a week. That's a minimum requirement that you have to be there to make sure that.
So were you doing that?
Yes.
Do you understand why we might have some concerns, even though you weren't necessarily doing pharmacy tests, how this relates potentially to your actions as a pharmacist?
No, I'm not aware. I don't know how this related.
Can we seek legal counsel in executive session, please?
You may. Would you like to make that motion?
I'd like to make a motion for
Executive
legal
session.
counsel and executive session.
Second.
Motion and a second. All those in favor?
Aye.
Any opposed? Mr. Trong, we'll be back with you in a few minutes. We're going to go into a separate room, so just hang tight. Okay, welcome back, everybody. Discussion after executive session. Thoughts on a motion?
Can I make a motion? I can. Okay, I will move to approve his renewal.
Do I have a second?
Second.
All those in favor?
Aye.
Aye. Mr. Trong, your license will be approved, but I do want to make a statement. So the reason why I ask you that question about why do you think the Board of Pharmacy would care about this? I have concerns that you didn't accept responsibility for something that you were responsible for. As a person that held that license from another department of this state, as a pharmacist, you also have responsibilities, right? And you work for another employer. I would hate for you to see us for you to come back before us for a decision that you made where you didn't hold responsibility for the actions that you had that are within the jurisdiction of this board. So hopefully we won't see you again. I just want you to understand that your lack of acceptance of your role in this does provide concern for me as a board member.
Thank you for advice. I learned a hard lesson. This is when I was so nice and trying to help it out, the facility to take care of the old people. And during the COVID, they have a difficult time to find a caretaker and nobody working. So I appreciate it. I learned a lesson.
I appreciate that. I hope that we won't have to see you again. So best of luck to you and thank you for being here today.
Are they going to renew my license by tomorrow so I can work on Saturday?
Yes, it will be renewed.
Right. Appreciate it. Thank you.
Thank you. I received a request for a comfort break. So if we could take like a 5-minute break and come back at 11, come back at 11:30. right, welcome back from break. Ms. Gannavon, can you do a quick roll call?
Certainly. Ms. Walmsley,
Present.
Ms. Davis.
Present.
Ms. Lehan,
Present.
Ms. Snare,
Here.
Mr. Dang,
Here.
Mr. Nassif,
Here.
Mr. Anderson,
Here.
Mr. Thorwald,
Present.
all accounted for.
Thank you very much. I think Mr. Walker has joined us. Mr. Walker, if you're in the room, if you could please either unmute yourself. I think you're online. Yes.
Yes.
If you could please introduce yourself for the record.
Cody Walker, pharmacist in Salt Lake City, Utah.
Okay, thank you. And then Ms. Garcia, if you could give us a brief review of his application renewal.
Mr. Walker applied to renew his pharmacist license October 23rd of 2023. He disclosed disciplinary action issued by the Utah State Board of Pharmacy. On May 16th and May 19th of 2022, the Utah Board conducted a random inspection of HRX Pharmacy. The violations that were found during the inspections are listed on pages 2232 and 2233 in the board book for the board's reference. Mr. Walker's pharmacist license with the Utah Board was revoked and immediately stayed. He was placed on probation for a period of 4 years with conditions including continuing education hours.
Thank you, Ms. Garcia. Mr. Walker, would you like to make a statement?
No, I believe most it's written in there. The stipulation outlines most everything. I've compliant with the state and I'm following their protocols and procedures for everything they're asking of me and have made all the necessary corrections and adjustments to my pharmacy and have also met the deadlines and the requirements the board's asking of me myself as well.
Mr. Walker, are you does your pharmacy ship into Arizona?
Yes.
And that's why you hold the Arizona license?
Yes.
Okay. Board members, questions or discussion?
Mr. Walker, it looks like you had quite a few repeat violations until the Utah Board took action. Have you corrected all of the violations that the board uncovered during their inspection?
Yes, I have.
When were you last inspected by the Utah Board?
It was May of 2022.
I'm personally comfortable with renewing his license, knowing that he has this agreement in place with Utah. His pharmacy is located in Utah. I know they keep a very close eye on their individuals that are under probation. So I'm personally comfortable with renewing it with no further action. I'm willing to make that motion.
I second.
The motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, thank you, Mr. Walker. Appreciate you attending today.
Thank you.
Thank
you for your time.
Ms. Kianavong, if you could direct me, do we want to go to conferences?
You could go to conferences or special requests.
Board members' thoughts? Do we want to go to conferences or try and knock out a couple of the special requests? Okay, let's go to special requests just because I don't know how long the conferences are going to take. Let's jump in. Starting at 29G. Discussion on possible deviation for produce pharmacy. Hello, Mr. Bozen.
Hello. Mark Bozen, counsel for Produce Pharmacy.
Hi, Brett Bannister, owner of Produce Pharmacy.
Thank you both for being here before us today. So we had a discussion at our last meeting about a potential deviation request. We asked for some additional information and you're back again. So
I
take it
am.
away.
I appreciate the board's opportunity to come back again. And I appreciate the thoughtfulness and allowing more time and giving some of us time to provide you with that information. Much of this information is in your book, but I also wanted to describe it in a little more summary fashion and also make it part of the public record because people in the gallery and online don't have access to what's in your book. So as you said, President Walmsley, at our October meeting, our firm and our client appeared to seek your interpretation of the shared services provisions that are found both in R423-110, which are the definitions, and R423-621. Simply, they describe the ability for two or more pharmacies to engage in shared order processing, shared order filling, or both. In this case, Red Mountain Pharmacy and Four Corners, and there are both under common ownership. My client is here. There was a brand new pharmacy that's license was approved but is not operational in Chandler, and then a pending application. So there will be more than two pharmacies eventually, should you approve this variance. Shared order processing, I'll remind the group, means, among other things, preparing, packaging, compounding, or labeling an order at the request of another pharmacy. In this case, the pharmacies request that either affirmation that the current law allows it to provide anticipatory compounding, and I'm going to use that word a lot because anticipatory compounding is uniquely different than manufacturing, for other pharmacies consistent with the shared services rule, or authorize a deviation from the rule the board views as a barrier. At our last meeting, board staff noted that R423-410, specifically subsection B3, may present a barrier because B3 states in part, a pharmacy permittee may not provide a compounded pharmaceutical product to a pharmacy, medical practitioner, or other person for dispensing or distributing. So in other words, if a pharmacy is doing anticipatory compounding for another pharmacy, it won't have a patient-specific label on it when it gets to the other pharmacy. And that seems to be objectionable according to Section B3. However, Section B3 goes on. That's only half the sentence. The second part of the sentence is, except that a compounded pharmaceutical product may be provided to a medical practitioner to administer to a patient of the medical practitioner if each container is accompanied by the written list of requirements that are found in Section I-5 and has a label. Well, we can't do that. Section B3 was preempted in 2013 by the DQSA. So to enforce the first part of the sentence of B3, but ignore the second part of the sentence B3, would be inconsistent with how an agency generally considers its regulations. But that's okay that that provision can be overlooked because we argued previously that Section 621 is more specific, more contemporaneous, and therefore is the controlling regulation. It's interesting, I wrote in my notes, if you wanted to enforce Section B3, you would have to, presumably, as a matter of law, allow for office use compounding for pharmacies that don't distribute interstate because it's on Arizona's law books. But we're not asking to do that. But that might be the unintended consequence by going forward with B3 controls. At the October meeting, we argued two things. First, it's improper to enforce half a sentence, like I described. And second, that the shared services rule is much newer and more specific than the good compounding practices found in Section B3. And you can and should enforce the newer rule. Why? If this were a conflicting statute, Arizona case law provides guidance about how to proceed. Now, I recognize the legal argument I'm going to make now is related to conflicting statutes. Statutes and rules are different. There was no compelling court case that I could find about guiding an agency of what to do when there are conflicting regulations. So I'll preface that. But what I do think we can do is use the court's rulings on conflicting statutes as guidance. for what to do if regulations conflict. The Arizona courts provide guidance on what to do when two statutes conflict. And I'll just preface this. Statutes and rules differ. The biggest difference between a statute and a rules, statutes are passed by the legislature. Regulations are written by the agency that enforces those statutes and interprets those statutes. But they're both laws and they both have force. So that's why I think we can use court guidance on how to handle conflicting statutes when dealing with conflicting regulations. The Arizona court's guidance is generally that the most recently drafted statute controls. When two statutes, and I'll quote, address the same matter and contain an irreconcilable conflict on a particular provision, the more recent statute governs. There's a 2005 published case, Arizona published case in Ray Manny, and then there's also St. Joseph's Hospital and Medical Center versus Maricopa County, which is also an Arizona case that dates back to 1983. The court says where it appears by reason of repugnancy or inconsistency in the provisions of the statutes that the two statutes cannot operate contemporaneously, it must be implied that the legislature intended to repeal the earlier enactment. In this case, I would argue that it must be implied that this board intended, and I can't say that, I can't use the same word intended, because I'll talk about when these rules came into existence. Section B3 that we're talking about goes back and dates to August 5th, 1997. Section 621 that talks about shared services goes back to April 7th, 2007. Now, at that time, I think it's interesting. There would have been no reason to repeal B3 at that time because the DQSA hadn't passed until 2013, that federal law that preempts B3. So I would argue that the statutes aren't conflicting at all, or the regulations aren't conflicting at all, and here's why. The shared services rule that exists in part in 110 under definitions talks about the preparing, packaging, compounding, or labeling an order at the request of another pharmacy. The or is important. Had it been an and, then I would argue the board requires the shared service pharmacy to prepare, package, compound, and label an order. But the or is disjunctive, which means the shared service pharmacy can do any one of those four activities. Now, if this body who wrote that regulation in 2007 intended that every single shared service prescription be a patient-specific prescription, the or would have been improper because you would have to label it with the patient's name. And by not requiring the shared service pharmacy to do all four functions, which includes attaching a patient-specific label, they're provided some deference to, hey, you got two pharmacies that are working together. You have a certain skill set, you have a certain amount of capacity, state-of-the-art facility, people, and you don't. I need you to do these functions to fill in the gap for me, compliant with Arizona law, and I'm going to do the other functions. And in this case, I can ask the other pharmacy to prepare, package, compound, or label, or do all four. The other provision that the Arizona courts talk about when you're, let's say you're still arguing, now I still think they conflict. The other provision is whether or not one is more specific than the other. I would argue that 621, the section on shared services, is more specific than section 410. Why? 410 applies to every licensed pharmacy because every licensed pharmacy, by virtue of having a license, has the ability to compound medications. It's very broad, applies to everyone who has a license. 621 only applies to those pharmacies that choose to enter into a shared services agreement, and it's a very, very narrow component of what a pharmacy does. And therefore, it provided more specific guidance, and it comes way after the implementation of the Pharmacy Practice Act that the legislature passed, and way after the implementation of the good compounding practices. And candidly, for those of you who've been working in the state for a long time, the enforcement position of this board was absolutely. Pharmacies engaged in a shared services agreement can engage in anticipatory compounding. There was never any formal substantive guidance. It was simply an enforcement position, and pharmacy inspectors use their enforcement discretion to decide whether or not pharmacies were acting appropriately. Our deviation request, so that's the background. That's the conflict of law analysis that Board Member Snare asked for. Happy to answer questions about that. But let me run through more specifically the deviation request. In the deviation request, you asked our client to submit 4 pieces of evidence to justify the deviation request. So let's say it doesn't matter. Mark, I still disagree with you. Reasonable people can disagree. B3 prohibits this activity. So how do you proceed if that's where you are? You are allowed to issue a deviation for a pharmacy to I don't want to say ignore, but to comply differently and waive the section of B3. And so let me talk about that. This is in your book. You asked our client to describe the reason for the deficiency request and the length of time requested, not to exceed 2 years. Well, the client's going to ask for 2 years because that's what they're allowed to ask for. But our client is willing to consider a shorter time frame if you want to call it a pilot program. At the last meeting, we said, hey, if this is uncomfortable for you, we can put boundaries on this, including time limits, and provide regular reports to you. The reports I would suspect you'd be most interested in is volume, types of products, whether there've been adverse events reported. We're willing to discuss all of those things as part of the deviation, should you decide to do that. But what are the other, so that's the length. But what are the reasons? First and foremost, we think this enhances patient safety. Why? It is no secret to anyone who runs a business that it's extremely difficult to find staff, particularly talented staff. And if there is a more important person in a pharmacy, I would find it hard to find the person who is more important than the sterile compounding pharmacy technician. I'm a 2nd-generation pharmacist. One of the things my dad told me when I got my license that I was very proud of, that it is a license to kill people if you're not careful, and you have a profound responsibility. I would argue the easiest way to harm someone and potentially cause a fatality is in the sterile compounding lab. And that means not only do you have to have state-of-the-art facilities, incredible quality assurance measures, but you've got to have talented staff. And as a pharmacy, and this one's a small pharmacy, and I think that should give you some comfort. Right now, there are 2 stores. There'll be 3 online pretty soon. And perhaps a 4th down the road. There is a pending application for a remote dispensing facility. It will follow all of the requirements of a community-based remote dispensing facility. But for the 3 main pharmacies, to make sure that state-of-the-art facilities, and particularly the most exceptional and talented pharmacy technicians and pharmacists are available to supervise these operations, to expect that to be replicated under every roof, under every 4 corners of every pharmacy, I think is unrealistic in 2023. Whether I don't care what business you're running, a law firm, a pharmacy, it's hard to find people, let alone exceptional people, and you need exceptional people. What else does it do? It provides for standardization and consistency. The easiest way to control quality is to control the number of people, the number of times, and have direct oversight over the facility where it's happening. The more times you repeat an activity, the more opportunities you have to make a mistake. It allows for more traceability and accountability. In the event that there would be a catastrophe, it would be much easier to do root cause analysis if there is one facility providing certain services as opposed to many. Resource allocation, I talked about that. And public health and confidence. One of the things that is no secret to the pharmacy community and especially to the public are the challenges facing community pharmacies. And the workload, the ability to staff them, the ability to be open, the hours that are open. And this is an opportunity. Statute allows you to modernize pharmacy. If there was ever an opportunity for us to modernize community pharmacy, it's now. We've got to be thinking very critically. Do we need everything that needs to be done by a pharmacy to happen under every roof, under every licensed facility? Or can the pharmacies utilize shared services more creatively to make sure our pharmacies are open, accessible to patients, because we're not having to close them, and providing high quality services because there's not too much to do. That leads to the second part. What's the expected public health benefit? We would argue reduced medication errors, enhanced patient outcomes because people are getting access to the medications that they need more quickly, lower costs. It is no secret that controlling overhead and FTEs is probably the biggest thing to help keep costs lower and providing lower healthcare costs, lower medication costs, pharmacist and technician well-being and retention, strengthening the public trust comes with that, and regulatory compliance. It's much easier to run a compliance program if you're viewing things in buckets. How does this deviation support the mission of the board? That's an important question. First and foremost, your mission is to protect the public health and safety. Right now, community pharmacies are on the front lines. They have been since COVID. They were there before. And if the data shows, and we believe it will, that this is a very, very safe, and we have confidence in the quality assurance, that accomplishes your mission to deal with patient safety. You also our compliance organization. It's going to help you and your inspectors with compliance. Rather than having 3 or 4 compounding pharmacies that are doing sterile things that you have to inspect with the limited staff and time you have, it's centralized. Here it is. You want to focus on the sterile compounding operation, you have one address to go to. Pharmacist, technician, and well-being. I would argue that's among your charge, because if we have pharmacists and technicians walking out of the job in these community pharmacies, that's going to affect patient safety and access. And therefore you have a stake in that. You're at least a stakeholder. And then that all of that leads into building the public trust. I want to be brief. You have this in your materials. How does the deviation from the statute advance experimentation and technology? It's interesting. That form is dated. There are 3 things that you're allowed to consider, and all 3 are disjunctive. There's an or: modernization, experimentation, or technological advances. That statute was updated to provide you much more authority and not have to rely on, oh, is this really an experiment or technological improvement? But we would argue, for the reasons I've said before, that this is part of modernizing how we handle and regulate community pharmacies. Let me address a couple of the objections that at least I heard or were implied at the last time I was here. 1, but isn't this manufacturing? Isn't this what 503Bs are for? And why doesn't your client just get a 503B license and build one of those facilities? Well, that's why I wanted to talk about anticipatory compounding. Anticipatory compounding is the function uniquely reserved by the United States Congress for 503A pharmacies. Does not appear in the 503B statute. And our client is not talking about becoming a manufacturer that is going to distribute product to medical practitioners, hospitals, and sell it to other pharmacies to make money like a manufacturer does. 503Bs don't have anticipatory compounding in their statute because it's irrelevant to their business model. That's all they do, is anticipate what the community is going to buy and ship it to them. Anticipatory compounding uniquely and squarely fits in 503A. Further, and this is my favorite part, there are 2 guidance documents issued by the FDA. The FDA could not be more concerned, cautious, and antagonistic toward compounding. They haven't liked it since they were incepted underneath the Department of Agriculture. But even they recognize that anticipatory compounding provides value, and recognize that it's their charge given to them by Congress that they allow 503A pharmacies to engage in anticipatory compounding. And the FDA even gives us a so-called safe harbor, which is, so long as the amount of compounded product you produce is no more than what you can anticipate receiving in prescriptions, patient-specific prescriptions for the next 30 days, we consider that squarely within the boundaries of what Congress anticipated, which is anticipatory compounding. Finally, if I were you, I would ask me the question, but it talks about an order, shared order processing. What's the definition of an order? The definition of an order is also found in R423-110, but it refers us to the statute, which is 32-1901. And the definition of an order in 32-1901 doesn't say patient-specific prescription order, but rather an order. And I believe that the legislature intended an order to be what Webster's dictionary would be, which is I have either a patient-specific order or I anticipate an order, and therefore shared order processing can include anticipatory compounding because that's permitted in Section 503A of the Food, Drug, and Cosmetic Act. With that, one more thing. Even though I wasn't in the room yesterday, I did watch the whole meeting. There were 2 compounding pharmacies that appeared before you yesterday that describe the fact that they're engaged in shared services. Now, in fairness, you didn't discuss what were those shared services and did they include anticipatory compounding? That wasn't discussed, but you didn't raise the question. They were items 13A and 25A, just for sake of argument. It is not something that has traditionally offended this board that pharmacies engage in shared services and other compounding functions. What you've been concerned about in recent years, though, has been anticipatory compounding. And I believe it fits squarely here, or you have the ability and to waive that restriction if you still believe it's there. And with that, I'll answer questions. I apologize. I got a dry mouth, but so I feel like the microphone's picking up the smacking, and I apologize.
I have a question. Do you know of anywhere that this is currently taking place in any state?
I can't reveal attorney-client privileged information. But what I can tell you is it was ubiquitous years ago when I worked. And it was very, very useful. Before 2013, there were no 503Bs, and it was ubiquitous throughout the state. It was common, and there is a document somewhere at one of my old employers that's signed by Hal Wan that said he approved that process. That did not go through the formal deviation process, but the board was notified and the executive director signed off on it. And my guess is that other pharmacies have that piece of paper somewhere and haven't come to you to say, does this piece of paper still hold? Because they're afraid of the answer. Our client said, I don't want to be one of those people. I want to be upfront, I want to disclose, and I want them to be comfortable with what I'm doing.
And my other question was, last time you described the business model a little more, and I thought I remembered something about being in the same facility. Can you remind me how that was working?
If I said that, it may have been a misstatement. These are different buildings, different parts, and Brett can talk a little bit about his operations if that's helpful, if you want a picture.
I'd be curious. Yeah.
Sure. I acquired the business in March of this year. There were 2 existing pharmacies, Red Mountain Compounding Pharmacy in Mesa, Four Corners Compounding Pharmacy in Queen Creek. Each respectively has compounding lab footprints. Red Mountain currently has sterile and non-sterile. Four Corners has non-sterile only. As Mark's alluded to with additional facilities, we are bringing on a closed-door pharmacy location just recently inspected in Chandler to provide additional sterile and centralized, pending obviously this decision, centralized sterile compounding capabilities.
Have you spoken with legislative counsel to determine if they have what their intent of that legislation was, what the legislature's intent was?
Just to reiterate, we're talking about the waiver of a regulation. So the legislature did not write those things that I'm asking be waived. So no, I have not.
I have a question. So anticipatory compounding is allowed under Section 503A of the DQSA, but the amount to anticipatorily compound is based on historical receipt of prescriptions. How would you account for historical receipt of prescriptions that weren't previously able to even be offered at your facility?
It's my understanding that right now, the compounded prescriptions that are received by the other pharmacy are sent to the other one for either delivery to the patient or pickup at the pharmacy that requested it, which absolutely no one's arguing is permissible. The ability to do anticipatory compounding would allow, particularly for medications that have this would be better to get today than a day from now, 2 days from now. Those would be the compounds that would be highest on the list to deal with. And so both pharmacies do know how many prescriptions they get and have gotten. These were existing pharmacies for years before Brett became an owner. And so he has that data. It's just as he considers growing the businesses and thinking about how much infrastructure, what should I have to build in these places? Can I provide more of these services? So right now he's in Mesa, he's in Queen Creek. The new pharmacy that was inspected last week is in Chandler. He'd like to move out to the West Valley, presumably other parts of the city, other parts of the state. And the ability to make sure that access is provided beyond the East Valley and other places, or even within the East Valley, is attractive to the patients who don't want to drop off a prescription at Four Corners and be told it's going to be a day or two before I can get it to you. I don't do that here.
How much would this speed up the delivery of medication?
Presumably it would be contemporaneous. So for things that can be compounded and anticipated, the patient could get it the same day.
Mr. Boson, so I do understand that shared services is permissible, and according to the document provided by you, it says, quote, returning the fill order to the requesting pharmacy for delivery to the patient. That further clarified to me that shared services pertain to individual specific patient, not for multiple patients.
Yeah, and I anticipated that objection, and I looked at that more carefully. I agree that you could interpret it either way, but when you look at the definition of orders and when you look at the definition of shared services, it didn't anticipate that the shared service pharmacy had to do all 4 functions, which includes applying a patient-specific label. And traditionally, as I said years ago, the board was comfortable that label could mean a sufficient label for what I will colloquially refer to as a stock bottle of a finished prescription that would otherwise be on the shelf in anticipation of a patient coming in at the pharmacy that dispenses it, or at one of the commonly owned pharmacies that would also benefit from it. And so I believe the statute has language that could be interpreted both ways, or the regulation has language that could be interpreted both ways, in fairness. And I understand your concern there, which is why originally I came here saying I want a declaratory judgment. And you're like, no, I don't think so. Inspector Sutcliffe came up and said the board staff disagrees. Here's why. And so I said, well, let's do a variance then. But it wasn't agendized for a variance. I didn't fill out the form. And so we appeared again requesting a variance. And so I think the bottom line is you have the ability to deviate if you believe that this is an experiment or a modernization that is worth trying for all of the reasons that we've laid out in our deviation request, and one that you could shorten to a certain time period and request data on. And candidly, I think that's also part of your mission. This is a small provider, local, not national, conscientious. It would provide you some data on whether or not this is a good idea. Should you approve this today, presumably others would come. But if you said, hey, look, I'd want some data. I want to see if this is a good idea. This is a controlled environment experiment, which the legislature absolutely did anticipate that this board would want pharmacies to experiment with things that might improve care and modernize the practice, you could do that. And I think that's a good opportunity. And I think particularly in 2023, when you've got walkouts and burnout and we're post-COVID and everybody who's working hospital, community, managed care are just exhausted, to require everybody to do everything at the same time under the same roof just because it feels comfortable to me, I don't think moves the ball forward and addresses some of the bigger issues that are affecting this profession, which are squarely within your mission.
Well, in my opinion, the Arizona Administrative Code is very clear and is not ambiguous at all. So to make any modification to your request, I think we should go back to legislature for statutory change.
Would that mean that we could provide a waiver, though, is the question? And I actually would want to refer to our legal counsel to say, ask their opinion. And I don't know if you want to give it out in open session or if you want.
I'd prefer.
Madam Chair, before we go into the executive session, if I can share, and I'm going to apologize now, I may mute while I'm talking in an event I have a coughing spell, but I did put in your board books the guidance documents by the FDA, the 503A language by the FDA and the FDA code, and then a brief summary that I outlined for you. And Mr. Bozen's proposal, I mean, there's a little flaw in that, because when Mr. Bozen practiced prior to 2013 and exercised what he's proposing, 503A and 503B at that time wasn't in play. It was in play later on, and 503A is pretty specific about, as we know, compounded drugs are not FDA approved products. They haven't gone through a proper approval process and so forth, so they're unapproved drugs. But the 503A language is pretty specific as to it has to be released with a patient-specific label on that package. Releasing it before a patient-specific label would be deemed misbranded or adulterated. So though the board can waive and rules and allow this practice, you can't waive FDA guidance or FDA 503A rules that's put forth by the FDA. So, you know, I would definitely encourage, I guess, discussion with legal on this matter, because it's a slippery slope. There is a way of doing it today, just as Mr. Bozen outlined. That pharmacy A can put a label on it and ship it to pharmacy B for dispensation, or patient or ship it to the patient or the provider, or go through the route of 503B, which offers a higher quality product because it's a little more stringent than USP. And just as Mr. Bozen said, you know, we're looking to provide a good quality product to these patients and do service to the Arizona folks. So there's a means to do it today with the process we have in place.
Madam Chair, if I could provide a response. Section 503A, Section 1 does require an individualized patient prescription prior to compounding, but Section 2 provides the exception, which is a licensed pharmacist or licensed physician in limited quantities before the receipt of a valid prescription order for such individual patient. Based upon a history of the licensed pharmacist or physician receiving valid prescription orders for the compounding of the human drug product. So those are not what Dr. Gandhi referenced as a requirement has an exception. That's what anticipatory compounding is. There is no patient-specific label to put on it. And whether it's under the same roof of the pharmacy that compounded it, or under the roof of a pharmacy where the Arizona State Board of Pharmacy knows where it is, that it's labeled with all of that pharmacy's information and can be tracked, doesn't violate the federal rule.
But Mr. Bozen, I thought Section 2 did mention the word individual.
It does. Because it's qualifying. Normally we want an individual, but I'll read it again. Compounding of a drug product is performed, and this is second bullet, by a licensed pharmacist or physician in limited quantities before the receipt of a valid prescription order for such individual patient. So it says the individual patient that we referenced in section 1 above doesn't, it's a player to be named later. We're allowing the pharmacist and the physician before knowledge of that individual person to compound limited quantities based upon the history of the receipt of those prescriptions that they can anticipate.
Another word that caught my attention is limited quantities.
Yes, and that's why I went to the guidance document that the FDA gave us. The FDA said there is no hard and fast rule about what limited quantities is, but if it's a 30-day supply or less, that feels comfortable to us, and that's the December 2016 guidance document from the FDA.
I make a motion for executive session, please.
Dr. Gandhi, did you want to add something before we go into executive session? You started to say something.
I did, and Mr. Bozen referenced number 2 in the 503A section that is compounded by a licensed pharmacist. When you ship it to a pharmacy B, it's not compounded by that pharmacist. So the anticipatory compounding Mr. Bozen is referring to occurs at the compounding site, not off-site.
If I may provide a rebuttal. If that's the standard, that the pharmacist who compounded it has to dispense it, you got a problem. Because that means pharmacist has to work every day and be there every minute of the day to dispense it. That doesn't happen in real life.
I second the motion.
Okay.
I have a motion and a second for executive session for legal. All those in favor? Aye.
Aye.
Any opposed? Back. Okay, welcome back, everybody. Discussion?
So I feel like what maybe we're running into is the concern of it being in regulation with the FDA guidelines. And we definitely can't be in a position, we're not able to be in a position to grant a deviation from that. Now, it may be something that if, you know, that you could take a look at getting some sort of statement maybe from the FDA that says that this particular setup between like the shared services between both locations and allowing the transfer it without better words for saying it to be given at the additional pharmacy would be allowable through their guidelines, then maybe that would be something that we could approve. At
If,
point.
what particular language in the section 503A is concerning? And I'd be happy to seek clarification on that. But I'm concerned that section 503A clearly does not prohibit this because other states don't prohibit this either. Section 503A anticipates anticipatory compounding. And to go back to the issue of the pharmacist who compounds, that does that mean technicians can't compound? I'm concerned that you're reading that too liberally. So if there's a specific section language that says, I believe this prohibits shared services, that would help me help you provide more information.
Because I think that's where it comes down to. It's the shared services component of it that is having a difficult time branching from what Arizona allows with the shared services and then what the 503A allows as far as the labeling requirements between the two pharmacies, not having a specific label for that patient as it's being transferred.
So with all due respect, USP defines some of the labeling requirements on the compounded medications. And the USP wouldn't prohibit this either, in fairness. But it does sound like, in fairness to you, it sounds like you have some concerns about the federal rule and your concern there. And I'd be happy to go to, and I probably won't get this, in fairness. The agencies generally don't provide independent guidance out of their guidance documents that have to go through their own process. So that may be a bridge too far, but it there if there is if there's a particular section or language that's offensive, what I could do is I could provide additional information the same way I would argue if I was in court. I'd bring in additional information. I'd bring in experts that perhaps you trust, maybe former FDA officials, maybe other people. We could do things like that, but I don't know the question to ask them, because the federal rules and the state rules are a list of things that you're not supposed to do. There isn't a list of permissive activities generally in the laws, sometimes in the regulations, but certainly Congress nor this legislature ever does a list of things that are allowable. They simply provide a list of things that you shall not do. And in this case, not only is it not prohibited, but it's expressly anticipated in state law. And just for the record, you have the authority, the exclusive authority over the practice of pharmacy. The FDA has zero jurisdiction over the practice of pharmacy. The FDA's jurisdiction is limited to the products that are within and underneath the roof, but there's no FDA license in any one of our pharmacies unless they're a manufacturer, and even that's not a license, that's a registration, and they have no authority over the practice. And so I can see an FDA attorney saying, that's a question for the states. They regulate the practice of pharmacy. And so long as our rule doesn't prohibit what the states are doing, and candidly, the other issue, and the FDA has been pretty clear about this, they understand their jurisdiction is limited, particularly for pharmacies that don't engage in interstate commerce, because that's exclusively the practice of pharmacy. And unless those finished compounds cross state lines, the FDA has recognized their limitations there. I mean, they're limited to the APIs you use and adulterated products that might have made it into interstate commerce, but their authority is limited. And so I appreciate your concern, and you can probably tell I'm a little frustrated with it, but that's okay. Reasonable people can disagree, and we do that a lot. But this is an issue that comes from my client. He's the one that hired me to do this. But this is an issue pervasive in the pharmacy profession, and I think you'll find in the coming days that access to compounded medications is going to get more and more difficult for patients. And these are the most vulnerable patients in society, going back to your charge. These are the ends of one. These are the people who can't benefit or do not benefit from either because of a drug shortage or because there's just no one making a drug for their particular condition. And you had a case earlier with California that has lost their mind. And we're on record with the California State Board that you have gone too far in regulating things like, you know, the USP or the Food, Drug, and Cosmetic Act says it shall have a USP monograph, among other things. Well, California says, well, this is a USP dietary supplement monograph. But Congress didn't say drug monograph. Congress simply said monograph. Board member Tennille got it just right, where California strayed. And so we can come back, and we will, because I think this is a valuable discussion, and I think it's an investment for the entire state. But I'm not going to be able to call up the FDA's attorney and say, hey, can you give me a letter saying you're okay with this? They would have to put it in a guidance document. But I could come with a legion of other attorneys who are much smarter than me, who I argue with side by side at the USP, who will say the same thing as me. But I don't want to come here unless you want the FDA to give the stamp of approval. And because they're just not going to do that. And candidly, that's your jurisdiction. I don't think you want the FDA getting into practice issues. And compounding is exclusively a practice issue. It's reserved only to pharmacists, pharmacy technicians, and physicians.
Mr. Boesen, can I read a statement and so you can help explain how this is permissible in this 503A guidance? So under section C, when it says when a compounded drug product can be distributed under section 503A, it talks about, compounding either upon receipt of a prescription or anticipatory compounding. And it says, we therefore understand that the compounder can distribute compounded drugs under section 503A only pursuant to such a valid patient-specific prescription, i.e. the compounder receives a valid patient-specific prescription before the compounded drug product leaves the compounding facility.
So I would go back to the exception that Congress gave us. That's neither a statute nor a regulation. And Congress in 2012, 2013, when the DQASA was being written, it was being written very, very quickly. But it was clear that here are the requirements. FDA, we want you to back off the pharmacies. We want you to let them compound. We want you to let them compound under these conditions. I would argue that the word distribute is the wrong word. I'll remind this board that pharmacies are allowed to distribute things without a patient-specific prescription all the time to another pharmacy. When does that happen? Pharmacy to pharmacy transfers. The executive director said when you do that without a patient-specific prescription, it becomes misbranded. I would argue it does not. Otherwise, we'd never be able to distribute a manufactured product that's in its finished container that doesn't have a patient-specific label. And so I think the FDA made a mistake when they wrote the guidance document and used the word distribute instead of dispense. I would argue dispensing is the act of delivering a prescription to a patient that has a patient-specific label. Distribute means something uniquely different in state and federal law. And I would argue that the section 503A was focused on what is permissible to compound with, what is not, who's allowed to do it, pharmacists and physicians, and states. You describe what more other than in the states, it's up to you. Do you want to adopt USP guidelines? Do you want to adopt your own? And states are all over the place right now on that. And so that what you decide today, I would argue, is within your control.
Madam
I'm
Chair,
not
just for point of clarification, Madam Chair, what I stated was a compounded drug is not an FDA approved drug. And you can't distribute an FDA approved drug without an appropriate patient specific label. And if you do, then it's misbranded and adulterated. So it was in the context of an unapproved FDA drug, not a manufactured drug.
So, I mean, we can go down a rabbit hole. We can talk about the pre-1938 drugs if you want.
I don't know that that's necessary, Mark.
I know.
Make a motion.
Unless there's additional discussion.
So given the fact that the Board of Pharmacy of Arizona is not able to deviate from the federal law, I make a motion to deny the request.
Second.
I have a motion and a second. Do I have any further discussion?
We had talked also about withdrawal of the request with asking them to get something from FDA.
If I may, Madam Chair, if it's within order, we'd be willing to withdraw the request. And if we come across information we believe would be compelling to the board that accommodates your concern that this is a violation of federal law, we would represent and we would be careful and make sure that information is compelling so as not to waste your time.
I think that's very
I'm fine
fair.
with that.
I think that's very fair.
Okay.
I withdraw my second.
Mark, does that mean that the pharmacies will not engage in this practice? in
They
the
haven't
future?
engaged in it and they didn't intend to unless there was an approval. So the answer is yes.
Just clarifying, thank you.
But for the record, the pharmacies, and I believe I heard this here and there was some consensus from staff and from you that if the order is compounded, has a patient label, and then moved to the pharmacy for pickup, that's okay, which is a process that is, among others, it just delays the
Yes,
obvious
or delivery to the patient.
Right,
either way.
okay, fair enough.
Yes,
All right,
Thank you.
thank you.
thank you for your time and your
Appreciate it.
thoughtfulness.
Do we need a motion to allow them to withdraw?
Oh, do we need a motion?
No.
Oh, okay.
All right, let's go to lunch. Do we want to do an hour or do we want to do 45 minutes? 45 minutes? We'll come back at 1:30. Thank you. We're good? Okay. All right. For the record, before we were online with our technological difficulties, Ms. Canavong took roll call and all board members are accounted for after lunch. We are on item 25B, complaint number 23-0160. If the parties could please introduce themselves. Mike, please.
Gotcha. I'm sorry. Good afternoon, everyone. Brian Convery. I'm Senior Legal Counsel for CVS Health. I am here today as a representative of CVS 6719.
Matt Green, PIC, CVS 6719.
Ben Castaneda, Compliance Officer, State Board of Pharmacy.
Thank you, Mr. Castaneda. If you could go ahead and start with a summary of the complaint.
Sure. So this complaint 230160 was brought to the board's attention, or was opened by the board from a complaint back in March 2023 when a complainant alleged that CVS had falsified his vaccine administration record. The complainant received his vaccination for a COVID booster back in September 2022, and that was documented on his vaccination card. However, the complainant then noticed that his CVS online profile and his statement from his insurance company showed a different date of March 8th, 2023. He said that he attempted to talk to the pharmacy about it, but was told it's not a big deal. And he also stated that he never received the vaccine information statement from the pharmacy. The PIC responded and stated that there was a miscommunication between the Ironman and their pharmacy operating system. So that you all know, the Ironman is a handheld device that they input the vaccination information on, and then that transmits it to their operating system. That miscommunication resulted in the incorrect date being applied on or being transmitted to the system in his profile. The PIC stated that the information had been corrected after it was escalated to the IT department. CVS records were requested from their RX regulatory department, and their transaction history showed different dates when they tried to correct the record by using a different prescription number and backdating it. However, the final record still shows discrepancies between the patient's vaccination card and CVS's records, including the administration date, the lot number, and the immunizing pharmacist. In regards to the vaccination records themselves, the last piece of information is that the PCP notification was sent on April 1st, 2023, more than 200 days after the vaccination was given. The last piece of information is that when looking at the patient's profile, the allergies and medical conditions have not been updated as of the date that I received the information from CVS, and they were showed as either as blank or no information available, even though CVS had filled prescriptions for the complainant since 2021.
Thank you. Questions, board members for Mr. Castaneda? Mr. Convery, would you like to address the board?
Sure, I'd love to explain what a little context of what Mr. Castaneda explained. Yes, this is what occurred. We do utilize the Ironman system. It's a handheld device, bigger than a phone, smaller than a tablet. We have found, unfortunately, that information that is input into the Ironman device, and that allows our pharmacy staff to actually go out and look at the patient profile and input information while they're giving the vaccination or at the vaccination station. Unfortunately, if our pharmacy staff does not close out the vaccination process on the Ironman, it would time out. And that's what happened here. The system, all the information would be input, but if you don't close it out, it reads that as, hey, all the information was input, the vaccination must not have been given. And it's not deleted, it's put on suspended status, and that is what appears to have happened here. Before moving on with what happened here, since that time, we have put an enhancement into our Ironman system that after 60 minutes, the pharmacist workstation will get an alert advising that, hey, there are vaccinations that remain open. Either close them or don't close them because maybe the patient didn't show up, but they need to do something. So what happened here was the prescription wasn't closed out, was put into a suspended status. At some point, the patient came back and brought that to the pharmacy staff's attention, which would be sometime in March. As Mr. Castaneda stated, and as I'm sure Mr. Green will tell you, they reached out to our IT help desk, and we have a process in place where that prescription can be taken out of suspended status. Unfortunately, it would appear that our IT help desk gave the wrong information, and the prescription was put back into the system with a new prescription number, and that's not what's supposed to happen. And that's why all the dates showed up in March. It showed up as a new prescription number, new dates, new everything. When again, we now have guidance documents, but what should have been done was that it should have been backdated utilizing that same prescription number, and it wasn't. So again, we've enhancement on our Ironman system, but also we now have guidance. We do have online guidance, and the IT help desk has been advised that this is the way it's supposed to be done to pull the prescription out of suspended status to show the proper dates and the proper information.
Madam Chair. So one thing I don't understand is that how come there is such a wide gap in terms of the date of vaccination? I understand that there's technology malfunction, but why the date of the vaccination there's such a
The
wide
date
gap?
in March would correspond to when the patient came back and realized something was wrong and came back and said, hey, my vaccination card shows this.
Okay.
So that's when someone, either the pharmacy staff reached out to the help desk, but that's when in March is when they looked back at it and put the new prescription number into the system and tried to fix it.
My subsequent question is that the handheld device that you're talking about, is it being used at other CVS locations or just this?
Oh, no, it's used nationwide.
And has this problem happened at other locations?
We have noticed that there have been instances in more than Arizona, outside of Arizona, where the Ironman, the system or the prescription has not been closed out, which is why this enhancement was put into place.
Is that the only vaccine record, or is there still a paper record so that you could go back and actually validate that that's the date that it was given and all the correct information?
We were able to validate it because the prescription was never deleted. So the prescription still lived in our system.
So what was missing from it to transmit to the vaccine information system correctly?
You can answer. No, you can tell me.
So in RX Connect, which is the system, it just said missed appointment, when in reality he had come to the appointment and gotten the shot. So either I forgot to hit submit on the Ironman, or I hit submit and it didn't communicate properly with the server, or something like that, a technical glitch essentially.
So none of that was done again until March.
But did you have the appropriate records of when everything was given in the system? Or is that all tied to the Ironman?
So the Ironman has RX Connect sort of on it, and it will communicate with our computers. He has his CDC vaccination record card, which has the correct lot number, correct date of administration. It's just a record in RX Connect. It says missed appointment, and then we called, all of us called on this many, many times. Because it said missed appointment and it was after the date, they had no way of just deleting that off of it. I imagine they told the engineers this has to be a permanent record, and they delivered a permanent record. So there's no way to delete it off there. The best we could do is my boss finally contacted this IT department, which is a special part of the help desk, which is not even on the phone tree. That he just knew about, but we didn't. They were able to change it to status null, which isn't really what the patient wants. He wants it to just say that he got it on the day he got it. So the missed appointment now is status null, and then we were directed to put in a new prescription, new vaccine. And there's no way to backdate it because we're not allowed to put in prescriptions for the past. The RX Connect won't let us do that. I'm sure to prevent fraud. So if you go into that prescription, it will show the correct date, date vaccine administered to patient, but it's just the date prescription when it was written was much further.
Where's the vaccine administration record within your records, I guess? Where is that housed? That the patient signs off on and where the pharmacist does the clinical review of it? Whereas, is that housed in the Ironman? Your
The
Arc
Iron Man is
Connect?
just a remote,
Mhm.
it's just a remote data entry device.
So I can pull that shot up in RX Connect, just like a prescription, and I can do DOR verification on it. If I go into his profile, I can pull up like a special section for all his vaccines, and I can see what CVS can like shows that he's gotten for. I think it goes back further than 3 years for vaccines.
Has there been any look back and auditing been done on the process now that you are aware that there was an issue?
I'm not aware. I can't, I'm gonna say I'm not aware of it, but I just don't know the answer to that question.
So when you say like the vaccine was on suspended status, right, for a long time, what that means? Like, it's mean not given to a patient?
Well, so as Mr. Green said, it's almost as if there was a missed appointment. So the information is all input, and then if the patient
Okay.
doesn't show up, it's not closed out. It's not deleted, but
Okay.
it's put on hold or a suspended status in our
So,
system.
so in this case, how the patient was able to see it in his or her profile? Like,
Because they have their own version of their profile on CVS.com. So he can, so CVS like communicates that to you in an email, and you pull up your account and you can see what vaccines you've gotten. So what it was showing him was, hey, you missed your appointment this day. And there was no way for him to say like, hey, I actually did get it, because that we have to do on our end. So the whole process is designed to be, largely happen
Okay.
automatically to take workload off of the pharmacist that's giving the shots so he can be more productive. But in this case, there seems to have been a glitch, or maybe it was communicated, or maybe I forgot to hit submit.
Okay. Thank you.
Board, if I may, I just want to direct your attention to page 2405 in the book, just so you can see visually what they're referring to when it shows missed appointment. And then on page 2406, the subsequent prescription that was billed.
So,
So Dr. Green, can you, the database today that CVS maintains, is it accurate? Because from what Dr. Castaneda presented, and from what I'm hearing, it does not match the vaccine administration record card. Is the database accurate today? Do they match?
Okay, so the prescription that was we're directed to put back in there, it has correct vaccine NDC and date vaccine administered to patient. But again, it's post dated. And then the only thing is the lot number, because we didn't have the lot number. So the lot number on that vaccine record is different from the lot number he actually got, which is on his CDC vaccine record card.
So that goes back to my original question. When you give a vaccine, there should be a vaccine administration record. So something that some pharmacies use an electronic version, some pharmacies use a paper version, that the patient indicates what vaccine they want to get, any type of prior, health conditions that might be adverse to being able to administer that to the patient. Then it contains the information about the lot number, where it was administered to the patient. And there's some sort of sign off by the patient that they acknowledge that their information is correct and this is the correct vaccine. And then the administering pharmacist and or technician also sign off on it. Where does that record live? Was that lost as a part of this Ironman? Because it's all electronic. Like, I'm trying to understand what actually happened to the administration record. Was it completely lost as a part of this process because it's all electronic? Because the patient should have had to sign off on it somehow, somewhere, and so should have the pharmacist.
So he made his appointment online. So he did his consent form, he answered his questions, and he consented for the vaccine. I did my bit, and so if the process on the Ironman had submitted properly, it would have shown like, hey, this is what you got, this was your lot number, this was your date. But it's just because it didn't go through correctly that, yeah. So I believe, if memory serves, the last time I tried to view in that original missed appointment, because it's now status null, it won't let me view anything. So I have on RX Connect, I have the new record of the shot with the wrong lot number, but it does show the correct date.
But there's no paper records of the vaccine anywhere. They're all electronic at this point.
Exactly, yeah,
Okay.
it's designed to be that. So if they want to walk in, we'll still do a paper vaccine record for them. But yeah, if they make an appointment, it's all electronic.
So, but the patient has the right lot number, right? On his card.
On his card, but that
Yeah,
was not what
card,
was
yeah.
transmitted to ASUS, right? Because that's not what was in your electronic file that was then
Correct.
transmitted to ASUS.
Correct.
And your database today does not contain the correct information either.
So what does the ASUS record show? The ASUS record shows the new modified date with the wrong lot number,
So I
the
I
March
haven't-
date roughly.
I don't know if the ASUS record will show the status null one, but it will show the one we were directed to put in with the wrong lot number on it.
And the wrong date.
So date administered to patient should be correct. It's
Okay.
just date the vaccine was typed that's incorrect.
No, I mean, I feel like it's a technical issue from the beginning. I mean, so.
But
nobody
if I
can-
could just again really quickly, please.
Yeah,
The vaccine administration record that CVS provided to me is on page 2412 on the board book. And it appears to still have the administration date stating 9/12, just for your own reference.
which is the right date?
No, his vaccination card says 9/11. That is on page 2400.
2400. So if there is no glitch in the system, I mean, it would not, none of this would be happen, right? I believe we're assuming just glitch happened in the system
If-
caused this issue.
If it had been closed out at the time.
On the
of-
time.
At the time of the vaccination, correct,
Correct.
everything would have been correct and everything would have been shown. the
But
correct-
nobody can confirm if the pharmacist forgot to submit or it just, he submitted, but the system glitched. I mean, nobody can confirm. Anybody can correct me here? Yeah.
So you mentioned that they get a message if it's been more than 60 minutes.
It was set at 60 minutes initially when we first rolled out this enhancement. I believe it's
So
still at
what
60.
happens if they don't go back and do that? Is there some sort of other like triage that happens at that point, or does it just eventually fall off?
So I haven't had that happen so far, so I don't know.
I believe it keeps alerting. I'm not sure how long it will keep alerting. I believe it would go out another hour after that, but
Does it ever alert outside of the pharmacy? Like to a district leader or your support office, anything like that?
I don't know the answer to that question. I believe it's no, but I can't be 100% sure.
Because my thought is, okay, pharmacies get busy and we've all worked in those environments. Looks like this happened right in the height of when the new RSV vaccine came out, which was in the middle of flu season and people were being encouraged to get vaccine boosters. So I get it, stuff happens. Sounds like, I know you guys have probably administered millions of vaccines using this process very safely. Sounds like you guys have put in some system stops. I just want to understand, like, say this is a really overwhelmed pharmacy for whatever reason, what is the process to make sure that it does get effectively closed out so that the records are correct? Because it seems like otherwise we're going to be losing patient information because there isn't necessarily a paper trail. That was my concern there.
Correct. And the block I see, and I can only speak to what I'm seeing from my IT people. It is an alert that pops up in the middle of RX Connect. It's not in the queue. It is a large alert that blocks everything else that the pharmacist is looking at, or effectively blocks. It's in the middle of the screen that effectively blocks them. And I believe there has to be an affirmative action taken to get rid of that alert.
Basically, it comes right to the top of my pharmacist queue and it'll show as like, hey, this is past due, you have to do this. So
Can you go around it?
I suppose you could if you wanted to just continuously ignore it for, but then it would just always still be there in the top of your queue. And I guess that would be my job as the pharmacist manager to say like, for example, like, oh, okay, the floater didn't do this, so I have to follow up with this patient and like.
I have a question about the vaccine administration record.
Yeah,
I-
I'm sorry, also I'm sorry, I didn't mean to cut you off, and I just asked him that question. The alert also is a different color on the bar. It shows up as a different color to the pharmacist, which it's a red, which is an alert color.
So I can see how there might have been a malfunction with the machine and it goes into suspended status and you guys type it 6 months later or whatever. But the actual vaccine card shows the administration date of 9/11, but the vaccine administration record where the patient would have signed all of his disclosures shows 9/12. Was that vaccine administration record created like after the fact too, or how would those differentiate from each other?
If you know, the only thing I can think of, because I don't know what Mr. Castaneda is looking at. Unfortunately, he's got page numbers from the board book. I see different multiple submissions that have given to the board, so I'm not exactly sure what
It's a
he's.
picture of the immunization card that was given to the patient.
Okay.
Is what we're looking at.
And then the vaccine administration record starts on page 2412, but the vaccine administration date on this vaccine administration record is on page 2414, and it shows the administration date as 9/12. So a day after that was written on the card, and that the administering pharmacist was William Faber.
That's I thought that's what, so that's from the shot that was, so like, that was IT's solution. So what had finally happened was my boss got on the phone with help desk and the IT desk, and then like called in and told my partner like, okay, put in the record for such and such information, so that like all of us were just trying to satisfy the patient. So I guess they must have put in the wrong date.
Yeah, that's that. I think that the 9/12 was a date that was put in later when they tried to recreate it with the wrong prescription number.
Yeah, that was my question. Thank you.
So if the patient hadn't complained, there would be no record, correct? It would have completely been lost. There'd be no record.
It would have remained in its suspended status, but again, we wouldn't have been able to recreate everything because, as Ms. Walmsley pointed out, the lot numbers we couldn't find the lot number. We couldn't recreate that.
I'm just concerned about tracing and tracking, dealing with some kind of recall or any kind of event that happened with the patient.
Which is why we try to nip it in the bud before we get to that point.
So
Are you aware of any incidents that have occurred since you put in the fix?
I'm
The
not
system
aware of
fix.
So can you explain, you mentioned a suspended status. So if the process had been used with the Ironman, wouldn't the lot number have been put into Ironman and included in that suspended status? Why did the lot number not transmit once it was finally released?
So it probably did, but then once IT went in and changed that one to null, now I can no longer view that. So I don't know if it was the right lot number or not anymore. It's.
Yeah, unfortunately, the fix that they tried to do was wrong also. And that's, that's the second unfortunate thing that occurred here. The fix that IT tried to do was the incorrect fix, which is why that we've now have a guidance in place that tells them how to actually do this fix if this should happen.
It sounds to me that there's absolutely nothing Matthew Green could have done differently in this situation to have prevented or corrected this error.
I agree.
Right.
Perhaps the only thing would be is if he didn't follow through, and that's the reason why it went to the suspended status, but I don't think we know that at this point.
Yeah, he said he could have pushed the button and it could have not communicated.
Right, or he could have gotten busy and not finished it, and it just kind of got lost in the system.
Isn't there a requirement that the provider get it within 24 hours? And that also part of the,
I would assume you use some sort of an electronic process after the fact,
We
but
know
that's
that
also
was done.
probably tied to the Ironman records. Yes,
so
Yes.
it wasn't being communicated to the provider either.
which
Because it all hinged on like that submit going
Communication.
through and, yep.
The system read it as a missed appointment.
and there's also a requirement that it gets put into ACES, which is why I ask about ACES. But again, that's probably going to be tied to all of their electronic record keeping when that was wrong because they lost their original record. All of that got messed up too.
Board members. There is a document on page 2422 that does show the PCV notification, but it was not sent until April 1st, 2023.
Which is when the system was corrected,
Yes,
probably with also the incorrect information.
correct.
Yeah, I believe all what they try to do satisfy patients so the patient will have the right date, and they try to rush everything without thinking like what's the lot number, what's in I mean. So because they could have called a patient, say what's the lot number on your card, assuming the card has a lot number, but the IT would not know that because they're just focusing on fixing the IT issue than writing the right information without communicating with any pharmacist. No, none of the leaders, pharmacy leaders or PIC. So the way I look, I mean, unfortunately that happens in like IT world, you know what I mean? Like I don't see this could have prevented by like PIC or any pharmacist or technician. So, and the way I hear from CVS team that they did their part to try to fix the system, I would have a concern if that happened again in the future, definitely, because we all know now, like they are aware of the issue. So I'll be fine with like, me personally, I'll be fine with dismiss the case.
I was kind of thinking maybe a non-disciplinary letter of concern to the permit holder. I agree. I'm comfortable with the steps that they've taken, and I appreciate the fact that they've taken systematic steps to correct it. But I would like to have something on record in the event that you're right, it comes back or something like that. So I was kind of thinking a non-disciplinary letter of concern.
I agree, but I will remove the pharmacist name, the PIC name.
I agree with you.
Okay.
Is that your motion?
Yeah, this is my motion.
Do I have a second?
I'll second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Green, for being here with us today. I think you're still with us for the next one, Mr. Convery.
I am.
Go ahead. But use your mic, Frank.
Once it leaves Iron Man and goes into the main system, I assume there's a backup for all data. Is that correct? That say your system went down or one computer, your main computer system went down, that there'd be a backup for
There
that
is.
data.
Yeah, no, the data lives somewhere, but again, in this situation, the system read it as a missed appointment, which
Thank
was
you.
the problem.
All right, thank you. We'll move on to 25C, complaint number 23-0199. I see Mr. Patel is joining us, and we have somebody else joining from CVS. If the new additions can introduce themselves to the table, from the table.
Nolan Bauer. Compliance Officer Chirag Patel.
Mr. Patel, if you could please give us a summary of the complaint.
Sure. This was a complaint number 23-0199. This is a complaint opened up by the board staff after receiving notification from the permit holder that a pharmacy clerk who was not licensed with the pharmacy board was terminated by the permit holder after admitting to theft of several controlled substance drugs from the will call bins. The theft was discovered on February 20th, 2023, and there's an error in the summary, but the permit holder notified the board office not until April 3rd, which is about a little over a month of the initial loss. And they also filled out the DEA 106 on April 3rd, 2023. The permit holder discovered the employee theft when a prescription bag in the will call bin was found empty without medication. During the investigation by the permit holder, the pharmacy clerk admitted to additional theft of several other controlled substance medications. There's a complete list in the report. So what we have here is two possible items to discuss. One is a failure to maintain effective controls against diversion of controlled substances, and that applies to the permit holder and the PIC. And then there's also a untimely reporting of loss of controlled substances to the Board of Pharmacy and filling out a DEA 106 on the PIC.
Thank you, Mr. Patel. Mr. Comfrey, would you like to make a statement? Please use your mic.
Briefly, and I know I have been in front of this board multiple times in the past on late filings of 106s. I will point out, though, that this dates back to February. I think I've been here since then, and I have brought this board's concerns to my drug loss team. They have put improvements into their process and into their system this year. Again, this is February into March of this year. So they have put process improvements into their system. They tell me that they are much better on meeting deadlines. I would hope that board staff would say that at the current time that they are not seeing late 106s, but this would fall back in February before we put enhancements in. And I believe the enhancements include more accountability for our field leaders, because that's where the drug loss processing goes through. But again, I think we've put processes into place, and I believe those processes are working.
Can I ask a question really quick? It looks like that the Arizona Board of Pharmacy was faxed on 2/20,
I believe
23 about the loss.
my records show the IN was filed on the 24th of February. It was the 106 that was not filed until April.
Sorry, let me clarify that. So there was no notification on 2/20. There's a typographical error in the summary. There was a notification on February 28th, but that was later removed on March 1st, where they faxed a notification to the Board of Pharmacy stating that they want us to disregard the initial notification that was sent on February 28th. So basically, there was no notification until April 3rd.
It looks to me like we have a copy of an actual fax with the fax receipt to the Arizona Board on February 20th. Page 2462.
Let me take a look. I'm sorry, which page did you say?
2462.
I stand corrected. Yes, that is February 20th.
So if this 2/20th or 28th, it is. So if that's the date is true, which is true, I mean, they have confirmation, so they'll be in compliant or still?
They would be partially compliant. They notified the Board of Pharmacy, but I don't see a DEA 106 until April 3rd.
So, okay, I have a question now to CVS team. So what is the process to submit, when and how you submit 106? Like,
Please use your mic.
Do this every time. When the drug loss team is alerted to the loss, the drug loss team, jumps onto the case, for lack of a better way of putting it. The board gets the IN. As I've said, I've been here before with regards to the 106, which needs to be filed shortly thereafter. In this case, the process is the drug loss team now, as we approach the deadline, the field leaders, the district leaders, and the regional director are getting automated emails, which we did not have in place before, telling them that the deadline is coming up for a 106, starting a number of days in advance and then daily until then. And then on a weekly basis, our district leaders and our regional directors are also getting a report of any late 106 is nationwide. So not just within Arizona, but every state are getting a report of that on a weekly basis.
Yeah, because 106 is the responsibility for PIC or for the permit holder. I mean, like, right? Not only PIC.
PIC only.
PIC only? Okay. So, but CVS, obviously, they took the responsibility, but I don't know if they can do that from the PIC. And it's not the first time we see a PIC in front of the board from CVS for the same reason. And it's really like taking a long time. I don't know how much investigation sometimes, they need to, until they make decision, because the rule says when you determine, right? I mean, as long as they're investigating, they don't need to report. Is that right?
Yeah, so we've
Yeah.
had a number of discussions, just
Yeah.
since you and
Same
Jeff are
thing,
both,
yeah.
both new board members, around both who can submit submit a 106, and then what does the 10-day reporting really mean? Because a lot of times, if you've been involved with theft cases before, oftentimes it takes a lot longer than 10 days, which is what our rule says, to actually thoroughly investigate and be able to submit a true 106. You might know that you have a loss, but you may not know the extent of the loss, nor who might be the individual responsible. Be that as it may, the rule still says 10 days, which is the reason, really, quite frankly, why we're here.
Is this one that would, in the rule rewrite, was it changed to 15 if that's accepted, not currently?
I don't remember exactly where we were at.
Typically, we took out promptly or immediately and put a day.
I thought we were trying to align it with the DEA's requirement, which I think is 30 days for some reason.
Okay.
That
Well,
is,
it's
that
not
is
in
a
place.
thought process, Madam Chair. We're trying to align.
So that way it's not different in Arizona rule versus federal law.
And it's not in place currently anyway. I just was curious. I have a question about how such a large volume was taken out of the pharmacy by a clerk. And what have you done to help prevent that in the future?
So with this particular clerk, he did it in a very, very short amount of time. I didn't even know about it until the day AP was there. They had me do some counts on Abilify, Xanax, and testosterone. Didn't tell me why. Maybe count it for a week. And then all of a sudden they're there, and the Adderall got stolen while AP was there, actually. And then I was notified of what's going on. It was a very short amount of time. He admitted in one of my texts that he had pills. He showed them in the glove box. And that's when she notified the store manager, but they kept me out of the loop because they wanted to investigate to make sure I wasn't part of it. My pharmacists weren't part of it. And then the investigation happened very, very quickly with getting in there to interview him. They interviewed me first, and I didn't know what the heck was going on. And then they interviewed Junior, was the associate. They interviewed Junior, and he admitted to stealing it. But it seemed like he would have been it was had it been within a month, because we have cycle counts, and our cycle counts were not raw. So he was either taking them very quickly when he's putting drugs away, because that's one of the clerk responsibilities that they're allowed to do. So he's putting drugs away. And then that would be about the only time he had contact with it outside of ringing people up.
Who asked you to do the cycle count?
The cycle counts were asked by AP
What's that?
as a protection.
Oh, thank you.
Yeah.
And did they
and-
see it? Like, what prompted them? Just curious.
Whenever the other, actually another clerk, notified the store manager that Junior had said something, he reported it to AP, and then AP said, don't tell anybody, because they wanted to investigate all the pharmacists as well. I will say the Adderall was actually taken the day AP was there, and that one was pocketed. We saw it on the camera. You didn't see the actual vial going in his pocket, but you can see him stick something in his pocket, and he left out of the pharmacy with that. He took that out of will call. He peeled the bottom of the bag off and took that out.
How often do you guys do cycle count?
Cycle counts are done every day, but drugs are at least once a month. If you dispense them more frequently, then you have to do more cycle counts. So say Xanax is one of the big ones that we cycle count all the time, because you're using so much of it that they make you count it. It pops up into the queue, and the techs have to clear that queue every day. So they're doing cycle counts. And then if there's a discrepancy, we have to take care of that every Tuesday. Investigated, whatnot.
But he was taking it out of the finished work. So it wouldn't, so it would not have shown up necessarily on your cycle counts,
It might
because
not show up.
because your physical inventory was correct.
Correct.
He just, either the patient was getting an empty bottle or not as many as you just
After
mentioned.
Junior was gone, the cycle counts popped up and our counts started being, our counts were wrong whenever the AP had me testing it. But before that, they were off 1 or 2 tablets here or there once in a while.
How long was he an employee in your pharmacy?
Around 6 months. He was front store mostly, but he came back to pharmacy for about the last 3 months of his tenure with us. He went to Walgreens afterwards, if that helps.
Actually, no, not for me.
He got fired from there too, or left there too.
Mr. Bauer,
Yes, sir.
I have a question. So the Adderall is what prompted this deeper dive.
I figured it was.
So the 106 lists testosterone, alprazolam, other drugs. So and that his MO, if you will, was taking from the will call. So if these patients aren't getting their alprazolam and testosterone for 6 months, where is that getting escalated and what happened?
Like I said, I don't know how long he was actually stealing. He's only in the pharmacy for about 3 months. He worked for CVS for about 6. He's only in the pharmacy for about 3. I wasn't getting complaints about drugs being stolen or like shorted or anything. So I am honestly, I don't know what's going on. He was taking stuff from will call. We know that the Adderall for sure was will call. The patient came to pick it up. That's how we noticed it. And it was filled that morning by me. So we went through every single bin in our will call. There was not to be found. And I knew AP was there. So I went and talked to him and he pulled up cameras and that's when we saw him. So I had to redo the prescription and I filed the IN right then because I knew there was a loss. So I filed the IN right there and AP saw him on camera going down by that bin and then putting something in his pocket. And he went on a bathroom break right after that.
So was there any further investigation looking back at cameras for the testosterone and the alprazolam, or?
The cameras are only for so long. And if you're on will call, they're in and out all the time. So I don't know what they did with AP side, but it's going to be tough to find him because he's working 10-hour shifts. So I'm not sure.
So so the DA require 10 days or 14 days or 15 days to submit the
10 days.
Our rules require 10 days.
10 days to report to state board, right? That to our board.
Yes.
But to the DA, I believe they changed the rules to 15 or as I'm aware of, maybe they changed the rules to 15 days, right? Anybody knows from the DA? I could be wrong.
Thought it was 14, but I
14 or
could be
15.
wrong.
Yeah. So, but regardless, they were still right, like not compliant with the DA for 106.
I'd like to correct something again, Ms.
Yeah.
Davis.
Yeah.
You had mentioned that they had notified on February 20th, which they did. But then there was a fax on March 1st that stated specifically to disregard that notice on February 20th.
Is that in our packet? I didn't see that one.
That's not in the packet. That was in the iGov, which I had neglected to add that to it. I just wanted to clarify that. And sorry, Mr. Nassif, what was your question again?
So about so you just answered. You said they sent another fax to discard the
original
which is-
notification.
So they basically took it away, like they withdrew the fax. So.
Madam Chair, just to clarify, these alprazolam looks like almost 400 tablets of alprazolam were stolen from this pharmacy from the will call, not directly from the safe. So over almost 2 months period, you did not receive any phone call from patients complaining to you that they're short 5 pills, 10 pills, or whatever.
We did not, and it's not in the safe. None of the Xanax will be in a safe. It's going to be on the shelf.
Okay.
The Adderall absolutely in the safe, but the Xanax will not be in a safe.
But I believe the question is not stolen from the shelf, from the will call, right? So have you done like any report how many alprazolam you've dispensed within the those 2
Yes.
months
AP,
or 3 months?
we were
Yeah.
checking our inventories.
Yeah.
That he had us doing it for about a
But-
week after everything took place too, to keep track of what's going on. AP is the one that came up with the numbers. All we did was count them. And that's when the discrepancies started being shown, because from our cycle count that we had the month before all this happened was on, or at least within the amount that's allotted, and then it got bad afterwards.
So there's stealing narcotic not only from the will call, also from the shelf.
It's very
right?
possible.
Yeah.
We never caught it. We never saw him doing it. Never caught him doing it.
Okay, but
Okay.
then going back to my previous question, you said the cycle count is only done for fast movers, and alprazolam, you stated that is one of the fast moving medications.
Cycle counts are done for all of them.
Yeah.
It's done at least monthly. And usually if stuff's moving fast, it gets counted more frequently.
Which
Yes.
is daily, as I recall. That's what you
Not,
said.
not daily, more
What he
frequently.
said was
Freq-
they do cycle counts on a daily basis.
Yeah, we do cycle counts every day, but it's not every drug. Different drugs fall in there every
So
day.
Loss prevention will ask them to do cycle counts on a specific drug on a daily basis.
Okay,
Is what-
but then alprazolam being a fast mover in your store,
It's probably going to be done like once every 2 to 3 weeks instead of once a month, or maybe even weekly. Just depends.
so let's say even weekly, you could have caught that there's almost 400 tablets of.
Not if he took it all the
Exactly.
last day or the day before. We wouldn't have gotten the cycle count yet.
And not probably if he was taking it out of the finished product.
Yeah, if he was doing that, we wouldn't have caught it at all. But we did not receive any calls with people getting shorted. Then again, we're pretty strict on our controls too. So
Mr. Bauer, who's your normal compliance officer?
I honestly don't.
The store would need to make the change.
Yeah, I see a permit holder issue here and not a PIC issue.
I agree with that.
Yeah.
Madam Chair, with
Are we having issues again, IT issues?
Madam Chair, was there a question a few minutes ago about whether this is a repeat issue? Had this been an issue before? Could you?
No,
There was not.
no, we know this is a rape issue.
We know that. I just made this statement. I said that this is not the first time.
There was no question though.
There's no question.
Okay, thank you.
I think I'm ready to make a motion if we're.
I was just gonna say, maybe that's something the board needs to discuss in a future agenda as well.
I think I'd
I
like.
mean,
to-
we're looking at the rules right now. I don't know that it requires a whole separate discussion. But
I'd like to make a motion to offer a consent agreement to be signed within 30 days to resolve this complaint against the permit holder Y4945 to include a civil penalty of $1,000 per violation for a total of $3,000 to be paid within 90 days.
I second that.
any discussion?
What are the three
Yeah,
violations?
I would ask the same question.
They're listed on Mr. Patel's report.
There's only one for the permit holder as potential violations.
Security requirements, records and order forms, and definition of unethical conduct and unprofessional conduct for permittees.
There's one for the permit holder and 2 for the pharmacist in charge.
I think I would be in favor of supporting that for the permit holder and just one. And I wouldn't find that the pick was in a violation.
Okay.
I'll make that modification to just one civil penalty of $1,000 per the one violation.
I'll modify my second.
Can we clarify if it's disciplinary or non-disciplinary?
Civil penalty would be disciplinary. I don't think this can be non-disciplinary.
Okay.
Is that true?
It could be.
It could be.
non-disciplinary, but you have found, violations. So you'd want to determine the, severity, and did you have discretion?
What about instead of a consent agreement, a non-disciplinary letter of concern? That if the Arizona law is that the pharmacist in charge is to report to a DEA 106 within 10 days, the letter of concern being to CVS to give their pharmacist in charge that authority or the power back to them.
I'm in favor of the penalty just because it's a repeat violation.
Mhm.
But I do think that that statement should be included.
Although I do think that there is a fair point that this was from a while ago. They say they've put additional measures in place. They've been before us since that last time. Since when this occurred. I don't know.
There's still a quantity. When it came to us, there still was a quantity of things that came to us. So I would say like, because of the multiples,
I'm more in favor of a non-disciplinary letter of concern for 32-1901.01.
I would agree with that. Letter of concern to the permit holder.
I just don't know how so much Xanax and testosterone can be missing without any sort of notification or alert. That's where I'm struggling, I think there should be some sort of penalty.
I agree with you.
Agree.
So we have a motion on the floor and it has been seconded for a consent agreement. They would have 30 days to decide whether to sign for a civil penalty of $1,000 for violating 32-1901.0123. Still don't have any information if that's supposed to be disciplinary or non-disciplinary. A consent agreement suggests it's disciplinary.
Mhm.
And I hear other options perhaps, but you do have that on the floor and we would have to take a vote on that or withdraw the first and the second.
Would we have consensus if it was non-disciplinary?
I can go either way.
I think it should be disciplined due to the mass.
Let's take the vote is where my head is. Let's take the vote and see where it comes and then we can take a shot at an alternative motion if it doesn't pass.
So this is Mr. Anderson. Is it disciplinary or non-disciplinary?
Disciplinary.
So disciplinary, $1,000 civil penalty, consent agreement. And then we'll do a roll call.
And the motion did include to be paid within 90 days.
Yeah.
Ms. Walmsley,
No.
Ms. Davis,
Nay.
I'm sorry.
Nay, sir.
Thank you. Ms. Lehan, recused. Ms. Snare,
Aye.
Mr. Dang,
Aye.
Mr. Nassif,
Nay.
Mr. Anderson,
Aye.
Mr. Thorwald.
Aye.
Pass 4-3, motion passes.
All right. Do we need to take a motion with regards to Mr. Bauer, since we did not address him? I think we're probably all of the opinion for dismissal there.
I'll make a motion to dismiss any action against the pig.
Second.
Motion and second. All those in favor?
Aye.
Aye.
Any opposed? Thank you both for your time today.
Thank you.
Thank you, Mr. Patel. 25D complaint number 23-0233, Christina Montiel. Is Miss Montiel present?
It doesn't
I
appear
don't see
she's
her.
in.
I don't see her online, Madam Chair.
Okay. My gut is she's not going to, was not going to show anyway. So I guess let's go ahead and proceed. Miss Mitchell, thanks for joining us. If you could give us a brief summary here.
Christina Montiel was licensed as a pharmacy technician trainee on August 30th, 2021. Her license will expire on August 31st, 2024. Her last known place of employment
was Integrity RX Specialty Pharmacy. On April 25th, 2023, Ms. Montiel reported that she'd been charged with DUI. That day, staff requested that Ms. Montiel provide copies of the arresting agency records, copies of court documents to date, and her current place of employment. Ms. Montiel responded with a copy of a final release order and order regarding counsel and her current place of employment. On June 28th, 2023, staff reached out to Ms. Montiel by email requesting an update on her case and following up on the request for copies of the arresting agency records. On July 11th, 2023, staff sent Ms. Montiel a subpoena requiring her to submit a detailed description of the events that led to her charges, the status of her charges, and any remedial or corrective action she had taken. Staff also required her to provide copies of the report from the arresting agency and records from the adjudicating court. Her response was due on July 25th, 2023. She did not respond. Ms. Montiel was charged with aggravated DUI passenger under 15 and aggravated DUI BAC .08 passenger under 15. According to the Maricopa County Superior Court website, on October 26th, 2023, Ms. Montiel pled guilty to an amended charge of aggravated driving or actual physical control while under the influence of an intoxicating liquor or drugs, a Class 6 undesignated offense. She was placed on supervised probation for 2 years.
I'll make a motion. I'll make a motion to proceed to hearing for revocation.
Second.
A motion and a second.
And is that based upon her failure to respond to the subpoena? And allow us to look more closely at her criminal conviction to see if that would also be grounds.
Yes, I would also say her unregulated ability. Can't spit out the word.
And modify my second.
All those in favor?
Aye.
Any opposed? Hearing none. Thank you, Ms. Mitchell. All right, let's go to 29H. We have a deviation request on behalf of Optum Infusion Services. Who do we have present from Optum?
Well, he's coming back.
You've been waiting so patiently, and then as soon as you leave the room, I call you. It's a test. Hi there, if you could please introduce yourselves.
My name is Lawrence Moore. I'm the Director of Pharmacy at Optum Infusion in Chandler.
And I'm Shauna Vassallo, Director of Nursing at Optum Infusion in Chandler.
Very good. Can you tell us a little bit about the request that you have before us today?
Yes. So today we come before you to request a waiver of the anti-depoting clause to allow us to deliver our prescription medication to our AIS in advance of the patients arriving for the day of the infusion, so that we can expedite the process and facilitate more immediate patient care.
Correct. So the pharmacy would deliver to the AIS for our registered nurses to infuse. The AIS is licensed as an outpatient treatment center through the Arizona Department of Health. And we would store the medication in a secure location and temperature controlled, just as our pharmacy would.
Pharmacy would monitor this and audit to ensure that this occurred before any medication should return back to the pharmacy should the patient not arrive.
And these are medications that are being administered at the facility, right?
By a
Yes.
registered nurse, yes.
Correct. And the AIS is connected to the same building, just not with a door connected to our pharmacy, to the licensed pharmacy space.
When I was looking at this, and I guess I'll just jump off a little bit discussion, I don't know that I think we need a deviation here. I mean, I don't see any reason personally why this can't be done. Yeah.
So you just like send the medication with label, has the patient's information. I don't think they need approval, right? So you mail medication, right? You are like mail order pharmacy or?
No, we're home infusion.
I'm sorry, home
Yeah, so we
infusion. So
can
this is,
mail,
and this is the only facility you mail to or you ship to, right?
So
Or how
we be
you
shipping-
ship the medication?
Yeah, so we two different methods. So we either ship via courier a common
Correct.
courier that will deliver it to the patients and have them sign the delivery ticket.
Okay.
Or it could be shipped via common courier like FedEx
Okay.
or UPS.
And those medication cannot be administered by patient themselves, right? It is
These
normally-
cannot because
Okay.
in this, yeah.
Which I honestly think it's safer to have it delivered to the
Yeah,
facility than
I
to the
agree.
patient
I
where
agree.
it could be misused by, because the patient doesn't know what they're doing.
I agree. I don't think we need to approve anything.
Are
This
there any
is-
controlled substances involved?
No.
So you had mentioned that the permit holder, the pharmacy, would provide initial support for looking at temperature control and excursions. Is there ongoing support from the permit holder to the OTC?
Right. So within the policy, nursing will evaluate the temperature when they arrive to the facility, and then keeping the medication within the controlled space within secured area will then keep the log that of temperatures that the medication is stored at. And pharmacy can audit that as well to ensure that it is maintained within controlled room temperature.
Is that part of the policy where this is periodic,
This is part of the
inspections?
policy for them too.
Correct, yes.
I mean, I don't think we need to vote or to, I mean, I see it, I don't know why they're here, to be honest.
Can we just take no action?
That they want to
be. Yeah. Of course.
Yes, abundance of caution.
Yeah.
Ms. Galvin?
You could vote to take no action as you deem the request for a waiver unnecessary.
Okay,
So I move for no action, right?
because we
Don't-
feel that the
wait,
waiver is
yeah, The
unnecessary.
waiver unnecessary and they're doing,
Is Ms. Montiel present?
It doesn't appear she's in.
I don't see her online, Madam Chair.
Okay. My gut is she's not going to, was not going to show anyway. So I guess let's go ahead and proceed. Ms. Mitchell, thanks for joining us. If you could give us a brief summary here.
Christina Montiel was licensed as a pharmacy technician trainee on August 30th, 2021. Her license will expire on August 31st, 2024. Her last known place of employment was Integrity RX Specialty Pharmacy. On April 25th, 2023, Ms. Montiel reported that she'd been charged with DUI. That day, staff requested that Ms. Montiel provide copies of the arresting agency records, copies of court documents to date, and her current place of employment. Ms. Montiel responded with a copy of a final release order and order regarding counsel and her current place of employment. On June 28th, 2023, staff reached out to Ms. Montiel by email requesting an update on her case and following up on the request for copies of the arresting agency records. On July 11th, 2023, staff sent Ms. Montiel a subpoena requiring her to submit a detailed description of the events that led to her charges, the status of her charges, and any remedial or corrective action she had taken. Staff also required her to provide copies of the report from the arresting agency and records from the adjudicating court. Her response was due on July 25th, 2023. She did not respond. Ms. Montiel was charged with aggravated DUI passenger under 15 and aggravated DUI BAC .08 passenger under 15. According to the Maricopa County Superior Court website on October 26, 2023, Ms. Montiel pled guilty to an amended charge of aggravated driving or actual physical control while under the influence of an intoxicating liquor or drugs, a Class 6 undesignated offense. She was placed on supervised probation for 2 years.
I'll make a motion. I'll make a motion to proceed to hearing for revocation.
Second.
A motion and a second.
And is that based upon her failure to respond to the subpoena? And allow us to look more closely at her criminal conviction to see if that would also be grounds.
Yes, I would also say her unregulated ability. Can't spit out the word.
And modify my second.
All those in favor?
Aye.
Any opposed? Hearing none. Thank you, Ms. Mitchell. All right, let's go to 29H. We have a deviation request on behalf of Optum Infusion Services. Who do we have present from Optum?
Well, he's coming back.
You've been waiting so patiently, and then as soon as you leave the room, I call you. It's a test. Hi there, if you could please introduce yourselves.
My name is Lawrence Moore. I'm the Director of Pharmacy at Optimum Infusion in Chandler.
And I'm Shauna Vassallo, Director of Nursing at Optimum Infusion in Chandler.
Very good. Can you tell us a little bit about the request that you have before us today?
Yes, so today we come before you to request a waiver of the anti-depoing clause to allow us to deliver our prescription medication to our AIS in advance of the patient's arriving for the day of the infusion, so that we can expedite the process and facilitate more immediate patient care.
Correct. So the pharmacy would deliver to the AIS for our registered nurses to infuse. The AIS is licensed as an outpatient treatment center through the Arizona Department of Health. And we would store the medication in a secure location and temperature controlled, just as our pharmacy would.
Pharmacy would monitor this and audit and to ensure that this occurred before any medication should return back to the pharmacy should the patient not arrive.
And these are medications that are being administered at the facility, right?
By a
Yes.
registered nurse, yes.
Correct. And the AIS is connected to the same building, just not with a door connected to our pharmacy, to the licensed pharmacy space.
When I was looking at this, and I guess I'll just jump off a little bit discussion, I don't know that I think we need a deviation here. I mean, I don't see any reason personally why this can't be done. Yeah.
So you just like send the medication with label, has the patient's information. I don't think they need approval, right? I mean, so you mail medication, right? You are like mail order pharmacy or?
No, we're home infusion.
I'm sorry, home
Yeah, so we
infusion. So
can
this is,
mail.
and this is the only facility you mail to or you ship to, right?
So
Or how
we be
you
shipping-
ship the medication?
yeah, so we two different methods. So we
Yeah.
either ship via courier, a common
Correct.
courier that will deliver it to the patients and have them sign the delivery ticket,
Okay.
or it could be shipped via common courier like FedEx
Okay.
or UPS.
And those medication cannot be administered by patient themselves, right? It is
These
normally-
cannot because
Okay.
in this, yeah.
Which I honestly think it's safer to have it delivered to the
Yeah,
facility than
I
to the
agree.
patient where
I
it
agree.
could be misused by, because the patient doesn't know what they're doing.
I agree. I don't think we need to approve anything.
Are there
this
any
is-
controlled substances involved?
No.
So you had mentioned that the permit holder, the pharmacy, would provide initial support for looking at temperature control and excursions. Is there ongoing support from the permit holder to the OTC?
Right. So within the policy, nursing will evaluate the temperature when they arrive to the facility, and then keeping the medication within the controlled space within the secured area will then keep the log that of temperatures that the medication is stored at. And pharmacy can audit that as well to ensure that it is maintained within controlled room temperature.
Is that part of the policy where this is periodic,
This is part of the
inspections?
policy for them too.
Correct, yes.
I mean, I don't think we need to vote or to, I mean, I see it, I don't know why they're here, to be honest.
Can we just take no action?
That they want to be.
Yeah. Of
Yes,
course.
abundance of caution.
Yeah.
Ms. Galvin?
You could vote to take no action as you deem the request for a waiver unnecessary.
Okay,
So I move for no action, right?
because we
Don't-
feel that the
we-
waiver is
yeah, The
unnecessary.
waiver unnecessary and they're doing like,
They're in compliance.
they're compliant.
All those in favor? Aye. Any opposed? Hearing none, go forth and
Thank
prosper.
you.
Thank you for your time.
Have a good day.
All right, 29I. All right. Christopher Sean Stoffel. Is Mr. Stoffel present?
I don't see him online, Madam Chair.
Let's go ahead and knock off the rest of the special requests then, and then we can come back to his. Dr. Gandhi, can somebody reach out to staff reach out to him and see if we can get him on?
Certainly.
Thank you. 29J, Peter Grant. Is Mr. Grant present? He's online.
Yes. Hello.
Hi, if you could please introduce yourself for the record.
Yep, my name's Peter Grant. I'm a pharmacist based in Philadelphia.
Mr. Grant, can you please tell us why you're before us today?
Yes, I'm requesting another attempt at the MPJE. I've had 4 previous attempts. I've failed all 4, 2 back in, I think, 2018 and 2 more recently this summer. And I'm asking the board to allow me to have another attempt at practicing pharmacy and passing and, joining you there in Arizona.
Are you working as a pharmacist, you said, in Pennsylvania?
Yes, just outside of Philadelphia, at a hospital here.
Okay. Mr. Grant, we're gonna have to pause for a second. We lost our YouTube feed. Apologize. Maybe let's take a bio break while we reboot. Mr. Grant, we'll be back in like maybe, how long will it take, Lynn? 5 minutes, 10 minutes? 10? 5. 10 minutes. So we'll come back. Well, let's just say at the top of the hour.
Top of the hour.
Thank you.
Thank you.
Mr. Grant, can you hear us?
Yes, I can hear you.
Okay, terrific. Ms. Cannavong, if you can do roll call, please.
Certainly, Ms. Walmsley,
Present.
Ms. Davis,
Present.
Ms. Lehan,
Present.
Ms. Snare,
Here.
Mr. Dang,
Here.
Mr. Nussey,
Here.
Mr. Anderson,
Here.
Mr. Thorwald,
Here.
all accounted for.
Thank you, Ms. Cannavong. Mr. Grant, again, apologize for having to start and then stop, but we have to keep our YouTube streaming going since that is our official minutes. If you could please tell us a little bit about why you're before us here today for the record.
Yes, my name is Peter Grant. I'm a pharmacist based here in Philadelphia. I'm looking to receive approval from the board for a 5th attempt at the Arizona MPJE. I am licensed in Pennsylvania and practice in Pennsylvania. I'm also licensed in Delaware, Maryland, and Iowa. I have no grievances. I've been a practicing pharmacist since 2012, and I just would like to be given the opportunity to take this test one more time. I did take the 2 tests in 2018 and then 2 more this past summer. And I've invested a lot financially, but I need to invest more time into studying.
Why the gap of the almost 5 years in between there?
It was just Arizona is it's not a work reason. I want to, I have a personal interest in Arizona, so I had nothing that was urgently making me seek out a employment within Arizona. I just always wanted to eventually, and then so once I had failed after twice back in 2018, I really wasn't worried about it at the time. But in, as you get older, and it snows behind me here in Philadelphia. I would, love to, join you guys out there.
Yeah, it's 70 today, so it's a pretty terrible place to be. Maybe not in, August when it's 120, but
Yeah.
So you said you've invested a lot in working towards studying for your test. Can you tell us a little bit about what you're doing to make sure that you're successful on this, hopefully 5th and final attempt that we can grant for you?
Yeah, I bought the practice test because I thought I was going to be given a 5th opportunity, and then I got the email about the 5th. I had to go before the board, but before I realized that, I had already bought the practice test, and then I'm going through the laws on your website very thoroughly, and I'll be ready to go if granted.
Mr. Grant, are the laws in Arizona that different than the laws in Pennsylvania? This is just a curiosity question.
Here and there a little bit, there's intricacies into any state. it's, I'm not a lawyer by any means, but, sometimes the tests take a little bit, more thorough looking at. And, I still have to do my due diligence there and to ensure that I'll be ready for the test in your state.
So I have motion if, okay, I move to approve the request to retake the test.
Second.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, Mr. Grant, best of luck to you. We hope that you're able to join us.
Really appreciate it. Thank you very much for your time, guys.
29K, Viva Gauda?
Hi, yep, it's Viva.
Viva? Okay.
Thank you all for having me today.
If you could
I'm
please
here
tell us
to-
about your request. Thank you.
Yeah, so I'm here to request to use my 5th attempt for the Netflix today.
Can you tell us a little bit about what you're doing to prepare differently this time?
Sure. So after my 4th attempt, I kind of took a step back from studying to kind of just reassess what I wanted to do moving forward, and ultimately came to the decision that I wanted to restudy for the exam. So in September, I enrolled in the Pass Netflix Now live course, and I went through that. I'm using that to study, as well as the resources they have available with their recordings and quizzes and practice tests. I also have a pharmacy calculation resource that I'm using for extra practice. And my goal is to kind of assess my readiness with those practice exams and the pre-Netflix when I'm ready to take the exam.
When did you graduate from pharmacy school?
December of 2020.
Okay.
And are you practicing as an intern today?
So I've worked in retail for almost 6 years. I was with CVS just until recently, because I did take a separation just to kind of think of what I wanted to do in the future. So I think I stopped working for CVS in May.
Miss Lahan, do you know Miss Gauda?
No, I do not.
Will your employment predisposition your judgment here?
No, it will not.
Okay, thank you.
So I graduated in Illinois. I worked out in Tucson for like a year and a half. So I haven't been in the Phoenix area for long.
Board members, additional questions?
I'll make a motion to approve her request.
I second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? All right. Best of luck to you, Miss Gauda. Your request is approved.
Thank you so much.
Good luck to you. Any luck reaching Mr. Stoffel?
No, Madam Chair, I tried calling him and then I shot him just an email recently and I haven't heard back.
We've still got a lot on the agenda. Do we want to table this to the next meeting, or do we want to go ahead and discuss this without him? Looking for direction from the staff.
I think you may want.
I think we may want to hear from him as well.
Yeah.
So.
That was kind of where my head is. All right, let's see if he has the opportunity to join us later this afternoon. Otherwise, we'll table it till the next meeting. Let's jump into reports. Dr. Gandhi, if you want to get started with yours. We can take a break if you need a break partway through. We can kick it over to Jen.
Yeah, no, I'm good right now. Thank you. Couple of things on my agenda to talk about. I'll start with the easier subjects, if that's okay, Madam Chair. And then we'll dive into the number one category for me, which is USP, but I'll do the easier ones first right now. Last week I had an opportunity to be in Chicago in a cold, blistering weather, and it's nice to be back. But I brought back a gift as well, this flu bug that I caught. The member forum meeting was a good meeting. We continue to talk about working conditions and mental health in that space. Thus, that question I asked Stephen yesterday during our discussion with the Poison Center about whether they are working with pharmacist well-being or mental health. There are some states across the country that have partnered with folks that deal in this space, and I think we may need to entertain that discussion going forward, just to assist our workforce in having somebody to talk to, having somebody to vent to, or whatever the case is. We can agendize that for a future item and get into that discussion. Next topic was NABP Verify. It's surprising to see multiple states, many states, not have shared services or being able to leverage stores that are slower and balance the workload with busier stores. Obviously, Arizona has been in that space for a long time. It looks like we've kind of had a crystal ball and saw the future and moved in that direction ahead of time. So a lot of times when you have these discussions about NABP Verify or other advancements that pharmacy has to take, Arizona is usually an example of things working the way they should be working and staying ahead of the game. So what NABP is offering is a tool that we used during the pandemic, the COVID epidemic issue, where we had to verify pharmacists were in good standing before we allowed them to work here. Other states now are going to be leveraging that tool to see if pharmacists can assist their state, and those pharmacists, of course, have to have a good background check, and there may be some statutory changes that need to come with that to register them, not license them, but register them to work for their state. So there's more discussion. This is still an early discussion, very young discussion, but it's an interesting topic. Again, it doesn't really impact us so much because we already have a lot of these things in place for our state. But it's interesting to see what other states are going to be doing, see if they come up with something more creative that we can leverage as well in the future. A lot of board members attended that meeting, and one of the hot topics was conflict of interest and just disclosures. And over the last several years, you've seen board staff also step up their efforts in ensuring conflicts of interest are disclosed and addressed, and disclosures are also noted for the record. This is also impacting the rest of the country, and so everybody else is being educated at this point. Next one was drug shortage, compounding, and USP revisions. Obviously, we're talking about that too in our state, so we're not immune to that discussion, but it is a problem, not just in the US, but it's a global issue. Canada was there representing their country. And it seems like they're being impacted by drug shortages as well. And it's basically raw material that's unavailable right now. And we don't know if that's political or what's driving that, but it is causing major concern with taking care of patients' health. One of the topics that I'm going to be talking about here later also is IV hydration was discussed as a hot topic. It looks like South Carolina may have solved it a little bit, but it is a growing concern across the country. I think there was a death in Texas related to IV hydration because of handling of medications for compounding practices. It was an interesting, I'll dive into that more a little later. It's on my legislative topic here coming up. Any questions so far?
No? Go ahead.
All right, let me see where I'm at here. There's three proposed legislations that we may be running this year, Madam Chair and members. The first is the opioid antagonist. We do have a major hurdle, a bump in the road regarding reporting it to the PMP. That was at one point needed for a DHS to show how much activity of naloxone is out there, how much is being dispensed, and so forth. Since, as of this past spring, DHS no longer needs that data, but it's still a law that any dispensation of opioid antagonists has to be reported. And that seems to be a problem for emergency departments, doctors' offices, and so forth, because that law applies to them too. So we tried to repeal that last spring, but I think it was a little too late. Legislative session had moved on too far for us to piggyback off of any bill. But we've had meetings over the summer and early fall with different groups, AZPA, Access, DHS, and other groups that are interested in this topic. And we do have a bill that we're introducing. Senator Shope is sponsoring it to remove that burden. So hopefully the plan is to introduce it in both houses and move it to the governor's desk for signature and an immediate effective date. So hopefully by February, March time period, that law will be lifted and we could distribute naloxone more freely and without that burden.
The draft language is what's in our book.
Correct.
Do you need us to approve that?
I think you already did. I just wanted to give you an
Okay.
update, but in case you didn't, and I'm a little foggy, we may just want to memorialize it again.
I'll make a motion to approve the language that's proposed.
I'll second.
All those in favor?
Aye.
Any opposed? All right, go on, Cam.
Thank you. The next bill is 2344. That was supposed to be introduced last year, but for whatever reason, the legislator that was running it didn't make friends last year, and so it kind of died early. Senator Shope has offered to rerun that bill. We did add another component to that bill, and it's in your packet. The additional language that I just recently proposed was to make third-party logistics less burdensome. I know as far as our wholesale permits, the full service versus non-prescription, the full service requires a fingerprint clearance card. The non-prescription does not. And so third-party logistics, I'm kind of mirroring that language. And that was a request of one of our permit holders saying, hey, we don't mind being permitted, but can you lessen the burden because we're not dealing with dangerous drugs, prescription drugs, controlled substances, and so forth. And so it made sense to align with our wholesaler process. So I did run language by Senator Shope's assistant, and they're willing to support that if you guys are okay with that as well.
What page is that language on, Cam, since that's new?
That is new. It's added to 2344, but it's not in your board book. That just was drafted not too long ago, like yesterday. But in essence, it says third-party logistics, if you're dealing only in non-prescription drugs, you do not need a fingerprint clearance card.
That makes sense to me since we unregulated it anyway for pharmacies. Do you need a motion to approve?
Yeah, if you're okay with that, because that was the only addition to that package.
I'll make a motion to approve the proposed language for third-party logistics.
Second.
All those in favor?
Aye.
Any opposed? All right, go ahead, Cam.
The third proposed bill, and it's still in its infancy, was brought on by Representative, I'm skipping my bio, but one of the representative, Walmsley or
It's Willoughby.
Willoughby, sorry. I was close.
I haven't been elected to the state house. It's okay.
It was somewhere there. So Representative Willoughby called us into her office and wanted to talk about IV hydration. And it's an interest to her because she's an RN and she worked in this space before she moved into the legislative world and identified a lot of concerns in that space. One of the concerns is how medications are kept, like on site when they're at a soccer field or some event, they're taking a cooler and storing hydration bags in those coolers and pretty much compounding it right on a tabletop or something like that, adding additives or whatever, and then of course providing the hydration. At the end of the day, they take the inventory back home and they put it in a refrigerator, which is inside their home with foods and stuff like that. As far as intake forms go, she's like, I've had a stack full of intake forms. Asked my supervisor where they go, and she said, "Don't worry about it. We'll take care of them." So her thoughts and her ideas, like, okay, they're probably being shredded or whatever it is and not being appropriately filed or managed. So there is a lot of issues in that space. It has grown exponentially across the country. But her ask of us is, are we willing to take on the challenge as far as storage and handling of medications at the low end of it, and then we'll build up from there. I don't have any proposed language for you, but I wanted to draw that to your attention because I think that representative is going to give it to us whether we're in agreement or not. I think it's a good idea because when you talk about drugs, the first thing you think about is the Board of Pharmacy. And so who better to regulate it than us? It does have create a lot of questions for me on, because this is mobile hydration. They're in one area one day, another area another day. How do we figure out the logistics on how to inspect them and so forth? So there's a lot of questions, not a lot of answers yet, but just wanted you to know what we're working on.
Would that only be regulating pharmacists and technicians or other healthcare providers?
We will not be regulating other healthcare providers. We will be regulating on how they manage the medication.
Okay, gotcha.
So it would come with, of course, permitting that mobile unit, inspecting whether they have the right equipment for storage and handling and all that stuff, and then, of course, policy procedures and how they manage that when they're off hours. So,
Well, what I was wondering is if they didn't follow those regulations, we would just notify the appropriate board.
we would do that and take action against the permit holder.
Okay.
So we would issue a permit for this activity. The number one topic on my list is, of course, USP. Mr. Bose and Mr. Rain gave a presentation during the last meeting and citing a statute. And the statute they cited now pertains to rules, not necessarily statute. And the official compendium definition sits in the statute. And of course, it says complying with the most updated version of USP. The legislators obviously knew that this could evolve over time, and that's why they approved this language. So I do have a note in your file, my summary and a memo to the board regarding my thoughts on it after consulting with Gene and Seth regarding it. So entertain any questions from you guys. You've had a chance, I hope, to read it and digest that information.
So Cam, I feel like we're kind of caught between a rock and a hard place. This is just my personal pontification. I feel bad because we've kind of gone back and forth, back and forth. I also understand what you're saying, which is the reason why we made the original decision, which was that we were going to have to uphold the chapters because that's what the statute said. Then we came forward last meeting or the meeting before, decided that we would take it to rulemaking, have that first discussion. So I feel like our messaging to the public has been mixed. I don't know how it's possible to think, especially now that the date for USP implementation has passed, how it's possible to think that all of the public is going to comply. We've also provided no recent guidance on what our expectation would be. So I feel like we're putting the public in a bad place, and I worry that we're going to have access issues, which is what we've talked about over the last couple of meetings. And I think we have to carefully balance what we think is right from an access standpoint versus the law. I mean, we had a very robust discussion in the rules task force, which not all the board members were a part of. And I feel like what we decided in general, and Tennille or Kristen, please jump in, is that while, you know, USP has some really good guidance that probably not every type of non-sterile compound needs to be handled in that way. And we talked about all the challenges that exist. So I feel like we're kind of in a little bit of a tough place, and I don't want to have compounds not be available to the Arizona public. In the meantime, and I also don't want to put our licensees in a bad place where they're forced to break the law or potentially even go out of business in the meantime. So that's where my initial head is, but I'd like to hear others' thoughts.
So part of the discussion was that USP is not a regulatory agency. They're a standard setting organization. So USP chapter updates don't go through, say, a formal rule process that, allows the public to weigh in and then debates those things in a public forum. There's also some discussion about whether or not a tiered enforcement of USP 800 would be more appropriate. So compounders that just do, Mr. Boson said, like, say, fluconazole capsules would have a different enforcement than a pharmacy that was mixing chemotherapy, which would obviously should be required to follow USP 800 to protect its staff. So I'm with Ms. Walmsley and I think USP is in the same place too, where they're trying to balance access with safety. USP never effectively demonstrated that there was a problem with the previous USP chapters as long as the pharmacies were actually following those rules. There are cases of pharmacies like NECC that, have tragic outcomes because of poor practices, but they weren't following the rules as written anyway, whether those were the older version or the newer version of the rules. So USP hasn't been able to demonstrate, at least to me, in any of I've been to, lots and lots of USP meetings, the need for the change in these chapters.
Additional thoughts, board members?
So in the hospital setting, although I agree with you that USP 795, 797, 800 are not technically laws, but they're strictly enforced by CMS. And CMS is a governmental entity.
But not every pharmacy is held by those standards with CMS either. In the hospital you are, but like a independent community pharmacy is not. A grocery store pharmacy is not.
But they don't have, in those places, they wouldn't do any compounding.
They might do 795 compounding, that make Miracle mouthwash, butt paste.
My pharmacy does sterile and non-sterile compounding. We're not
Regulated by. Medicare.
regulated by Medicare because we don't take insurance.
Or JACO. And that's where I have the concerns, right? I just don't feel like we've given enough guidance to the public to really sufficiently prepare to not have access issues. And to Ms. Davis's point, these meetings, while they do ask for public comment, are not public deliberations like any other rulemaking or lawmaking is either. I don't know.
They're a standard setting organization. They're not a lawmaking body.
And just for USP 800, I believe they say that each entity will do their own risk assessment. So now, how are you going to make rules if they allow like organizations or pharmacy to do self-assessment to decide which one to change the group, because it's clear there. So pharmacy can do their self-assessment.
Well, and you're right. That is a part of 800. And I think that that should be something that we allow. But again, I think that there needs to be guidance out there to the
Correct.
regulated public of what the expectations are.
Correct.
Pharmacies can't do an assessment of risk if they're compounding with API. So
Raw
if they're
powder.
crushing tablets and stuff, they can perform an assessment of risk, but if they're weighing powders, they can't.
So that's what I mean. Like, you cannot really make one rule to cover everything. So I agree with both of you.
Mr. Anderson, did you have something you wanted to add?
No, I agree. It's a standard setting organization and, there's a national consensus that that these are standards of practice. And I would hate to see Arizona deviate from those standards that has been the expectation for pharmacies across.
When you sit down.
Cam, you're not on mute. FYI.
Not all of the states have adopted the new USP chapters.
Oh, no.
Understood.
Isn't it by 1124?
It was on 11-1.
But to my understanding, 1124 is going to be strictly enforced by Joint Commission, which is all hospitals throughout the whole country that are accredited by Joint Commission have to be abided by USP 800.
So that's, I agree, yeah. I mean, like, it's already enforced by June Commission.
But again, that's not every pharmacy.
Yeah, that's not
That's
community
true.
pharmacies. It's not community pharmacy, which I believe majority of them, they do like non-sterile compounding, like medical mouthwash, for example, right?
So Cam, what are you asking from us today?
Though USP is not a regulating entity, we do reference it in our statute, so it does bridge that language over to us to be compliant. Now, I understand we've gone back and forth. This discussion has also been in play for what, 6-8 years or something like that, for companies not to even think about being prepared, or I'm not sure, even if we push this out another year, 2 years, whatever it is, even in that time frame, there are going to be companies we're going to have the same conversation at that time. So when are we going to rip my ask is, when do we rip the Band-Aid off and have them comply?
My recollection is that Mr. Boson was going to bring back proposed language for us to look at in the rules.
He's saying that that's not an option anymore because of the statute after looking at it again. He
Oh.
disagrees with that. So Ms. Galvin, Mr. Hargraves, I don't know if this is an executive session type conversation, what our legal options are here. The standards technically are already in place, effective November 1st. If that's the decision that we make today, so that means that as of that moment, there's probably going to be pharmacies that are not in compliance.
But yeah, we've had it on our Board of Pharmacy website for months since we
Right.
that we were not going to enforce on November 1st.
Is a delayed enforcement period a potential option?
That would be appropriate for
Legal
executive
advice?
session.
Okay. Ms. Fine, I see that you're in the audience. I know this was something that AZPA brought to the board as a concern. Is there anything you would like to weigh in this discussion? Want to give you the opportunity to speak if you do.
Hi, Kelly Fine, EZPA. Thank you for the opportunity. I don't know if I have very specific comments. It was kind of thrown off guard because I thought we were kind of on another track based on the presentation, based on the fact that the board rescinded a vote. The discussion was that we were going to deal with it in rules, and that's what we've been communicating out to all the pharmacies. And so the conversation was, we were concerned that there were a number of pharmacies not ready, and would the standards, are they even necessary at all of the different pharmacies? Creating a situation where we would all of a sudden have pharmacies that could not provide necessary compounded medications to patients who very much needed them, not understanding what the full intent of going forward with implementation was on November 1st. So I don't know what's transpired between then and now, because I know we have our rules task force. And so I know there can be difference of legal opinions or where we go forward, but I would urge the board not to move forward with implementation as previously voted, not understanding what all of the unintended consequences are. I'm not a lawyer, so I can't present legal opinions. The attorney we hired, Mark Boson, is not here in person to speak to any of this either. So he's our legal counsel on this particular matter. So I'm not prepared to discuss any of this, as I was not aware this sort of discussion was going to be on the agenda. So,
Ms. Fine, do you have any knowledge of how many compounding pharmacies that have been in contact with you that say aren't ready?
we did a survey back in April when the first vote was taken for implementation, and that was what prompted our appearance at the board. And we surveyed hospitals and independent and chain pharmacies, and we had about 8. I'm a little foggy on the data now because it's been so long. And again, I'm not prepared to really present data, but 80 some pharmacies responded. A vast majority of them said that they were not going to be ready by November. And so that's what prompted our discussion of like, hey, wait, like other states aren't implementing this. All of these regulations or standards don't necessarily need to apply and don't make sense for every single pharmacy. It depends on what medications they're compounding, what are the circumstances within those facilities. Let's take a step back, determine what really makes sense for the state of Arizona so that we don't have unintended consequences, not just of pharmacies going out of business, but patients not having access to medications that they may very much need. And so that was I thought the decision that we came to based on the impact, not just to pharmacies, but on potential patients and not understanding the scope of what this would mean for the state and not having broad discussions with the other stakeholders of what this would be. So again, I appreciate the opportunity to give a few comments.
Board members, any other discussion or questions? Otherwise, I think we should probably get legal advice. I'll make that my motion. Do I have a second?
I second.
All those in favor?
Aye.
Any opposed? All right, we'll be back.
Why? Oh,
All right, welcome back, everybody. Let's jump back into discussion.
So Ms. Fine had said a little bit earlier that when they surveyed pharmacies in April, 80 of them were not ready. That was, more than 6 months ago. Steve or Sandy, you guys have been out in the field. Do any of you want to comment on what you see about readiness for 800 compliance?
I can just provide you with a little bit of feedback. Steve Heiber, Compliance Officer. The majority of the pharmacies that are going to stay in the game are ready. The rest of them, they probably are just waiting for the hammer to hit, and then they're going to go ahead and get out of that business because it's a large investment. There's a few out there that I think they did sort of a remodel and they believe they're compliant. And once we see, once the board comes up with a decision as to what we're going to enforce, let's say you carve out some items, then we'll be in a better position to provide them with feedback. And obviously, if they're not fully compliant, we can gauge the level of noncompliance and then issue needs improvements and then work with them to become fully compliant. If they're really far off base, obviously we'll go the violation route. And if really necessary, we'll open a complaint. But this has been out there for a long time. And the feeling I get is the people that were planning on staying in the game, they moved, they made the changes. The ones who didn't do it aren't sitting around waiting for some miracle to happen because they know it's not going to go away. And shame on any that believe that it's going to go away and they didn't move on it. They'll just have to stop what they're doing and then, do what they need to do if they want to stay in the game.
So I have a question for you. How do you know they're compliant or not? I mean,
through our normal inspections, we can see.
So, but and not only for you, for all our compliance officers. I mean, are you aware of the standards for USP 800, USP 7? I mean, do you know like if this company compliant or not? I mean, what do you look for? I mean, there is like about thousands of medications under USP 800, right? So how do you inspect that?
Well, we were inspecting the primary and secondary engineering controls in that regard. I know that they have to hire personnel in order to, manage that. There's a requirement in 797. There's additional testing they'll need to do. They'll be doing their own monthly testing. So obviously you won't know that level of compliance until they actually pull the trigger on it. Some are already doing that. Some already know how to do that testing. So again, it's
sorry. Yeah, I'm maybe I'm talking more about community pharmacy because when the rules go for everyone, right? Like, so do you think community pharmacy are ready for that?
There are not as many community pharmacies that do compounding anymore. So if they're going to do 795 compounding.
But that's what exactly, I mean, 795. Do you think community pharmacies are able to be compliant with 795?
Yeah, I think they can do that. Sure. Though they've already removed carpeting and things like that. And many of the large chains will centralize it, which is a good business decision because obviously to have 5 roller mills, it's better to have 1 roller mill. It's better to have 1 planetary mixer at 1 location and centralize that compounding.
Okay.
And it can be done under central fill.
Yep.
Thank you so much.
You're welcome.
just to piggyback on the question that was asked by Mr. Nassif, yes, there are thousands of medications out there that would consider hazardous, but they are divided into 3 different tables, table 1 drug, table 2 drug, and table 3 drugs. And table 1 are very common drugs. And not every pharmacies carry all of those thousands drugs. Make sense?
Yeah. I mean, like, I'm very aware of the USP 800. I mean, actually, the company I work for follow USP 800 already. But I'm just like, my concern is about enforcing rules, and pharmacies are not ready, and that might cause harm for our public, because I can see pharmacies gonna say, like, simple as Miracle mouthwash, said, okay, I'm not gonna do it, and then you have a patient, they have discharged hospital on Friday, or like a weekend, they cannot find a pharmacy to do Miracle mouthwash for little baby, like, for like a little kid. So that's what I'm worried about. But I believe those standards should be followed at some point. But just trying to be more like passionate about the time, about when we need to do so.
And one thing I forgot to mention, all of the compliance officers that were here more than 3 years ago have gone through, this is before the pandemic rolled into town. We were all put through USP training, 795, 797, and then we were trained on the, the 800 piece that hasn't been put out yet or is not enforceable yet. So the newer compliance officers would have to go through that training. So we'd have to make sure that we got that training in the budget, as well as a refresher course for those of us who haven't been, because you lose it if you're not out there doing it all the time. You become a little rusty. So I just wanted to add that to the record.
I personally don't think it's reasonable to reverse course today and expect people to be compliant tomorrow. I don't see a world in which I think that that's fair to the public, whether it's patients or our regulated public. We have gone back and forth. We've had it posted on our website for a number of months, if anybody was following that discussion, and to expect that everybody knows tomorrow, the strike of midnight, that this is now a requirement, I don't think is fair to the public. So I feel like we need to find some sort of in-between solution. I feel like there probably needs to be more evaluation here. If our expectation is truly going to be for the pharmacies to follow all 3 of the compendiums, I think we probably have a duty to the public to do some education as well as around what is expected. Because there's some things in the compendiums that are not super clear on even what our expectation would be as a board. So I feel like we need to look for a middle of the road solution to make sure that we don't lose access to compounds tomorrow. And that we also don't put people in a bad place and expect them to be compliant with the law that we, quite frankly, right at this very moment as we sit here, says on our website that we aren't going to expect compliance with. So.
So,
go ahead. I'm sorry. Go ahead.
So I guess the happy medium here is to establish a committee, USP committee, and we can have weekly meetings and maybe present the discussion at the February board meeting, and inform the public that after the February meeting, we will enforce it. So that give them about 2 months, more than 2 months, to get themselves really prepared.
I don't know that I guess it depends on. So say a pharmacy had already done the construction, but they needed a BSc to do hazardous sterile compounding. There's no way they could get one within 2 months in the current climate. Just all of those kind of supplies have a really long order date.
But then in fairness, like Mr. Haber had mentioned earlier, these pharmacies are well aware of the changes years and months in advance. They know that it's coming. And for them to wait until now, I'm sorry, but I don't feel sorry for those pharmacies.
If it's going to be put into rule, it's still got to go through the governor's office and through GERC, and it's going to require quite a bit of time and information on what the other states are doing, the impact on the public, businesses. It's going to they're going to want to see all of that and see how it's benefiting the people of this state before they move forward with it as well. And there's a time frame for all of those things that would extend it past that February date.
I kind of the opinion, and we've already had one discussion, like I mentioned earlier, in our rules task force, and we were planning, I believe, to have some proposed language at the next meeting. Perhaps we need to convene some sort of expert group within the state. I don't really feel comfortable today changing our position. I think if anything, we should put something out on our website that says the board is potentially reconsidering this. We'd like your feedback. And maybe gather some direct feedback from the regulated public on what are the challenges that they will face to become in compliance. I don't know. I don't, my gut tells me that it's not fair to anybody, most as from an Arizona perspective, to expect this tomorrow.
What I can see we can do that we can copy the FDA, what they did with the DSCSA. They did like stabilization period. So they're not giving citation to any company not following the DSCSA, and they give them 1 year. And I don't know if we can do that, just like give them like here advance this stabilization period of time, so you have a year to be compliant. That's just like that's what the FDA did, right? That's just a suggestion.
So Dr. Gandhi, just for clarity, this is in your executive director report, and what exactly is the ask of the board?
The ask is if we maintain our course, we have a task force meeting group already that's talking about this, or accept part of USP, because some of our rules 410 does say you have to comply with the beyond use state of the most current version. It doesn't talk about the structure and the environment that these products need to be made in, so that needs to be addressed in a future rule writing session. But I think we had a plan. I just wanted to draw to the board's attention that this official compendium is in statute and not in rule, so it can be enforceable today if the board chooses, but parts of it only, not the full version.
But only with regards to the beyond use state.
That's what I saw in 410. I haven't seen like the structural changes, requirements for structures and all that stuff. That's not in our rules.
I think sanitation might be in there as well. Scam.
Yeah.
My personal opinion, and I'm just going to throw it out here, is that we maintain our current course and that we pick up this discussion one more time at the next rule writing committee and determine what we think has to be changed in there. And then if we feel like emergency rules are necessary, we can pursue that as an option with the governor's office to make sure that we can get this done in an expedited fashion to make sure that we protect public safety. But in the meantime, we can at least put it out there to the public that we're considering adopting part of it, and it's whether, you know, some of those specific provisions that are matching with the statute. But I personally feel like continuing on our current course, I don't think there was anything magical about November 1st, 2023 that makes it all of a sudden unsafe on December 7th, 2023. So the difference of, you know, 60 days roughly. In the meantime, we have one more committee meeting. We can bring this back for further discussion and potentially look at taking action in February of some sort. And part of that might be that we decide that we need to promulgate emergency rules with regard to compounding, and then we might need to have some in-between meetings. I don't know. That's where my head is.
I agree with all
I
of
agree.
those comments.
Do we need motion for that, or just we table it, or?
I would suggest, based upon the discussion, just taking no action at this time.
So I move to take no action for this matter.
Recognizing that it'll be discussed by rules. in a couple
Recognizing
weeks.
to be discussing by rules on next meeting.
I'll second that.
All those in favor?
Aye.
Any opposed? Dr. Gandhi, I think you just have update on board member requests. Anything from that one?
There is a grid in your handout in your book there about what we're working on. Just culture is still being talked about across the country. We're going to be modifying, obviously, my compliance officers. Our team is modifying how we approach investigations related to prescription errors. I think we operate in a just culture realm. We just have to now take it up a step about asking for root cause analysis and what systems break down and what they're going to do to fix it. But I think in the long run, I think our board is already aligned with that thought process. Next one
Can-
is, yeah,
Can we get a meeting on the books for that so we can
Yeah.
discuss that form?
I will do that.
Thanks.
A rule writing task force, we have one coming up in about a week and a half or so, or 2 weeks, to talk about this very topic. We got the Drug Supply Chain Securities Act also on our controlled substance transfer to talk about that, and any miscellaneous items regarding the new the rules task force. Medication donation. This is becoming a little bit tricky. I learned last week on my trip to Chicago about Drug Supply Chain Securities Act and how that is being pushed actually by another year. So it gives us an opportunity to get our ducks in a row. Medication donation. Don't know how Drug Supply Chain Securities Act applies to medication donation, because we are not only taking medications from possibly manufacturers, wholesalers, pharmacies, but also patients. So I have posed that question with my counterparts across the country, some experts in this space, in this topic, and they're researching it for me to see if we have violated or we will be violating any federal laws regarding it, but I'll keep you posted on that one. Physician ownership of pharmacies, obviously we took no action on that. That was discussed some time ago. Harmonization of statutes and rules. Getting more and more traction on this one. I just learned that the osteopathic board is requested our inspection forms to start inspecting the osteopathic dispensing physicians. So as we talk about more, as we beat the drum more and more agencies are coming in alignment saying this could be a problem. Let's step up our efforts. So we are getting some traction there. And then continuing education for board meetings. Working with NABP to incorporate that. They just sent me a slew of paperwork that I got to fill out. It seems like I may have to have each one of you fill out some paperwork. Anybody that's presenting has to fill out paperwork to get it accredited and get themselves accredited. So I'm trying to schedule a meeting with NABP to see how detailed this has to be, or can it be done globally as far as, here's my agenda. This is what's going to be discussed. But like all CE, it's got to have, valid content and the purpose. And then I don't know whether to have to test for cognitive ability, like, hey, we learned this or we learned that from this meeting and so forth. So there's still some questions. I still got some time. The hope is to get this going by the February meeting. So I'll keep you
Sam?
posted on that. Yep.
Do you think it would be possible to offer that for people who are only able to attend virtually?
That's a hard question. That's a determination you guys will have to make, because I mean, for me, for instance, I've been on this meeting for almost 2 full days, but I haven't had my video on, and I could just collect the the code at the end and then submit for my CEs. Is that, how do we verify that they actually watched it?
We do a quiz at the end. What was Lori wearing?
Yeah, but then we also record this thing so they can watch it anytime.
Did she wear her glasses or not?
Yeah, that's the hard part. I don't know whether we should allow for virtual CE.
Okay. What about, do you know of any other states that do CE and how they handle it?
I don't, I mean, this is why it's taking so long with NABP, because I don't think NABP was leveraged in this category for.
There came from attending meetings from around the country. There are other states that do it, but I think most of the other states do just what we did before, which was non-accredited CE.
Yeah.
Gotcha.
So it wouldn't hit your
Okay.
CPE monitor.
Yeah.
You'd have to put it in as like other CE.
Okay, thanks.
Could AZPA be the,
NABP.
oh,
The AZPA could.
right?
I wanted to comment on one of the things that Cam mentioned on medication donation. Access even though the rules were passed some time ago through here and the legislation was passed even longer, and everybody had been informed, Access just a few months ago finally realized that they actually could do this. They didn't realize that they could do a donated medication. And they put forward their rules just in the last month or so at GERC to allow for them to do that with people. So part of the issue there is that's moving forward, but part of the issue there is still getting the word out or re-getting it out to the different departments that need it and the public, because they just like Access, even though they were told, it didn't hit with where they needed to be to understand that they could do this until just not too long ago. So just FYI.
Dr. Gandhi, does that conclude your report?
That does, Madam Chair. Thank you.
Were we able to reach Mr. Stoffel?
No, he has not responded to my email or returned my phone call.
Can we, should we take a motion to table that till the next meeting?
I think you can just make that.
We can just table it. Okay. That leaves us with Ms. Kianavong's report. I know some people told me that they have a hard stop at 4:30. Ms. Kianavong, are there certain items that you want to make sure that we get to today? Or if we could prioritize your report?
Well, in the interest of time and providing the board the cleanest draft possible, I'd like to request to table 30B1 to February, proposed substantive policy statement on medication administration by pharmacists. That's agreeable to the board.
Yeah, that's fine.
I'm happy to present the activity reports to the board, or I can present a year end at the meeting in February.
Either's fine. And then we've got the discussion on the trainee, like the trainees.
Correct.
Is that something that you'd like to make sure we accomplish today, is the discussion on the trainees?
I think it would be helpful to address that.
Okay,
today.
let's do that. Because I do think that that's going to take some action before we lose the other board members. And then if, depending on how we feel about time, we can either do your reports or plan them for the next meeting.
Perfect. Okay, so 30B2. This is discussion, consideration, and possible action regarding pharmacy technician trainees and fingerprint clearance card denial letters. So at its meeting in August, the board discussed whether it would like to consider applications for pharmacy technician trainee registrations. When board staff has knowledge that includes but is not limited to an applicant's disciplinary action, prior criminal charges, or criminal convictions. And at that time, the board indicated that it did want to be made aware of those matters as they pertain to new technician trainee registration applications. So since that meeting, staff have become aware of applications for fingerprint clearance cards that have been denied by Department of Public Safety, DPS, after the board has issued a technician trainee registration for criminal matters that occurred prior to the registrant ever applying with the board. I've provided some screenshots in the file. There was also an example where a denial letter was received from DPS prior to the board issuing a registration, but the majority of these issues tend to be around the denial letters being received by the office after the registration has been issued for matters that occurred prior to these individuals applying with us.
So Ms. Kianavong, a question there.
Yes.
So explain a situation where that might happen. Is it somebody that might have had a fingerprint clearance card from another profession? Now we're not requiring it, but because they would potentially hold an Arizona license, that information just comes to us?
Correct. So it may have been that they were previous applicants for technician trainee license, and then the board transitioned to a registration. So they had applied for a card at that time. As we know, the card is not required for registration. It may be that they hold a fingerprint clearance card because they're under the jurisdiction of another board or regulatory body in the state that requires it. Either way, our office is notified, and my understanding, it's because they're indicating that they're under the jurisdiction of the Board of Pharmacy on that card.
I agree
So-
with Ms. Galvin's comments and appreciate that. We can take action on things that we become aware of. And I would want to see it.
I have a question. Is there something preventing us from requesting that information on the application just anyways? Even though the fingerprint clearance card is not required, requesting if they have any prior disciplinary action or criminal charges or convictions, like it said before, even though we don't require the card?
So if we go back earlier in the year, and this is why we wanted to bring it back today, when the application for registration was considered by the board, we did present the license application and then the proposed registration application. And that registration application was drafted after, multiple discussions with this board. And the requirements on the registration application are pretty basic. All of the regulatory questions are gone. The fingerprint clearance card requirement, there's several things that are no longer there. So I did include them back into this file as a possible consideration for this board to, if you wish, reconsider what is on this registration application as well.
Also, is there a path that we can move towards possibly amending and asking for a background check? Changing the statute?
Yes, that would require statutory change. The reason we don't ask those background questions is because the statute is very limited. As far as what information you can request, the vetting for a trainee is significantly less than previous.
Yeah, I'll call you back, my friend. So in board meeting. Thanks.
Maybe I would be interested in moving forward with amending the statute and starting that path because of these very reasons that keep coming up, and maybe they will be demonstration as to why we'd want it changed. Doesn't help in the meantime.
Yeah, in the interim, and it's, in my opinion, and Cam, it would be too late for this session, or we're really bumping up against this session. I know he had a couple possible changes, but I mean, you're looking at another year before that could be implemented.
And I'd also think that we need to balance and think about what that does to the pipeline of trainees. While I do think that we are obligated to take action if we know that there's some sort of conduct that might prevent them from getting a license later, the reason why the legislature removed the requirement and moved it to a registration versus a license was to increase the pipeline of technicians into the trainees, into the population, and to speed the registration time.
I agree with you, but I think that our mission is for safety. And that to me is not safety minded.
But how often do we deny a license because they have a criminal background? Not very often.
We'd like to be aware if there's a pattern.
I
minimum.
don't disagree. But I'm just saying that we need to consider the pros and cons. I don't know that I would favor a statutory change. And again, as Ms. Galvin pointed out, it's a little late for this year. But I do think that we need to see, when we are aware of issues, we need to be aware. We need to have a discussion. Additional thoughts?
I don't know that we could change the application much because it would be beyond what we're allowed to ask, to be honest. But if we have the information, I do want to present it to the board.
Do you need some sort of a motion? Or what are you asking for us to?
Yeah, so some
I
guidance
think we're all
here.
tired at this point.
Yeah, some guidance and clarification. When we receive these denial letters, after we've issued a registration for a criminal charge, conviction, arrest that's occurred before the individual ever applied with us, what would you are there certain criteria that the board would like to see? How would you like to see those? Would you like to see them in the form of a complaint opened on the registrant? Are there certain things you'd prefer to see or not see? Is there a kind of a look back period you'd like staff to consider when presenting those matters to you?
What if we reached out to that technician trainee? I don't know, would these technician trainees get a full technician license if they pass the PTCB, even with this information on their fingerprint clearance card?
Can staff make that determination? I think that might be board determination. How about an agenda item that's registrations requiring board review? That way it's not a complaint and then it comes before us.
Question, if DHS comes back and denies it, does that mean we have to terminate their what were the authorizations we gave them?
Right now, we're unable to do anything with them. We have a copy and that's why we're discussing it today.
You mean if they don't have their fingerprint clearance card?
I mean, if DHS comes back and say they have a problem with them.
If they deny it.
Yes.
If they deny a fingerprint clearance card.
They can continue to work.
I'm asking because does that mean what does that mean to us? What should it mean to us? Is it something then that we go back and need to revoke their licenses because of that? Or is it something that's meaningless? And depending on which answer, there's different kinds of methods to go forward.
I don't think it's pending that particular thing. It's more pending the behavior and how we view the behavior, the criminal behavior.
Can a pharmacy technician trainee get a full pharmacy technician license with a denied fingerprint clearance card?
No, they need a fingerprint clearance card to have an administratively complete application, although they could seek a good cause exception.
So could we reach out to them when you get the denial and say, hey, just FYI, you're never going to be able to get your, full technician license unless XYZ?
We can, but that doesn't, does that satisfy the board in addressing the issues that we're seeing on the denial? We have drug charges, we have theft charges. Is that something the board wants to address?
I would like to hear those things when they come through. Maybe like within 2 years' time of their application to us. I don't know, as far as she was asking for a time frame.
I think the same timeframe that we use on other license.
I mean,
Even though they're not licensed.
If they get to the point where they get a denial of a clearance card, I definitely think it needs to come before us. Ultimately, they're never going to be able to matriculate to a full technician license unless they can get a good cause exception. So at some point, I don't know why we would allow them to hold a registration with us if their conduct is as such that they wouldn't be able to hold a license with us later. I don't know. That's just my head. I don't know how we facilitate that, because I know it takes time, right? So if you find out tomorrow that there's a fingerprint clearance card that's denied, how long does it take for them to apply for a good cause exception? What does that process look like? And then I don't know, legally, are we able to revoke the license since it's not a requirement of the license?
So the board does have the authority to consider an application, even if the applicant is denied a fingerprint clearance card. The law was written to grant the board that discretion, and it's in 32-1904 A6 that says you have to require each applicant for an initial license to apply for a fingerprint clearance card. If the applicant is issued a card, the applicant shall submit the clearance card to the board. If they apply for a card and it's denied, the applicant may request that the board consider the application for licensure notwithstanding the absence of a valid fingerprint clearance card. The board in its discretion may approve an application for licensure despite the denial of a valid fingerprint clearance card if the board determines that the applicant's criminal history information on which the denial was based does not alone disqualify the applicant from licensure. So you do have that discretion. It is not an automatic bar.
Then I think we should have them presented to us when we receive them at the next meeting.
Are tech trainee registrants required to display moral turpitude?
No one is required to display moral turpitude because of recent legislative change.
Professional conduct, though. They can still have unprofessional conduct.
Correct.
Well, under 1927.01A, a trainee is subject to disciplinary action by the board for any of the enumerated reasons. The first one is the board determines that the registrant has committed an act of professional conduct. Also under 1927.01R, the board may deny the application of a registrant who has basically falls under 27.01A. So basically you can deny if the applicant has committed an act of professional conduct, or you can take disciplinary action if they have a registration and they commit an act of unprofessional conduct. I think the issue was that, you know, if you're not asking certain questions, how do you know whether or not they committed unprofessional conduct in order to possibly deny?
I think in that case, if you come to know of unprofessional conduct, then we should open a complaint against the registrant.
But if they were denied a fingerprint clearance card for an event that happened, say in 10 years ago, is that unprofessional conduct under our current?
It depends on the event.
And Seth and Jean, correct me if I'm wrong, but I think once we issue a registration or license, we can only go back 4 years anyways, right?
That is correct, once it's issued.
Didn't we have an event that was 25 years ago in our last board meeting?
Well, they were not licensed. They were consideration. Their application was under consideration. But once we issue a registration, we may find out after the fact that FCC was denied or something happened. Now we can only go back 4 years because it's an active registration.
Okay. So do you want a motion?
Please.
I would say if we become aware of someone's criminal history, that it comes before the board as under the labeled in our agenda as registrants requiring board review. And that we get information up to 4 years in the past.
Question, what if you, we put into the application documents that if you fail to pass the fingerprint test, that you can't do that? Yeah. I was just gonna say if you need to.
That's what was removed.
Right, I realize that, but where I was going, yeah. Right.
And also part of my motion is no change to the application. I don't think we're able to. So that's my motion.
I've got your motion, but perhaps Dr. Gandhi can weigh in on this, but without a case number or a complaint number, I don't know how we compel a licensee to attend a board meeting for the reasons we're discussing.
But if they don't come, then we can open a complaint, I guess.
Or
'cause they've been
is your recommendation that we open a complaint if we find criminal history that would be of a concern
Yeah,
to
so we-
prevent for them to hold a license, pharmacy technician license at some point in the future? I don't know.
I think that makes more sense.
So they're put on the agenda for review and then we decide if there's a
It would,
complaint that
no,
needs
it
to
would be a
opened.
complaint.
Mhm.
Can I ask, would you mind Ms. Mitchell to come up? She might have some additional thoughts.
And we might have to discuss.
Do you
this at a
want, do you
future
want to,
meeting.
do you want to rescind your motion since you're not going to be here?
I'll rescind my motion and you have my opinion. I have to go.
I just, we've talked about this many times about opening a complaint against a licensed or a registrant who may not know that they have a possible violation. Going through the whole complaint process, issuing them a subpoena for something that they weren't required to provide at the beginning, and just because they made the mistake of trying to obtain a fingerprint clearance card, now being held accountable for something that others would not be held accountable for. So I guess the question for me, since it will fall to me to do, is it a full complaint investigation where it will be on their record as them having a complaint? And, under what violations are we sending this complaint to this person who didn't know what they didn't know?
Can we do just like give authority to board staff to do like dismissal for those finding? And if they think it's necessary, they can bring it to the board meeting as a complaint.
Lori, based on my recollection from years ago, when I first joined the board, we only hear cases that happened 5 years or newer. If incidents that had happened 20 years, 15 years, 10 years ago, we just bypass that. Maybe we can just give the board a set number. If incidents had happened within 5 years or newer, then yes, we would like to have them come in front of us. But if
But then what happens, just plain devil's advocate, when they show up for their technician license? So it happened 5 years ago from now, we'll say, or even 3 years ago from now. We decide we're not going to take action on it. They come back for a technician license, have a failed fingerprint clearance card. They're going to appear before us again. Now, are we going to give them a license or are we not going to give them a license?
then we just have to go by case basis and vote to dismiss.
What if you just put on their application that if you want to get a technician's license, you have to be able to pass?
It's gonna be tough.
I don't know if that's okay. I'm okay with the board staff or like administration for our state board to make a decision. And if they think something we need to review, we are willing to review.
What's staff's recommendation for us? I'm gonna put this back on you.
Well, as Ms. Mitchell indicated, we've had a lot of discussions and have kind of beat our heads against the wall on this. So we're really trying to present the issue as concisely as possible. It's a complicated issue.
Hey, Glory, I mean, you hit the nail on the head saying if we come up with a problem today, drug related or whatever it is, and the board doesn't do anything to that registration, then you may be obligated to give them the full technician license when they apply.
That's why I was wondering if you put it on the original application, if they're going to get a technician's license, here are the requirements, and with a notification up front that if they do not meet all those notifications when it comes to that time, they could be, you notice I use the word could be, denied a technician's license. That gives them the incentive to either well, I may have something back there and I really don't want to do this, or I'm going to be limited in my future in my job.
Yeah, but the catch 22 though, Frank, here is if board staff receives something, right, that there's a concern with a registrant, and then we don't do anything about it because statutorily it wasn't a requirement for them to submit it, but we knew anyways. and something goes south, we knew the situation. We have to do something.
Well, that's the point I'm getting at. If it's put in there initially up there that when in the original application, that when they get to this point, they may be denied that if they don't have something, then you have that ability later on when they get there to look back and say, this was in the original documentation that you received. This is saying you may be denied this if you did not get it. So it's setting a prerequisite that then would go past the limitations you have, in my mind. That we'd have to ask council, but that would be my workaround.
Jean and Seth, if we were to get something that is of grave concern, somebody that was found trafficking oxycodone, and we know they're a technician trainee in one of our pharmacies, even if they had not been presented by their employer that they had stolen or diverted drugs or any of those kinds of things, could we take action if we received a fingerprint clearance denial card for a trainee in that circumstance? Because that would be a great example of somebody that personally, I don't want that person to continue to be behind the counter probably. And at the very least, I think we at least need to have discussion about what risk that person poses to the public having access to drugs.
Yeah, the statute as amended for the registrants would allow you to investigate and take action against a registrant.
So opening a complaint might be the right direction to go.
Correct.
Correct.
So that would be my recommendation is if the staff receives information that would cause pause as that comes to their knowledge as a result of a fingerprint clearance denial, a fingerprint clearance notification for some reason, that if it's something that we would normally have a discussion around for a technician or for a pharmacist, that be a complaint be opened and that be brought before us. Does that answer your question, Ms. Mitchell?
Answered. Thank you.
Okay.
Thank you very
Is
much.
that your motion?
That would be my motion. I have a motion and a second. Any discussion?
We're fine.
All those in favor?
Aye.
Aye. Any opposed? Okay. Ms. Ganavong, I think let's table your reports. That leaves us with call to the public, correct?
That's correct.
If you want to go ahead and open that up, Lynn, please.
There's about a 20-second delay.
Madam Chair, while we're waiting for a call to the public, Mr. Stoffel still has not responded, so we're gonna, just for clarification, we're tabling until next time.
Terrific. Thank you.
I don't see anybody logging on, Madam Chair.
All right, then we will adjourn the meeting at 4:44 p.m. Thank you all for your participation today and happy holidays.
Thank you.